Hello and welcome to Legal Bites. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legal Bites merch. Again, all links are in the description below. And with that said, let's get into it. All right. Good morning, good afternoon, good evening. Hope you are doing wonderfully wherever you are watching from. Happy Tuesday, everybody. I know this, I haven't really been covering this trial too much. I have been following it kind of from the sidelines a little bit here and there. But I finally decided, I was like, you know what? I've got legal tea on Tuesday. This is closing arguments. I might as well just jump in and live stream it, from gavel to gavel, so to speak, even though I know it's been live streaming for the last 30 minutes. They've been in court. There's been some arguments. And I know that right now was kind of the perfect time to go live because the judge decided to take a quick 5-minute recess before bringing in the jury. So for anybody that has been following this case or not following this case, we are talking about the case of Wisconsin versus Darrell Brooks. This is also known as the Waukesha Christmas Parade massacre trial. There are, I think it's, oh gosh, I totally should, I knew I should have written down the number. I think it's 67 counts against him. I mean, it's insane. There's so much going on in this case. And the state has put on a very, very good case, in my opinion. They've put on witnesses that have identified him as the driver of the car. They've had they've introduced evidence about a mechanical inspection of the car showing that it was working properly. Witnesses say that they saw him driving into the parade. And not only that he didn't slow down, didn't stop on Main Street, but maybe even accelerated as he was driving. Evidence was showing obviously about the harms that resulted as a result of his actions. So, there's a very solid case that has been put on by the prosecution in this case. But of course, what we are mostly concerned with here is the courtroom antics that have really kind of called into question, whether or not he is competent, whether or not he has he has any sort of claims on the fact that he's representing himself. Probably not. I think that all this judge has been doing a very, very, very good job of maintaining a very strong record of all of the chances that he has had to make certain decisions and the ways in which he has been informed along the way as well. So there's been a lot going on. I mean, even just like yesterday, the fact that, he refused to answer the judge's simple questions and as a result forfeited his opportunity to testify himself or to call any more witnesses. There's a question about whether he was going to call his mother as a witness, as an example. And because of his flat out refusal to answer the questions that Judge Doro was giving him, she basically said, okay, then you're done. And we're moving into jury instructions and we're going to, go through those and you can participate or you can't, you can participate or not, but it's encouraged for you to participate essentially. And so, yeah, so here we are, it's people were talking about the fact that, at one point in his frustration during this process, he was like hiding behind a fort of boxes of these bankers boxes that that are common to be seen in trial. Just one of many instances of odd behavior that has sort of popped up over time in this courtroom. But let me say hi to folks in the chat. I wanted to get that quick sort of like little recap ahead of time, like out there before, before the court comes back with the jury. But let me say hi to folks in the chat here. Tracy, good morning from Grafton, New York. We've got Shireen, good morning from coastal Yorkshire. Good morning. Secret Mixed Squirrel, good afternoon from Scotland. We've got Carrie Ann says, hi all. Night Eyes, good day everyone from Canterbury, UK. Has 01, good morning from chilly Alberta, Canada. JC, welcome to Bike Club. Thanks so much for joining and for supporting the channel. I really, really appreciate it. And I hope that we can see you on Friday for our Bike Club exclusive live stream. It's just a very casual hangout. And it'll be great to see you there if you can make it. And JC also says, coffee at the ready, slice of pecan and maple roulade on the desk. I'm all set. That sounds delightful. That sounds absolutely delightful. So let's see. And then we're gonna get into some more from the chat. Hello from Sweden, from Monica Korpinen. Oh, and I believe Judge is back.
For the record. And upon your refusal, that would be looked at.
How's the volume, guys?
I'm not addressing it. The jury's coming out.
Oh, it was originally 83 counts.
So
I didn't know that.
Is that
76 now? Okay.
A tacit agreement that you don't have to answer
thank
any
you so much.
questions
That's
as a
so sweet
public
of you.
servant, Your Honor? Therefore, that's dishonor. Are you going to honor your oath of office?
Stand. I'm not addressing it further.
Are you going to honor your oath of office?
All right.
All right, jury's coming back in.
So I'll take that as a tacit agreement that you're not going to honor
Elise Lynch
your
from
oath.
Vermont.
Excuse the jury.
Oh no, jury's getting excused already. Just because member in the chat says he finally pronounced tacit correctly. Oh no.
Mr. Brooks, I warned you that if you made any interruptions when
Okay,
they
volume
came
is
out,
fine.
you
Good.
would be removed to the courtroom. That's what I'm doing right now. You're forfeiting your right to be present in this courtroom unless you can promise me right now you'll respect prior rulings of this court and not interrupt this next phase of the trial, which is the court reading the jury instructions without interruption
Oh
from
boy.
you.
Oh
Can
boy.
you do that?
Have I acted in dishonor, Your Honor?
Mr. Brooks, I very expressly warned you.
Have I acted in dishonor?
You have disobeyed a direct order from this court.
Yep.
Have I acted in dishonor?
You have
That's
disrupted
irrelevant.
these proceedings.
I have not disrupted these proceedings.
Sir, can you pledge to
You are
me
disrupting them
that
now.
when this jury comes back out, that you will remain silent and not reference things like subject matter jurisdiction, the court's oath of office, tacit agreements, or anything? Can you
Dane's
pledge
addiction,
that
he
you will
might.
respect these proceedings and this jury by not interrupting?
Have I acted in dishonor, Your Honor?
I will ask you one more time. Can you pledge to be quiet?
She's having none of it.
Why should I have to make a pledge, Your Honor? Have I acted in dishonor?
Because under Illinois versus Allen, I believe you've already forfeited your right to be here, but you can reclaim that as soon as you are willing to conduct yourself consistently with the decorum and respect inherent in these proceedings, which at this point in the proceedings, sir, all I am doing is reading through the final jury instructions. I do not want that process interrupted by statements by you that are frankly misstatements of the law.
If they're misstatements of the law, Your Honor, how come they haven't been proven for the record? And I'm asking, have
All
I
right,
acted
he
in dishonor?
refuses to answer the
Have I acted
questions.
in dishonor,
I have given
Your Honor?
him an ample opportunity to do so. He has forfeited his right to be present
Oh,
for the
no.
reading of the jury
Okay,
instructions.
so
and
he's
he is
gone
to be moved
already.
to the neighboring courtroom. We will be in recess until that takes place.
Your Honor,
Thank you.
have I acted in dishonor?
Oh, wow. Okay. First off, Andy the Game Maker, thanks so much for your super chat. Are you going to pull a jacket over your head as soon as Brooke starts getting cringy? Well, that would be already now. So I didn't prepare my cringe blazer for this live stream. I probably should have. So oh my gosh, you guys. Okay, so this is already happening. He has already decided to speak up. As soon as the jury was walking in, the judge had to excuse the jury and then have this back and forth with him and then to tell him that he's not going to be allowed to be in the courtroom for the jury instructions. So while they are reading the instructions to the jury, basically to say, like, this is what you are supposed to do now from this point on. Here are the steps that you are supposed to be taking in order to either find a conviction or to find him to exonerate him, right? So this is, anyone who has watched jury instructions knows that, generally speaking, that's a relatively, I mean, it's a very important part of the process, but it can be a little bit dull. Let's be honest, right? So this is not the time for argument. It's not the time for, for any sort of back and forth, for talking about subject matter jurisdiction, which is one of the big things that he's been pulling up, over time throughout this entire case, because he's been pulling up this, folks that have been following this know this is like one of his main arguments here, is that he declares himself as a sovereign citizen. And so therefore he says, I'm not subject to the laws of the state of Wisconsin or the United States of America, and therefore I'm just a sovereign by myself. I just happen to be here. So your laws have no power over me. And so that's where a lot of this sort of bizarreness has been coming into this case. He's tried to, for example, the first witness that he tried to call was the state of Wisconsin, which is, you can't do that, because you've got to call a person. You've got to call a person to the witness stand. You can't call an entity. Even when we're talking about businesses that are suing one another, you call witnesses, right? You call witnesses in those cases, but what you do is you call persons most knowledgeable. You call somebody who is in the best possible position to be representing that company on the witness stand. And so that's what you would do there. But he tried to call the state of Wisconsin to try to argue this whole subject matter jurisdiction concept. And he has, at other times, he's come in. The judge has had to ask him to put his clothes on. Is one way to describe it. He came in, wearing the orange jumpsuit, and the judge told him, I was going to say advised him. The judge isn't supposed to be advising him, right? She's not supposed to be giving him any kind of advice, giving him help. She's not supposed to be, teaching him along the way. She can give explanations like behind her reasoning, of course, but in terms of like what she is going to be, like what he needs to know in order to represent himself, that's not up to the judge. That's not her role. That's not her job. And that would be highly improper, because that would be her essentially putting her thumb on the scale. But she explained to him, it's a good idea to come in a suit or in some kind of street clothes, because, you coming in a jumpsuit is probably not a good idea. And it's like, I almost wanted to, when I was watching it, I almost wanted to like have her say, like, it's in your own best interest. He tried to argue back and forth, with her that, like, well, they all know that I'm in jail at this point anyway, because they're, it's all over the news and all this kind of stuff. It's all over the news. And well, which, number one, jury is not supposed to be watching the news, right? Like that's one of the earliest admonitions that any judge will give in any kind of a trial is stay away from the news, stay away from social media, stay away from people talking about this case.
Please be seated.
And
the record to
so
reflect that Mr. Brooks has been placed in the other courtroom. He is presently
so
on
much circus
mute so that I can make a record. I do need to confirm that the audio and visual equipment and system is working.
So now she's putting it on the record.
A thumbs up from the bailiff. I'll just ask Madam Clerk to confirm with the clerk that's over there as well. I would note Mr. Brooks has the headphones on.
Meaning he can hear.
This court certainly doesn't take pleasure in removing Mr. Brooks from this courtroom once again. We are at an important stage of this proceeding where the court
explaining her reasoning
needs to instruct the jury concerning all of the law that will guide them in their deliberations. As I've put on the record previously, the total pages comes to 107. I will be reading this morning through page 73 prior to the parties given the opportunity to make closing arguments, and then reading from pages 74 to 106 following that. It is very important that the court do this without interruption. Yesterday, this court held a jury instruction conference where both parties had a full and fair opportunity to raise objections regarding any of the proposed jury instructions, to make requests regarding inclusion of any jury instructions that the court did not include. As well as review all of the verdict forms. There's absolutely no reason for there to be an interruption or an objection to this process at this time. The court spent the better part of 25 minutes this morning with Mr. Brooks raising issues and prior rulings that this court has spent an abundant amount of time on, including subject matter jurisdiction. He continues to claim he did not consent. That's been noted for the record. He continues to claim that he has a limited or no understanding of prior rulings and decisions of this court. I repeatedly advised him I would not be revisiting these issues, that I wanted to go forward with the jury instructions, and repeatedly warned him that any interruption once the jury came out would result in his removal from the courtroom. Again, I take no pleasure in doing that. I prefer that he be here, but frankly, the decision I made here today, with the speed at which I made the decision here today, is not only to preserve the dignity of these proceedings, but to do so in a way that avoided the court admonishing Mr. Brooks in front of the jury. This, of course, comes on the history in this case with the repeated removals that this court has had to undertake with Mr. Brooks, given his conduct and his behavior in this case. I am currently being advised that he would like to come back. That, of course, is always something that I will give him. As soon as I make my full findings, I will pause, and he will be brought back into this courtroom so that he can be in attendance when the jury is brought out. Of course, my decision that I made this morning to remove him is based on the authority from Illinois versus Allen.
Brittany King, thanks so much for the super chat.
I also note that
I'm so glad you're covering this live. I watched the death trial with y'all and have watched this from the beginning. I've missed the commentary. Thanks. Thank you. Thank you so much. So kind of you.
Clearly, even though Mr. Brooks
Stuck
was
on
using
strings.
a
Thanks so much for the super chat as well. He spent an abundant amount of time hiding behind the Bible in a box
not
fort.
interrupt
May the
once
fort
the
be
jury
either
was brought
you,
out.
me, Brooks.
He did that
Or do you mean may the force be with
immediately
you?
upon the first juror walking in.
May the fort be with
I
you.
believe only a few of the jurors even walked in. He was continuing to talk. I immediately removed them from the courtroom to minimize the impact of his disruption. It was clearly disruptive, but again, he is asking to come back, and I will honor that request. I will further advise him, though, that
interlocution. Thanks for the super chat.
Interrupt.
Is there a screen in the courtroom where the jury witnesses and everyone else in the courtroom can see his antics from the other courtroom?
Phase of this
I think that's part of the point of putting him in the other room is so that they
issues,
can't see him. He does have a microphone though when they can when they turn it off
advisement
or
to the
turn
jury
it on,
by this
sorry,
court
and then
of all of the jury
he can ask questions or object. Or
I will consider admonishing him in the presence of the jury or simply removing the jury so that then I can admonish him and then making the appropriate record. All right, with that, since he's asking to come back, we will take a pause. We'll recess. We'll come back in when he is set up in this courtroom. Thank you, everyone.
All right. Okay, so we've got another quick recess. Stuck on strings. Sorry for the typos. May the fort be with you. Oh, thank you. Thank you. So yeah, there's already a ruckus, right? But she had to get everything on the record. And the whole purpose behind that is so that she can put all of her reasoning on there. She can put on the record exactly what happened, what he did, what she did, the reasoning for it, the warnings that she gave him before she acted on it. And so that way everything is on the record for an eventual appeal. And that's because this is the kind of defendant who will almost definitely be appealing this particular case. I mean, just based off of his behavior throughout this trial, this is somebody who probably is going to be appealing, not only appealing this case, but probably also suing the state of Wisconsin for all kinds of lawsuits regarding pretty much anything he can find is my guess. That's my prediction, because this just comes from, I've talked about this before, but from my time with my experience with the California Attorney General's office in their correctional law section, where it's like it was all civil cases with inmates that were suing the state of California over all kinds of things. And some of them were legitimate cases, right? You know, issues about their religious rights and, you know, religious practices and limitations that were being put on them by the prison facilities and all that kind of stuff. But then you had somebody that was like, you know, I remember there was a case where there was a guy that was like, I wanted to have my own cell. And so I told the guards that if I was placed in a cell with another inmate, I told them that I would beat up that inmate. And then he was placed in another cell with another inmate. He did beat up that inmate. And then he sued the state for that. So it was a bizarre claim, because there's no seemingly no harm to him for that. All kinds of wonky things. So you can find all kinds of crazy lawsuits that can come out of the prison system when people are incarcerated and they have a lot of time and they have a desire to fight and try to win against the state. The Demon Nat note, asking, did he win that case? I don't think so. I think he may have gotten a nuisance settlement, because and that's kind of the unfortunate case here, is that they also tend to learn that those kind of cases, you can file a case, and judges will they'll bend over backwards when somebody's representing themselves, and they will give all kinds of extra chances that they might not actually give someone who's otherwise represented by counsel. And so usually what happens is these cases tend to settle out. So you've got people that end up learning that they can make a quick buck if they do that kind of stuff. So interesting times, and a whole basket case of weirdness. So let me get super chats here. Steven Yarger says, I'm just here to watch Alita's calm, poised, and elegant demeanor creating commentary on a live dumpster fire. Thank you. I really appreciate
everyone,
it.
Please be seated.
And Tish in Tennessee, she needs to just leave him there. Probably. We'll see what happens, though.
Before the jury's brought out, can we address subject matter jurisdiction, Your Honor? Before
Absolutely
the jury's
not.
brought out.
Absolutely not.
He wants another chance to argue about subject matter
agreement
jurisdiction.
that you don't have to answer those questions as a public servant, Your Honor?
She's about to mute his mic.
Are you going to act in dishonor?
Mr. Brooks?
Are you going to act in
I've
dishonor?
already addressed your request.
It hasn't been proven for the record, Your Honor.
Oh my gosh.
The jury is on its way.
They're not out yet, though.
But they're on the way.
You held me in contempt.
I'm not
You
addressing these matters, sir.
Have I acted in dishonor, Your Honor? You held me in contempt without me being in dishonor. How have I dishonored the court? Have I acted in dishonor? Have I rose my voice or argued with Your Honor? Have I disrupted the courtroom
Mr. Brooks,
in any
you're
way?
back in this courtroom at your request. The jury is coming up.
I never should have been.
Please be respectful of their time.
I have been. They weren't even out before.
Of the proceedings.
They weren't even out before when I was trying to address what needed to be addressed before they came out. Am I acting in dishonor?
The proceedings.
Am I acting in dishonor? So that's a tacit agreement that you don't.
The jury, please.
It's a tacit agreement.
I understand why she wants to have him in there, because that's the most ideal situation.
No jury's out.
Is he's in there and he's not being disruptive.
I was trying to address this
they
before they
right
came
outside
out.
this door. I am not going to do this with you this morning. You either abide by these rules
Am I
and
acting in
stay
dishonor?
quiet,
Am
or
I
you will
acting
be
in
in the other
dishonor?
courtroom.
Am I acting in dishonor?
Yes, you are acting
How?
in dishonor.
How?
You are disobeying the direct order of this court to respect the decorum and the dignity of these proceedings. You are merely attempting to delay.
I don't care what you think. That's not accurate.
Mr. Brooks, I am having this jury out. And if you
and you're
say
making
one word. When that door opens,
You're making a tacit agreement.
then you will forfeit your right to be present.
So you're acting in dishonor then, Your Honor.
All right. The jury may come in.
You're acting in dishonor by making a tacit agreement that you don't have to answer any questions as a public servant. You're not holding up to your oath to protect the Constitution.
All right, the door is open and he's talking.
Okay, so you're going to hold me in
All right.
contempt?
The jury cannot come in. Never mind.
Are you going to hold me
Oh,
in
no.
contempt?
Mr. Brooks is going to be removed.
Yeah.
We're going to recess until that.
How am I
Oh,
acting in dishonor?
We're going to recess again. Oh my God. I have been streaming this trial for 25 minutes and we haven't gotten to the substantive jury instructions or the closing arguments. This is so frustrating. This is so frustrating. And I can see her frustration. She has had the patience of Job throughout this trial. And the fact that she is, I mean, getting heated again. Yikes. Okay. It's, you can tell that she's so done, but I also understand why she would rather him be in the courtroom, give him opportunities to do it. Because even if for no other reason for having that on the record, because if he says, I wasn't allowed to be in there for the jury instructions. And so, I wanted to object at one point because, something was improper that happened, but I couldn't object because I was out of the courtroom and I was put on, my mic was muted. My mic was alaned, so to speak. And so, there could be hypothetically an argument like that, going up on appeal. But if she gives him multiple opportunities to come back in and play nice, then if he immediately just goes right back into that prior behavior, then she can put that all on the record again, and then just that all just stacks up against him for a potential appellate argument. So, all right. So let's see here. Let me get some super chats and questions here. So Hezo1 says, question, Legal Bites, what is your opinion on how the judge has handled his behavior? I've heard some saying she's doing exactly what she should, and others say she's being too nice. I think that she's doing a great job of managing him. I think that sometimes people will say that judges in this kind of a position will be too nice. And that's just, I think that the reason for why she might be giving him more leeway than she would someone else is because of these appellate issues. And so I totally understand why she wants a case like this to not have to go through trial again, right? Can you imagine after all of this, then it goes up on appeal, and then the appellate court says, well, actually, there was something that did go wrong, that you made one mistake, and so therefore he deserves a new trial. And then we have to go through all of this all over again. Like that is like the most frustrating thing possible, right? So, and no judge wants a verdict to be overturned on appeal anyway, right? They want to know that their job has been done properly. The jury has done their job properly. And so the conviction, if it stands, is, or if there is a conviction, that it stands. So, I understand some people saying that she's being, too nice to him, but when it comes to pro se, parties, right? People that are representing themselves like him. Sometimes you have to take those extra steps. It seems like it is very frustrating, but it also seems like they're just being too nice. It's really because she's protecting the record, and she's protecting, the whole judicial process from having to go through all of this with this particular defendant on this particular case again. So craziness. Manny Fabani, thanks so much for the super chat. Says, I'm just here to second Steven's super chat. Oh, thank you. Tish in Tennessee, thanks for the super chat. Says, she's the parent who doesn't understand why her kid won't behave because he doesn't believe her that he will be grounded. She needs to put her foot down at this point. I think that after giving him one more opportunity to come in, and his immediate, getting right back to that behavior, I don't anticipate her giving him another chance anytime soon.
Thank you, everyone. Please be seated. Can I?
Oh, wait.
We are back on. The record appearances are as they were
Time
before.
Fallen says,
the record to
well, this is going to be a long stream. LOL.
In the
Yeah.
other
Thanks for the super chat.
courtroom. I currently have him muted so that I can add to the record.
Family man, Donnie. She needs to stop. I understand she's trying to be fair for
confirmed
appellate
he can
issues, but
hear
enough is
and
enough.
see as well. I would note he does have the headphones on while in that courtroom. He just lifted them up as well, or at least part of them.
And now he's waving at her.
This court has previously relied upon the U.S. Supreme Court case of Illinois versus Allen.
Petition Tennessee. I'll pull that up again in a minute.
Wherein the United States Supreme Court indicated it is essential to the proper administration of the criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. We believe trial judges confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. We think there are at least 3 constitutionally permissible ways for a trial judge to handle such a defendant, including 1, bind and gag him, thereby keeping him present, 2, cite him for contempt, or 3, take him out of the courtroom until he promises to
Laura
conduct
Cox,
himself
that's a great
properly.
idea.
I understand Mr. Brooks is waving to the
poll.
court. I'll address that momentarily. But the bottom line is there is a history of repeated disruptive behavior by Mr. Brooks. I warned him after he came back in. The first thing he wanted to do was address subject matter jurisdiction. That is, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. I've issued a written decision. He has yet to appeal that written decision. He has that right to file an interlocutory appeal. I would also note at no time during this case has jurisdiction ever been challenged when he was represented by an attorney. So I warned him, given the importance of the proceedings and the need for the court to advise this jury without interruption, he was removed once again. I will not bring him back into this courtroom unless he is willing and pledges to conform his conduct and pledge to not interrupt by making any statements when this jury is present and during the court reading all of the jury instructions. I will unmute him so that he can indicate what he would like to say to the court. You are unmuted, sir. Go ahead.
Can y'all hear me?
We can.
First of all, at 9:25, I would like the record to reflect that the prosecution was making disparative remarks and gestures in pursuant to what just happened. I don't appreciate it, and I think that is very disrespectful.
Okay.
For the record.
Okay.
And again, I'm trying to figure out how did I act in dishonor to be removed from the courtroom? How have I acted in dishonor? This is a whole nother.
Oh boy. How have I acted in dishonor?
How have I acted in dishonor?
All right, I'm going to mute Mr. Brooks. I'm not going to answer that question. I've made my ruling as far as anything that was
she
done
doesn't
by
need
the
to keep going on
prosecution.
it.
I was not in the courtroom. The jury was not present. Whatever happened, if anything at all, was done outside the presence of the jury. If there is anything the state wants to put on the record right now, I'll give you that opportunity. Otherwise, I am going to bring the jury out, Mr. Brooks. If you want to come back into this courtroom, you need to write your request down on a piece of paper. And when you do that, pledge to this court that you will not interrupt these proceedings. Without that, I will not bring you back into this courtroom.
Sounds about right. Sounds about
anything
right.
the state wants to put on the record.
I have a question, Your Honor. I don't have anything directly in response to Mr. Brooks' last statement.
All right, go ahead.
Yesterday afternoon, when we had the 4-screen up, there was a wider view of the courtroom so that the jury box could be seen. Is that possible to do again?
Yes, it is. We can take the witness stand camera and pull it out so that he has a view of the jury box as well. I can't angle it, but I can.
Yeah.
So he needs to make sure that he
for
can
the record,
see it.
when you do that, then he can see the jury box. So I would ask that that be done before we.
Please do that, Madam Clerk.
Of course, that's different than us being able to see the jury because we are supposed to not be able to view them for confidentiality reasons. So let me
Well,
get,
But they don't have.
It's not on Zoom, and so the court TV would be able to fix the camera on me and not on the screen, so that they don't capture any of the jurors, and they're directed to honor that and do that. Same thing, obviously, with our still photographer. If there are any images captured of Mr. Brooks, as you can see, the camera is being zoomed out, you would need to avoid capturing members of the jury.
right, right.
Thank you, Your Honor. The record should reflect you have zoomed out the camera, and it looks
Right.
like about 90% of the jury box can now be seen in the view if Mr. Brooks chooses to
Right.
do that.
That
Mr.
makes
Brooks,
sense.
I'll unmute. What is it you would like the court to address?
How can you rule that I don't have the right to be present in the courtroom?
Right. I've answered that previously. I've made my findings under Illinois versus Allen. He continues to interrupt, even if it is by asking questions. I've made my ruling. The record stands. It speaks for itself. And I intend to have the jury brought out. I need one moment before I do that. And so I'm going to just take about a 2-minute recess.
2-minute recess. There we go. Let me get some of this from the chat. Okay. Tish in Tennessee says she's the parent who doesn't understand why her kid won't behave because he doesn't believe her and that he'll be grounded. She needs to put her foot down at this point. Yeah, no, for sure. And I think that she is doing that, but I think she needed to, unlike a parent, a parent doesn't have to worry about any sort of appellate review of their decisions with their kids, right? I mean, unless we're talking about like government getting involved in somehow. Anyway, that's regardless. But generally speaking, can the kid have candy or can the kid not? Is a question that generally speaking doesn't get reviewed on this kind of stuff. But I see your point. And thanks so much for the super chat. Grant McRoberts says, I thought judges have authority to throw someone in jail if someone is disrupting the courtroom, lock him up until he learns to behave and listening. Yeah, I think this is one of those kind of unique sort of situations because of the fact that he is representing himself here. And so he also has a right to have representation in the process, even at this late stage, with jury instructions and then obviously with closing arguments and all that kind of stuff. So it's very frustrating. And so any judge is going to want to, because like I said, she's thinking about the appellate review of every single decision. She's going to want to take the least restrictive means possible because that means that she's got discretion over her courtroom, but usually, I mean, you want to show that you are giving chances. You want to show that you are giving opportunities for him to participate in the process because we're talking about due process issues, and that's already going to be some issues here. Stephen Yarger says, I'm just here to second Manny's comment. Thanks so much. And then Manny Fabani says, I'm just here to second Stephen seconding me. This is growing. What is happening? But I appreciate it, guys. Tish in Tennessee says, if this wasn't so tragic, it would make a great SNL script. I completely agree with you on that. I do agree with you on that. And that's the thing that's like the thing that keeps it from verging into comedy here, right? Is the fact that there were 6 people who died, and I believe others who were also injured. So we're talking about tragedy that is he's kind of making a mockery of this courtroom. And there are people that have really legitimately suffered and who are still suffering. And in the chat, somebody says, "What's SNL?" Saturday Night Live. I'm not sure if you might be outside of the United States, but it's a long running comedy sketch show that runs on Saturday nights on NBC in the United States. So anyway, but yeah, no, I totally agree with you on that, Tish. Juan Valdez, thanks so much for the super chat. Said she should have bound and gagged him a while ago. He's been very clear from the beginning of this trial that he has no intention to follow the rules. Yeah, but it's she has to walk that fine line between not rewarding bad behavior, but also making sure that his due process rights are intact. But I agree with you that it's very, very frustrating. Stuck on Strings, thanks so much for the super chat. Says, don't find she's been too nice / weak, but abundantly fair. Great job protecting record and proceedings, not school and parenting. It's justice. Yeah, I do agree with you on that. I think that she has been very, 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 very fair to him. And especially when, like, this is also, I think one thing to keep in mind here is that this is also a criminal case, right? It's not a civil case where you've got two private parties, in opposition to one another. You've got the state, and then you've got a private party that is defending their life, essentially, right? Because it's his liberty, essentially. Because if he gets convicted, he goes to jail for a long time. So if we're even if we're talking about a civil case between two parties, and one of them is representing themselves, a judge is going to have to be very careful about the way that they go about that case as well. But here, you've already got the state of Wisconsin, which, the prosecution's office has the full weight and force of the state behind them. So that is the government with a capital G, that is acting through these attorneys, right? So that already is a very powerful position for these individuals to be in. And that's why prosecutors have extra responsibilities under any state set of rules of professional conduct, right? Because all attorneys have to abide by certain ethical rules. Every state has, they're a little bit different from state to state, but generally speaking, I haven't heard of a single state in the US where the prosecution doesn't have extra rules on top of them that a normal attorney doesn't. And the reason for that is because they have so much power behind the things that they do. And if they do overstep certain ethical bounds, it's the kind of thing that can have even more repercussions on someone who shouldn't have been dealing with that. So yeah. Interlocution says, thank you for your analysis and explanations. Of course. Thank you. And thank you for the super chat. So, all right. I managed to get through all of them during a recess. So I think she said it was just going to be a couple minutes. So maybe we'll be back soon. But let's see if maybe we'll go through the chat a little bit and see what folks are talking about. But like I said, this is already a sorry, it's a shit show. There's really no other way to put it. And also, okay, Laura Cox says Uncivil Law did a great legal breakdown of Illinois v. Allen on his channel. I believe it. I absolutely believe it, because Kurt does really, really great breakdowns of these, of all of these cases. So definitely go and check it out in the chat. I can also, you know what? I'm also going to copy that and then, and then put in the description for folks on replay as well. So, but it does seem to me that he is not going to be coming back into the courtroom for the jury instructions. We'll see what happens when it comes time for the closing. But we'll definitely be seeing. Okay, so fun times. Thanks so much for your super chat. Says the back and forth of the jury is making me crazy. I don't know how the jury is dealing with it. Yeah, I would definitely be very frustrated by that as well, because this is also, how many weeks has this been going on, right? How long has this trial been going on for these jurors? They were in first jury selection and then actually sitting through the case, and now they're almost to the end. So I can just imagine that at this point they're probably like, you know what? I just want to get to the end of this. I just want to get to the end of this. I don't really care what's going on. Let's just get to the end of this. But yeah, it's probably driving them nuts. Although they don't see what we're seeing with these arguments in the back and forth between the judge and Mr. Brooks, right? So there are certain aspects here that are not being seen. So it's interesting to sort of speculate what they might be speculating about what's happening in this whole process. So, yep. But, well, oh, and also in the chat, we've got Sandra Ramirez with a member chat says, the deputy also has shown great patience. Yes, I would agree with that too. I can only imagine the conversations that are happening behind the scenes between the bailiff and the judge and the clerk. I mean, I don't know if they have seen any kind of a case like this before. It certainly seems to be the first time that we've seen a case like this publicized. So, but there are some interesting parties out there, I would say. But this I don't know that I've ever heard of this kind of case before. So Christine Bucci Walker says, I do give the judge a lot of credit. I have never seen this in my life. Yeah, I would definitely agree. And also Laura's explaining that they are moving the cameras around so he can see the jury box. So he'll be in there for a while. Yeah, I think so. I think this is something that they were talking about that actually the prosecution brought up, that because Darrell Brooks is now in this other observational room, and he's sitting behind a monitor and he has headphones on. The concern is that he needs to be able to see the full process, right? So previously the cameras were set up just to be on the judge and on the attorneys, on the prosecutors, and then on Darrell Brooks. Obviously the cameras are not supposed to be on the jury for purposes of the public, right? We've talked about this before. We don't have any kind of knowledge of what these individuals look like, and that is to try to have some sense of preservation of their privacy and their confidentiality, because we don't want people getting involved in this trial process, right? We talked about this a lot in previous trials. So, but for him, because he's in a separate room, he needs to be able to see what the jury is doing. He needs to be able to observe the jury, just like he would be able to see them from inside the courtroom. So that is why they are moving the cameras, is so that on his monitor he has the ability to see them there. So yeah, Sawdust, we are not at the instructions yet. It's crazy, right? 45 minutes in and we are not even there yet. Hi.
Do you want food?
I would like food, yeah. Mr. Bites is asking me if I want food. So, okay. Yeah, and this is another question that has come up a number of times with Darrell Brooks as well, is he even competent? Well, I think that a lot of although he's put a lot of antics forward for the entertainment of the masses, I could say, he still is involving himself in the process, right? He did call, I should tell Mr. Bites, you guys want food too. I see Alejandro Amaya, you want some? B, you want some too? Shireen as well. So his competency has been one of these things that's been an issue as well, right? So does he have the ability to put on a case here? And so no, the standard for that wouldn't be like is he disadvantaged over not having an attorney? Because I think that any reasonable person would look at that and say, well, yeah, of course he's disadvantaged, because he's not as intimately knowledgeable of the process as a practicing attorney and experienced attorney would be, or just an attorney who has passed the bar, right? Like even a fresh attorney has more experience than he does because of their educational experience. So that's not the standard here, right? The standard is whether or not he has the ability to understand what's going on in the process, who these various people are, what their roles are, what is the judge doing there, what is the prosecution doing there, what's the role of the jury, and so he has the ability to understand this stuff. based on, I think he does. I mean, based on multiple things, right? Number one, they actually did do an evaluation of his competency before the trial even began. And they brought it up, I think, at least a couple times during the trial, just to make sure that they got it on the record that this was, something that they looked into to make sure that he was not going to be going into a trial, and getting taken advantage of because he's incompetent. So there's that, and there's his active involvement in the process. He has brought, I think he called 9 witnesses, I think, something like that. He also cross-examined a bunch of the prosecution's witnesses as well. He was involved in the process yesterday with jury instructions, where he was asking some questions. There were a lot of questions that he was asking that were completely irrelevant and absolutely bogus. Again, going into subject matter jurisdiction and all that kind of stuff. But he also was going into other questions of giving some pushback to the state about certain jury instructions here and there that were actually relatively decent questions. So he is arguably competent enough to be able to understand the process, and his courtroom antics are just unfortunate, right? So, yeah. Laura Cox says he's more than competent. Remember, he's pathological. So this is all a way for him to attempt to take power over the judge. Could be. I mean, and that's what I saw a lot of with the correctional law section in the Attorney General's office as well. Is like, it seemed, I remember talking to attorneys that were very experienced in that area, as I was sort of like learning about that whole world, that I was like, what is it about this whole process that makes these people, want to fight the state on all kinds of reasons that are very often not legitimate. And I think part of it is because they want to feel like they have won something. They have fought against something, right? Because what else do they have to lose, right? They can kind of take a piece out of the system that has put them into a certain place in life. That may be one reason. Obviously, that's not for every single case. And like I said before, there are also legitimate cases where the state is not necessarily doing things that are proper, and so lawsuits are filed, and then conditions change. So. So yeah. Erica Robinson says, who thinks he's going to bring up jury nullification in his closing? I hope not. That was something that he did say yesterday he was going to be bringing up as well. And the judge said in no uncertain terms, no, you are not. That is not something that you are going to be able to bring up during a closing argument. And so we'll see.
Yes.
Adrian L. says, question, are there any behavioral disorders that would disqualify a defendant from dismissing their counsel?
Mr. Brooks sent a note that says, under Illinois v. Allen, I request for the second
I'll answer
to
this
be
in just a
present
second.
at my trial. I never consented to not being present, nor did I act in dishonor, because he has not made a pledge to conform his conduct as is required under Illinois versus Allen. He has not reclaimed his right to be present, and we will continue with him in the other room. I will also make a finding today, and I didn't do this previously, although he's forfeited his right to be present, given the technology, the audio and visual equipment that we have, the fact that we've also backed out the one camera so he can see the jurors. I'll make a finding, even without that, though, that it's the functional equivalent of being present in this courtroom. All right, with that, then the jury will be brought out. I'll remind Mr. Brooks, while he can reclaim the right to come back into the courtroom and make a request, I am going to be adamant that his request include a statement that he's willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings, and specifically pledge to not interrupt the reading of the jury instructions. Until such time, he will remain in that courtroom. All right, go ahead.
All right. So Adrian L says, question, are there any behavioral disorders that would disqualify a defendant from dismissing their counsel? I don't think that any specific behavioral disorders on their own would. The judge is always going to go step by step to make sure that the client understands what they are doing. They understand the disadvantages that they are putting themselves at by releasing their attorney and by going on their own. And so, regardless of what kind of disorders or mental defect that someone might have, they could still be competent enough to understand what it is that they're doing. So the judge is always going to go through like a whole set of questions, basically to make sure that this person understands. And that's what the judge in this case did as well. They had a whole long conversation when that happened before this trial popped off. And there was a whole long thing I remember where she was talking about, or she was asking him if he understood what it was that he was doing. And I saw this explanation from someone who was, I guess, familiar with sovereign citizens. I haven't spent too much time arguing with sovereign citizens or engaging too much with that. But I think that's like a particular buzzword that they don't like. So it was like she couldn't get him to say, I understand. But she managed to sort of work her way around it very frustratingly. So now the jury is coming back in.
Thank you, everyone. Please be seated. Members of the jury, the court will now instruct you upon the principles of law, which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The defendant is charged with 6 separate counts of first-degree intentional homicide, use of a dangerous weapon. The first count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Virginia Sorensen with intent to kill that person, and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The second count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Leanna Owen with intent to kill that person, and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The third count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Tamara Durand with intent to kill that person, and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub B of the Wisconsin statutes. The fourth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Jane Coolidge with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The fifth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Wilhelm Hospital with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The sixth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Jackson Sparks with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The defendant has entered a plea of not guilty to each of these charges, which means the state must prove every element of each offense charge beyond a reasonable doubt. First degree intentional homicide, as defined in section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of any count of first degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present with respect to that count. One, as to each count, the defendant caused the death of the victim named in that count. Cause means that the defendant's act was a substantial factor in producing the death. Two, as to each count, the defendant acted with intent to kill the victim named in that count. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The information alleges not only that the defendant committed the crimes of first-degree intentional homicide, but also that the defendant did so while using a dangerous weapon. Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Great bodily harm means serious bodily injury. If you find the defendant guilty of a count of first-degree intentional homicide, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime of first-degree intentional homicide while using a dangerous weapon. If you are not so satisfied, you must answer the question, no. If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count one, you should find the defendant guilty of first-degree intentional homicide as charged in count one. If you are not so
I can see it,
satisfied,
Laura.
you must find the defendant not guilty as to count one. If you find the defendant guilty of count one, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count two, you should find the defendant guilty of first-degree intentional homicide as charged in count two. If you are not so satisfied, you must find the defendant not guilty as to count two. If you find the defendant guilty of count two, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count three, you should find the defendant guilty of first-degree intentional homicide as charged in count three. If you are not so satisfied, you must find the defendant not guilty as to count three.
We have
If
not
you
seen a
find the
fortress
defendant
yet
guilty
today.
of count three, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count four, you should find the defendant guilty of first-degree intentional homicide as charged in count four. If you are not so satisfied, you must find the defendant not guilty as to count four. If you find the defendant guilty of count four, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count five, you should find the defendant guilty of first-degree intentional homicide as charged in count five. If you are not so satisfied, you must find the defendant not guilty as to count five. If you find the defendant guilty of count five, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count six, you should find the defendant guilty of first-degree intentional homicide as charged in count six. If you are not so satisfied, you must find the defendant not guilty as to count six. If you find the defendant guilty of count six, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? The defendant is charged with 61 separate counts of first-degree recklessly endangering safety, use of a dangerous weapon. The seventh count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Nicole White under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The eighth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Eleanor Anders under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The ninth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Sasha Catalan Castillo under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 10th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Maura Gilchrist under circumstances which show utter disregard for human life and while using a dangerous weapon contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 11th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Justin Gullickson under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 12th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Harry Guilfoyle under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 13th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Aiden Lofgren under circumstances which show utter disregard for human life and while using a dangerous weapon.
Hey, Eric, good to see you in the chat. I sent you a DM.
939.50 sub 3 sub F, 939.63 sub 1 sub B of the Wisconsin statutes. The 14th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Theo Mazza under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 15th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Tyler Pudliner under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 16th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Connor Tank under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 17th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Eric Teagues under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 18th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Adelia Maffioli under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 19th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Kelly Graybow under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 20th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Josh Craner under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 21st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Riley Rogers under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 22nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Caden Rogers under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the
Sandra
Wisconsin
Ramirez,
statutes.
thanks so much for gifting
The
so
23rd count
many
of the
Bike Club
information in
memberships.
this
That's
case
so kind of
charges
you.
that
Thank you.
Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Tucker Sparks.
Yeah, I've boosted the
under
volume,
circumstances
guys.
which show
Let me
utter
see here.
disregard for human life and while using a dangerous weapon,
Yeah.
contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 24th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Isabella Bartelt under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1,
Yeah, thank you, Sandra.
939.50
Very generous
sub
of
3
you.
sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 25th count of the information in this case charges that Darrell E.
25th count.
Brooks,
So
on or about
out of
Sunday,
77,
November
we're at
21,
25.
2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Yaretsi Becerra Montez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 26th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Samantha Coelho under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 27th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November
Thank you,
21,
Anime Wholesale. That's very
2021,
kind of you.
on Main Street in
It's
the
kind of
city
up to Carl
Waukesha,
Jobst
Waukesha County, Wisconsin,
if he wants to have me
did
back. But I would
recklessly
love
endanger
to
the
do more
safety of
collaborations
Madison
with him for sure.
Hollingsworth under
He's a really
circumstances
nice
which
guy
show
and
utter
really great
disregard for
content.
human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin
He's
statutes.
waving.
The 28th count of the information
Okay, we're up
in
to
this
28.
case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha,
We're actually
Waukesha
making
County,
progress here.
Wisconsin, did recklessly endanger the safety of Mackenzie Hollingsworth.
It's amazing how smoothly things go when you're not getting interrupted, right?
Life, and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.
Yeah, there's actually a total of 61 counts
the
for recklessly
Wisconsin
endangering
statutes.
safety with the use of a dangerous weapon. So
The 29th count
and she's
of
already
the
gone through the
information in
6
this
of
case
first-degree
charges
intentional
that
homicide.
Darrell E. Brooks,
So when
on
we
or
get
about
to
Sunday, November
count
21 of
68, then we are
2021, on Main Street
out of
in the
the
city of
reckless
Waukesha,
endangerment
Waukesha County, Wisconsin,
zone.
did recklessly endanger the safety of Mitchell Lampine under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes.
Funny.
The 30th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Kathleen Peelmeyer under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 31st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Julia Schleichow under circumstances which show utter disregard for human life and while using a dangerous weapon.
Kate Leslie, thanks so
contrary
much
to
for
sections
gifting more memberships.
941.30
Very,
sub
very
1,
kind of you. Thank you.
939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 32nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Olivia Stover.
Maria says, I think he's
under
actually plenty
circumstances which show utter
intelligent despite his
disregard for
atrocious
human
character.
life
It's a
and while
shame he
using a
didn't put his
dangerous
critical
weapon,
thinking to good use.
contrary to
I'm with
sections
you on that.
941.30 sub 1, 939.50 sub 3 sub F, and 939.63
EE Carolyn EE
sub 1
became a
sub B of the
YouTube member.
Wisconsin
Thanks so much for joining Bike Club.
The 33rd
Welcome to Bike
count
Club.
of the information in this
And
case
I hope to see you on
charges
Friday
that
during our
Darrell E.
members
Brooks,
members
on or about
exclusive
Sunday,
stream.
November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin.
And Maria,
did
yeah, hearing all
recklessly
these
endanger
counts
the
makes it
safety
even
of
more
Jennifer
frustrating that he's
Stover
made a spectacle of
under
this trial with his
circumstances which
behavior.
show utter
I am
disregard
with
for
you on
human life
that.
and
I
while
am with
using
you
a
on that because
dangerous weapon,
it sort of
contrary to sections
brings back into the
941,
courtroom the seriousness of
0.30 sub
why
1,
they're there in the first place,
939.50 sub 3 sub
which is
F,
that a lot of
and
people have been harmed by this
939.63
man.
sub 1
A
sub
lot
B
of
the
people.
Wisconsin statutes. The 34th count of the information in this case
And thanks so much for the
charges
super
that
chat again.
Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Jesselyn Torres under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F,
Love
and
it, Kate Leslie.
939.63 sub 1 sub B of the Wisconsin statutes. The 35th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha.
Thanks so much, Who's Your What Now.
Waukesha
It's very
County,
kind.
Wisconsin, to
And I
recklessly
agree.
endanger the
Folks in this
safety of
chat are
Alice
wonderful.
Darrell under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 36th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Charlotte Urell under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 37th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Vivian Urell under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 38th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Grayson Urell under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to
Good question. Maybe I should add some emojis to the bike club chat.
Sub 3 sub F and 939.63 sub 1 sub B of the Wisconsin statutes. The 39th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Lola Hospital under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.
So you guys know I'm taking some questions and I'm saving some of them for a break in this so that I don't interrupt too much, even though a lot of this is getting repetitive. So, you know, we're hearing a lot of the same things
Darrell E.
over.
Brooks, on or about Sunday, November 21 of 2021, on Main Street, the city of Waukesha, Waukesha County, Wisconsin, did
He's just getting some exercises in, guys. That's
Tamara
all.
Rosentrader under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statute.
Eric, you're right. I should have
The
a secret
40th
McSquirrel
count of the
emoji.
information in this case charges that Darrell
I think that's
E.
a good
Brooks,
idea.
on or about Sunday, the 41st
Guys,
count of the
also,
information
other
in
ideas.
this case
If you have an
charges
idea
that Darrell E.
for
Brooks,
another
on or about
emoji
Sunday,
for
November
Bike Club,
21 of
let me know in
2021
the
on Main
chat.
Street in the
I would
city
love
of
to get some
Waukesha,
ideas for that.
Waukesha County, Wisconsin, did recklessly endanger the safety of Betty Strang under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of
That's a
the
good one.
Wisconsin statutes. The 42nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday,
Megapint, that's a good
November
idea.
21 of 2021, on Main Street in the city of Waukesha,
Gavel.
Waukesha County, Wisconsin, did recklessly endanger the safety of Maria Alvarez Dominguez under circumstances which show utter disregard for
A
human
blue
life
gavel.
while using a
Oh,
dangerous
yeah, that's a good
weapon,
idea.
contrary to sections 941.30
Indian
sub
homes,
1,
of course.
939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 43rd
box fort
count of the
emoji.
information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Georgia Romelia Perez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statute.
A judge's wig, that would be great. Yeah, Indian
The
homes.
44th count of the information
for when
in
they
this
show up.
case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Elliot Hallmark under circumstances which show utter disregard for
Bites.
human life and while using a dangerous weapon, contrary to sections 941.
It'll be like a man silhouette with like a question mark over his face.
939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 45th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Benjamin Hallmark under circumstances which show utter disregard for human life and while
With
using a
food,
dangerous
even
weapon,
better.
contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 46th count of the information in this
Joe,
case charges
welcome to
that
Bike Club.
Darrell E. Brooks,
Thanks so much
on
for
or about
becoming a
Sunday,
member.
November
And I hope you
21
can
of
join us on Friday
2021,
during
on Main
our
Street in the
Bike
city
Club
of
stream.
Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Patrick Heppy under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes.
And Manny Fabani with a member chat
47th count
says,
of
when are
the
we going to see Holmes and
information in
Indy
this case
plushies?
charges that
They're on their
Darrell E.
way.
Brooks,
They should
on or
be.
about
They should
Sunday,
be
November
arriving
21 of
soon. I hope
2021 in Main Street in
at
the
some
city of
point.
Waukesha,
But
Waukesha County,
they're
Wisconsin,
supposed to be arriving here. The
did recklessly
samples.
endanger
So
the safety of Lori
hopefully
Logan under
soon.
circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and
Hey, Michael Cook.
939.63 sub 1
Welcome
sub
to
B
Bike
of the
Club. Thanks so
Wisconsin
much for
statutes.
becoming a YouTube member
The
and for
48th
supporting
count
the
of
channel.
information in this
Thank you.
case
Thank you.
charges
Thank you.
that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Marisol Lopez Gutierrez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 49th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Adair Lopez Rebelar under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 50th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main
Lucky with
Street
the
in
member
the
chat
city of
says, love the
Waukesha,
blue gavel
Waukesha County,
idea.
Wisconsin,
I think
did
you're right.
recklessly endanger
I
the
think
safety
that's
of
a
Juan
really good
Marquez
idea.
under
I'm gonna
circumstances which show utter
that's
disregard
definitely
for
going to be
human
one of the
life
next ones.
and while using a dangerous weapon, contrary to section 941.30
Also,
sub
Lucky,
1,
thanks so much for gifting another
939.50
10
sub 3
memberships
sub F,
for
and
Bike Club. Thank you.
939.63 sub 1 sub B of the Wisconsin statutes. The 51st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of David Marquez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 53rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin,
Gunslinger
recklessly endanger
THS,
the
love Law
safety of
Talk with
Jason
Mike. I
Tetschlock
do too. He's
under
wonderful. And he's
circumstances
also
which show utter
streaming this. So if you
disregard
guys
for
want a
human
different
life and while
vibe, you want to
using a
try
dangerous weapon,
out somebody else,
contrary to sections
definitely go and check him
941.30
out.
sub 1, 939.50
He's a good
sub
dude.
3
He's a
sub
really
F,
good
and
dude. And
939.63
I
sub 1
highly
sub B
encourage
of
you
the
guys to check
Wisconsin
him out if you
statutes.
haven't done so already.
The 54th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Margaret Pachulis under circumstances which
did
show
he
utter
really? He stopped
disregard for
streaming?
human life and while using a dangerous
I
weapon.
thought he's been streaming like this
Contrary
whole
to
time.
sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes.
He had court. Okay.
The 55th count of
That makes
the
sense.
information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Yamilet Perales Alvarez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary
Not for
to
you,
sections
puppy.
941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 56th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha,
Yeah, that makes
Waukesha
sense.
County, Wisconsin,
Cole Reeves.
did recklessly endanger the safety of Alin Perales Alvarez under circumstances which show utter disregard for human life. And while
Thank you.
using a dangerous weapon,
Yes, Mr. Weitz is a very good man. Love him.
941.30
Love him to
sub 1,
pieces.
939.50 sub 3 sub F,
Thanks, B.
939.63 sub 1 sub B of the Wisconsin statutes. The 56th count of the information in this case charges that
And Annie
Darrell
Mae
Brooks,
Wholesale
on
has some
about Sunday,
jokes.
November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Ashley Perales Alvarez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 58th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, to recklessly endanger the safety of Jose Perales
I appreciate
Alvarez
your humor.
under circumstances
Yes,
which show
exactly.
utter disregard for human life. And
I
while
missed
using
an
a
opportunity
dangerous
there.
Weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 59th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, to recklessly endanger the safety of Maria Perez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.
And I know there have been some questions in the chat about death penalty. In Wisconsin, they actually abolished the death penalty.
The 60th count of the information in this case charges that
Nope,
Darrell E.
they
Brooks,
do not have
on or
it.
about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, to recklessly endanger the safety of Camila Perez Gonzalez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 61st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, to recklessly endanger the safety of Isaac Foglia under circumstances which show utter disregard for human life and while using a
Sarah
dangerous
Gardner,
weapon,
it's
contrary
very
to
common
sections
in
941.30
litigation.
sub 1,
I would write it in pretty much
939.50 sub 3
any
sub F,
piece
and
of
939.63 sub 1 sub
filing
B of
that
the
I would
Wisconsin statutes.
file in the court. Geez,
The
if I can be
62nd count of
at
the
least
information in this
articulate
case
here.
charges that
But yeah,
Darrell E. Brooks,
basically,
on or
even
about
if I know the
Sunday,
exact date of
November
something, I
21
would
of
say on or about
2021 on
such
Main
and such
Street
date.
in the city of Waukesha,
It's just
Waukesha County,
common in the
Wisconsin,
practice.
to recklessly endanger the safety of Deborah Ramirez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 63rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, to recklessly endanger the safety of Charles Green under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 64th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Lily Green under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 65th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, to recklessly endanger the safety of Brinley Harris under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 66th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Kelsey Knapp under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 67th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Owen Ricciati under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The defendant has entered a plea of not guilty to each one of these charges, which means the state must prove every element of each offense charge beyond a reasonable doubt. I'm going to take a quick stand break. Please stand, everyone.
Okay, we get a standing break. Make sure everybody is awake. This could be that this is just what she normally does, especially when there's been this many charges, or she could also be observing that maybe one or more of the jurors are currently maybe falling asleep, which is common for these, right? Because like I said, jury instructions are so important, but they're kind of dull. So, especially when they get to be very repetitive like this.
First degree recklessly endangering safety as defined in section 941.30 sub 1 of the Criminal Code of Wisconsin is committed by one who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of any count of first degree recklessly endangering safety,
this makes sense.
The state must prove by evidence which satisfies you beyond a reasonable doubt the following three elements were present with respect to that count. 1, as to each count, the defendant endangered the safety of another human being. 2, as to each count, the defendant endangered the safety of another by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death.
I'm reading that there are a total of
or
77
which
charges
causes
currently.
Serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. 3, as to each count, the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. The information alleges not only that the defendant committed the crimes of first degree recklessly endangering safety, but also that the defendant did so while using a dangerous weapon. Dangerous weapon means any device or instrumentality which, in the manner in it is used or intended to be used, is likely to produce death or great bodily harm. Great bodily harm means serious bodily injury. If you find the defendant guilty of a count of first degree recklessly endangering safety, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime of first degree recklessly endangering safety while using a dangerous weapon. If you are not so satisfied, you must answer the question no. If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 7, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 7. If you are not so satisfied, you must find the defendant not guilty as to count 7. If you find the defendant guilty of count 7, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 8, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 8. If you are not so satisfied, you must find the defendant not guilty as to count 8. If you find the defendant guilty of count 8, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that
Kathy
all
Richardson,
3 elements
thank you.
of first-degree recklessly endangering
Love the
safety
Lawyers
have
and
been
Dragons
proved as to
references.
count 9, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 9.
Stephen Yarger, I
If
will
you are
definitely
not
write
so
that down as a
satisfied,
possibility.
You must
I
find the
hadn't thought of
defendant
that
not
idea, but
guilty as to count
I
9.
will write it down.
If you find the defendant guilty of count 9, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 10, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 10. If you are not so satisfied, you must find the defendant not guilty as to count 10. If you find the defendant guilty of count 10, you must answer the following question, yes or no. Did the defendant
Thanks,
commit
Manny
the crime
Fubani.
of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 11, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 11. If you are not so satisfied, you must find the defendant not guilty as to count 11. If you find the defendant guilty of count 11, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 12, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 12. If you are not so satisfied, you must find the defendant not guilty as to count 12. If you find the defendant guilty of count 12, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 13, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 13. If you are not so satisfied, you must find the defendant not guilty as to count 13. If you find the defendant guilty of count 13, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 14, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 14. If you are not so satisfied, you must find the defendant not guilty as to count 14. If you find the defendant guilty of count 14, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 15, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 15. If you are not so satisfied, you must find the defendant not guilty as to count 15. If you find the defendant guilty of count 15, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 16, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 16. If you are not so satisfied, you must find the defendant not guilty as to count 16. If you find the defendant guilty of count 16, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 17, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 17. If you are not so satisfied, you must find the defendant not guilty as to count 17. If you find the defendant guilty of count 17, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 18, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 18. If you are not so satisfied, you must find the defendant not guilty as to count 18. If you find the defendant guilty of count 18, you must answer the following question,
Not
yes
yet.
or no.
They haven't done them yet.
Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 19, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 19. If you are not so satisfied, you must find the defendant not guilty as to count 19. If you find the defendant guilty of count 19, you must answer the following question, yes or no.
Charles
the
Dawson,
defendant
thanks so
commit the
much for your
crime of
super
first
chat.
degree recklessly
Says, ask
endangering
Mr.
safety
Bites,
while
how's the
using a
cow?
dangerous weapon?
Which is that is definitely
If you are
a
satisfied
West
beyond
Point
a reasonable
reference.
doubt that all three elements of first degree
So
recklessly endangering
I
safety
appreciate
have been
that.
proved as to
Mr. Bites,
count
of course,
20,
was a
you
West
should
Point
find
grad.
the defendant
So
guilty of first degree recklessly endangering
very
safety
funny.
as charged in count 20.
Thanks so much for the super
If
chat.
you are not so satisfied, you must find the
Ian
defendant
Kinzel,
not
thanks.
guilty
Thank
as to
you
count
for the
20.
super chat. Thank you.
If you find the defendant guilty of count 20, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 21, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 21. If you are not so satisfied, you must
No,
find
this
the
is the
defendant not
thoroughness
guilty
of
as to
jury
count
instructions
21.
is each one has
If
to
you
be
find the
read.
defendant guilty of count 21,
So
you must
yeah,
answer the
even
following
though
question,
it's
yes or no.
like I said,
Did the
it gets
defendant commit the
pretty,
crime of first degree recklessly endangering
it gets a little
safety while
dreary
using a
as you go
dangerous
through,
weapon?
especially when there are this many charges. But
If you
yeah,
are
it's got to be.
satisfied beyond a
be
reasonable
done.
doubt that all three elements of first degree recklessly endangering safety have been proved as to count 22, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 22.
Oh, and
If you are
Charles
not so
Dossett,
satisfied, you must find the defendant not guilty
I got a
as to
text
count
response from
22.
Mr. Bites.
If you find
who
the
said,
defendant guilty of count
Sir, she
22,
walks, she
you
talks,
must
she's
answer
full
the
of
following
chalk.
question,
The
yes
lectial
or no.
fluid extracted
Did the
from the
defendant
female of the
commit the
bovine
crime of
species is
first
highly
degree
prolific to
recklessly
the nth
endangering
degree.
safety while
Is
using
that
a
really what you're
dangerous
supposed to
weapon?
respond when somebody walks up to you and says, how's
If you
the
are
cow?
satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 23, you should find the defendant
right.
guilty of first
Some
degree
of these
recklessly
traditions are
endangering
weird.
safety as charged in count 23. If you are not so satisfied, you must find the defendant not guilty as to count 23. If you find the defendant guilty of count 23, you must answer the following question, yes or
Cool.
no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 24, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 24. If you are not so satisfied, you must find the defendant not guilty as to count 24.
Nice.
If you find the defendant guilty of count 24,
Charles
you must
Dossett,
answer the following question,
you might actually
yes
know my
or
brother.
no.
There's a
Did the
chance.
defendant commit the crime of first degree recklessly endangering
DM me
safety
on
while
Twitter or
using a
something.
dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 25,
Alejandro
you should find the
Amaya
defendant guilty
merch
of first
idea
degree
that should
recklessly
say
endangering safety as
we
charged in
legally
count
bite.
25.
I'll let that to the list
If you are
too.
not so satisfied, you must find the defendant not guilty as to count 25. If you find the defendant guilty of count 25, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first
Kate
degree
Leslie, are you talking
recklessly
about the
endangering
how's the
safety
cow
have
question?
improved as to count
Was he a West
26,
Pointer too?
you should find the defendant guilty
Awesome.
of first degree recklessly endangering safety as charged in count 26. If you are not so satisfied, you must find the defendant not guilty as to count 26. If you find the defendant guilty of count 26, you must answer the following question, yes or no.
Nice.
Did the defendant
Nice.
commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 27, you should find the defendant guilty of first degree recklessly endangering safety as charged in
So I
count
don't
27.
think that she's going in order
If you are
anymore.
not so satisfied, you must find the defendant not guilty as to count 27. If you
She
find
said
the
this is
defendant
count
guilty of
27, but
count
she's also
27,
gone
you must
through the
answer following
28th count.
question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 28, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 28. If you are not so satisfied, you must find the defendant not guilty as to count 28. If you find the defendant guilty of count 28, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering
GoldenEye,
safety
yes.
while using a dangerous
They
weapon?
generally are pretty much
If
always
you are
this boring.
satisfied beyond a reasonable doubt that all three
It
elements
helps
of
if you
first
have
degree recklessly
them written
endangering
out in front of
safety
you
have
so
been
you can
proved as to
visually
count
follow
29,
along.
you should find the
But yeah,
defendant
they get
guilty
pretty
of
dull
first
very
degree recklessly
quickly.
endangering safety as charged in count 29. If you are not so
It is a small
satisfied,
world, Kate.
you must find the defendant not guilty as to count 29. If you find the defendant guilty of count 29, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 30, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 30. If you are not so satisfied, you must find the defendant not guilty as to count 30. If you find the defendant guilty of count 30, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon?
Ian Kinzel,
If you are satisfied
thanks so much for
beyond
the
a
super chat.
reasonable doubt
Says,
that all
I don't know
three
what y'all are
elements
talking
of
about. This
first
seems
degree
interesting to me.
recklessly endangering
Fair.
safety have been
Fair.
proved as to count 31, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 31. If you are not so satisfied, you must find the defendant not guilty as to count 31. If you find the defendant guilty of count 31, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 32, you should find the defendant guilty
I
of
like that
first
too,
degree
actually.
recklessly endangering safety as charged in count 32. If you are not so satisfied, you must find the defendant not guilty as to count 32. If you find the defendant guilty of count 32, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 33,
There are a number of reasons,
you
but
should find the defendant guilty
one
of
reason,
first degree
Pamela,
recklessly
see
endangering
why they're
safety
being
as
read
charged
before
in
closing
count
arguments
33.
is
You
to
are
prevent
not
the
so
need from
satisfied, you must
covering
find the
that in the
defendant
closing
not
arguments,
guilty as to count
so that
33.
this way there's
If you find the
a
defendant guilty of
certain,
count
like,
33, you must answer the
educational
following
standard
question,
that
yes or no.
everyone has
Did
had
the defendant commit the
before
crime of
closing
first
arguments, so
degree
that
recklessly endangering safety
the
while
attorneys can
using
just
a
make their
dangerous weapon?
arguments and kind of fit it
If you are
into
satisfied
the
beyond a
knowledge that the
reasonable
jury
doubt that
already
all three
has
elements of
through
first degree
the jury
recklessly endangering
instructions.
safety have been proved as to count 34, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 34. If you are not so satisfied, you must find the defendant not guilty as to count 34. If you find the defendant guilty of count 34, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon?
No problem.
If you are satisfied beyond a reasonable doubt that all three
HWS,
elements
thanks for
of
the super
first-degree
chat.
recklessly endangering
Says, yay, I
safety
finally
have
caught a stream.
improved
It's
as to
Aussie.
count
I'm Aussie. It's 3
35,
a.m.
you should find the
So
defendant
late.
guilty of first-degree recklessly endangering safety as charged in count 35.
Thanks for joining us.
If you are
Thanks
not
so
so
much.
satisfied, you must find the defendant not guilty as to count 35. If you find the defendant guilty of count 35, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 36, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 36. If you are not so satisfied, you must find the defendant not guilty as to count 36. If you find the defendant guilty of count 36, you must answer the following question, yes or no.
I would certainly
Did
hope
the
so.
defendant commit the crime of first-degree recklessly
definitely
endangering
hope
safety
so.
while using a dangerous weapon?
Whether he is or not,
If you
I
are
don't know.
satisfied beyond a
But I certainly
reasonable
would hope
doubt that
so.
all three elements of first-degree recklessly endangering safety have been proved as to count 37, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 37. If you are not so satisfied, you must find the defendant not guilty as to count 37. If you find the defendant guilty of count 37, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 38, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 38. If you are not so satisfied, you must find the defendant
He
not
is
guilty as
representing
to count
himself.
38. If you find the defendant guilty of count 38, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 39, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 39. If you are not so satisfied, you must find the defendant not guilty as to count 39. If you find the defendant guilty of count 39, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon?
Tiffany
If you are
Roberts, that's
satisfied beyond a
insane, but
reasonable
thank
doubt
God
that
they're
all
okay.
three elements of first-degree
This is
recklessly endangering
one of those
safety have
times
been
when
proved as to count
I would say to
40,
myself,
you should find the defendant
what's the
guilty
phrase?
of first-degree
But for the grace of
recklessly
God, there go
endangering
I.
safety as charged in count 40. If you
Man,
are not so satisfied,
that must have
you
been so
find the
harrowing for them,
defendant
though,
not
even
guilty
with all of
as
that.
to count 40. If you find the defendant guilty of count 40, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 41, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 41. If you are not so satisfied, you must find the defendant not guilty as to count 41.
Insomniac Software Dev
you
says,
find
can
the
he argue
defendant
later on
guilty of
appeal that he had
count
incompetent
41,
counsel, even though
you
he's
must answer
representing
the
himself?
following question, yes or no.
He
Did the defendant commit the crime of first
has
degree
been putting
recklessly
on some
endangering
kind of a
safety
case of
while using
insanity,
a
but
dangerous weapon?
the judge has been
If you are
making a
satisfied
very,
beyond a
very
reasonable
good,
doubt that
diligent
all three
record
elements of first degree
showing
recklessly
the ways in
endangering
which he
safety
is
have been
competent, in
proved as
fact,
to
in this
count
case.
42,
So
you should find the defendant guilty
I
of
don't
first
think that
degree
he's,
recklessly
I
endangering
mean,
safety
can
as
he
charged
argue
in
later
count
on appeal?
42.
Yes. Yeah.
If you are not so
He almost
satisfied, you must
undoubtedly
find
will
the
appeal,
defendant not
and he probably will
guilty
argue
as to
something
count
along those
42.
lines,
If you find the
along
defendant
with
guilty
other
of count
arguments.
42, you
But
must answer the following
is it going to
question,
win?
yes
I
or
doubt it.
no.
I
Did
doubt
the
it.
defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? I've read 41 pages thus far. I'm going
41.
to take a short comfort break, and we'll come back in about 10-15 minutes. This will
Wow.
also give the jurors and the parties a chance to have a comfort break as well. All rise for the jury.
All right. 10-15 minute comfort break. So let's chat. These have been long, right? They do get repetitive because they they have to read through all of them, even when it's almost the exact same charge, but it's just a different victim or a different alleged victim. They have to read through all of them, because that's the process that they go through, and it's a security mechanism, right? To make sure that everyone on the jury has heard all of those instructions, that they know that they can say that because they were sitting there. They were, they're taking these breaks to make sure that people are still awake, that they're paying
8
attention.
But I will address that when I get back on the record. We are in recess.
Okay. So she's gonna come back and put some more on the record. So that way they're able to say that every single one of these counts was put in front of the jury, and that they had an opportunity to hear it, to understand it. And so then they'll be given written instructions as well. So, but that way no juror can come back and say, I didn't actually look at the piece of paper. I didn't know what we were doing, because all of them were in the room, when they went through all of those instructions. So that's why they've got to go one by one through every single one of these, even though there's 61 that are effectively repeats, just different alleged victims. So yeah, and it does get long, right? We've got another 33 pages, so we're more than the halfway point at this point with these jury instructions, right? And this is always like one of the more tedious parts of a trial, but like I said, very, very, very important. So right. Let me go through some questions here, some questions and some comments too, that were really interesting. So Jamel Cooper said, I don't know how closely you've been watching this trial, but I'm not convinced of intent in this case. So yeah, I mean, in intent, the jury can look at it in various different ways, right? I think that one of the more compelling arguments for intent is the fact that he not only didn't stop, especially after he hit one person, but he didn't stop. In fact, there was testimony talking about how he actually even sped up as he went down Main Street, where it's reasonable to see that there are a bunch of people, that it's an unsafe behavior that he's engaging in. And to say that, like, if he sees all of these people on the street and he continues to ram his car in there, even if he's not thinking specifically about like this particular individual, like I have a specific motive to kill this person, you can still have an intent to kill that person, or an intent to commit grave bodily harm to this person and end up killing them, because you might just be essentially, sometimes recklessness can go that far too. But I think that the circumstances being that he hit one person, he hit another person, he hit another person, and then he kept going at that point. He knew the consequences of his actions. So that is the kind of inquiry that is going to establish intent, is whether or not he knew what he was doing and he did it anyway. So I see plenty of evidence in this case for intent. Julie Easter says, does the jury's verdict have to be unanimous? Yes, it does. Otherwise, there is a hung jury, and that is a mistrial. And then it goes all the way back to the beginning again. Hopefully that doesn't happen. Sabrina Nicole says, do you give an update on the Masterson trial today? I have not given an update on that. I will be doing that either tomorrow or on Thursday. Tomorrow's Deep Dive Wednesday, and I am thinking that I'm going to go into the chess cheating scandal. There's now a defamation complaint that has been filed in that case. So there's a whole, I was getting like way down deep into the rabbit hole of that one over the weekend, because that one was very, very, very interesting. But the Masterson case I've also been generally covering since before trial started. So I am definitely going to be putting out more content about updates on that one. I know Tony Ortega he's actually in the courtroom, so he's got some really, really, really good he's got some really, really good insight about what's happening in the courtroom, and what he thinks is what he thinks is effective and ineffective and all that kind of stuff. And I've been talking with him too. I'm trying to schedule a time that's good for him to come onto the channel as well. So, yeah, but so no Masterson update from me today, but maybe tomorrow, for sure Thursday, I'll be getting deep into the weeds on that. That one and the Weinstein case, because both of those are at trial right now as well. And unfortunately, no cameras in the courtroom for either one of those. But yeah, we'll definitely be getting all caught up then, for sure. Bronwyn Warwood says, question, did each of those harmed by reckless endangerment need to file against him themselves, or did they get added just because they were harmed? They get added because they were harmed. They don't need to do anything themselves to have the state press charges on their behalf. Amy J says, I live in Waukesha and this man broke all of our hearts that evening. It has been difficult for our typically safe community. I hope the jury throws everything they can at this guy and puts him away. Yeah, my heart goes out to you. I'm so sorry, because just the nature of what happened and the time of year that it happened was awful too. There's never, I said this before, there's never a good time to have that kind of it really was basically a massacre, right? Somebody driving recklessly or intentionally driving their automobile into a parade of people at a high rate of speed, killing half a dozen and injuring so many more. Yeah, that's absolutely traumatizing for any community. And to do that at Christmas time, that's just even more difficult, because people want to be celebrating the holidays. People want to be engaging in Christmas cheer. That's what people are literally there to do that day at that parade. So I'm so sorry about that. That you've been going through that. The whole community is I'm sure it'll take some time to heal, but yeah. Insomniac Software Dev, can you argue later? Oh yeah, I went through this one earlier about him, arguing about incompetent counsel. So his argument would probably be that he is incompetent, but there have been many opportunities along the way for that argument to be made, and well, for starters, they did an evaluation of him before trial, right? So he did have an expert evaluation on whether or not he was competent to stand trial. And then when he decided to represent himself, the judge also relatively painstakingly went through a process of questions to ensure that he understood what it was that he was doing and why he, what advantages or disadvantages that he was going to have in representing himself, mostly disadvantages, to be quite honest. So that, and then along the way, also the judge has been keeping a very, very, very strong record of the things that he's been doing, the ways in which he's been engaging in the process, how he's been cross-examining witnesses, he's been objecting, and all this kind of stuff. So it definitely shows that he has an understanding of who all of the moving pieces are in the room and what the process is there for, and what the consequences of his actions in the courtroom are. So yeah, I highly doubt that there's going to be any good argument about that. Pamela C says, would you like to be a judge one day? Not in a case like this. I think sometimes I've thought about that would be interesting to be a judge, but I don't know. I mean, if I can continue YouTubing, I kind of like, doing this kind of thing by helping people to understand the law in a more like, public kind of general kind of way. So yeah, Cheryl Maston, thank you for that, Alita. My thought on intent was different, so you've changed my mind. I think he actually found himself there and reacted really badly. I don't think he went there to do it. Yeah, I mean, but that was one thing that was very important, that that the judge said early on with the jury instructions is to say that, intent, there doesn't have to be any amount of time in order to establish intent. Like, it can be like a fraction of a second, essentially, that somebody can develop intent. So it doesn't have to be, a lot of times people will think of like this, premeditated plan, lying in wait kind of thing when they think of like that somebody has intentionally killed someone, right? But yeah. So yeah, that was it was an important part that she went over relatively early on, which hopefully the jury was paying attention. You never know. And Colby Fowler, yes, they're just on a quick 10 or 15-minute break. So yeah. She's gone through, I think, 41 charges, and now she's still got, or 41 pages of her charges. Now she's got like 33 left. I think that was the count that we had at the end of it. So yeah. Yep. Just going through. And right now he is in he's in the back room, right? Where he's watching on a monitor, and his mic is turned off. That way he can't disrupt the proceedings, because she gave him a couple chances this morning and said, you can be here if you don't disrupt anything. And he continued to disrupt and continued to disrupt and continued to disrupt. So she sent him away. And then she almost immediately brought him back again and said, like, are you going to sit here and not disrupt? And so he continued to disrupt. And so she said, you're gone. You're out of here. So yeah. That's basically been it. All right. Let's go through. Let's chat here for a bit. Caroline EE says, nope, he made a knowing adult choice to do things this way. The damn attorneys have zero right to forcibly intrude and make someone accept help. The snobbiness is really toxic. This dope chose. You mean for representing himself? Yeah, that's that, and that was part. Maybe I'll see if I can find the video where the judge explains to Darrell Brooks. Also, that might be during one of these breaks. I might do that. She explains to him that he has two competing rights here, right? He's got the right to an attorney, and he has the right to represent himself. And so she said, you can't have them both at the same time, right? Because you're either represented by an attorney or you're representing yourself. But he has a right to both of those, and that's basically up to him, so long as he understands. And so, this was his choice, and he made that pretty clear. Stuck on Streams says, along with Amy J's comment, I really felt the impact when the medical examiner fought to not break down when she went over the injuries of the 8-year-old child. My daughter is 8. I cried. Oh my God. I can only imagine how difficult that is, to give that kind of testimony. Medical examiners are routinely dealing with death, with autopsies, with this kind of stuff. So you'll often find that they may have a dark sense of humor, especially when it comes to death and things like that. But when it comes to an 8-year-old child, that's the kind of thing that can still sort of pierce through. So yeah, that's tough. And I can only imagine that for you, with that connection with an 8-year-old child, that's also very, very difficult. Kate Leslie says, Natalie had a great point last night when she said he's the product of growing up without parental love and boundaries, and it shows in his adult reactions. He has zero control of himself. That could be too. My understanding about his mom, I don't know anything about his dad, but what I have heard about his mom is that I guess she spoke with the media and said that she had like disagreed with his choice to represent himself. And so she said that she just was not watching the trial at all, wasn't paying attention to the trial at all. And I kind of wondered about that, because I think that even like, every mother is different. I don't want to judge motherhood. I'm not a mom at this point myself, but there are a lot of decisions, a lot of a lot of decisions that are made in parenthood that can be impactful one way or another. And sometimes even with the best of intentions, you can make the wrong choice. But I think that, I know that my mom would have probably wanted to be in the courtroom, even if she thought that I was being a total fool and doing the wrong thing. I know that she would have wanted to be there. But not every mom is my mom, but yeah, that's it's an interesting thing though to see that his mom hasn't even been watching the trial at all. It's interesting. So let's go through more. Annie Mae Wholesale says, please come to the video game community. They're pretty confused. Confused about what? But I know that there's a lot of interesting stuff to talk about with video games and law. For sure. I've done a little bit here and there, a little bit of crossover. Usually Rick Hogue is the video game attorney on YouTube. But yeah, there's some interesting stuff there too. Oh, Pause Tech TV says, good afternoon, Legal Bites. Hey, how's it going, man? Or woman. I don't know. I just assumed. Person. Kate Leslie says he wasn't a stove sit until he was in jail. Is that true? Is that the first time? How do we know that? Because that's an interesting, I mean, I can see that happening. I can see someone not ever having that as a passion or an interest until it just becomes a very convenient argument that can benefit them. So yeah, that is interesting. Ellen Lee says this judge has so much more patience than I could ever muster. She has a lot. Yeah, stuck on strings. The problem is he didn't stop. He continued. Yeah, that is one of the biggest pieces, I think. Smiley Town SF, based on his past social media posts regarding violence against white people, why hasn't he been charged with any hate crimes? Hate crimes can be very difficult to prosecute. And when there are already 77 charges, that's a lot already. Usually for a hate crime, for a crime to become a hate crime, even if somebody has a past of verbalizing hate for another race, that doesn't necessarily mean that when they later commit a crime, it is motivated by race. So, usually you're going to be looking for things that they say around the commission of the crime, or if they vandalize, if somebody take someone out of their car and they beat them up and then they vandalize their car with some sort of a racial slur, for example, that's the kind of thing that could be the basis of a hate crime. But those can be pretty difficult to prove if you don't have something like that adds that extra element of racism to the actual crime. So yeah. Caroline E says, the meta view, Brooks knows his life is over. This is a coping behavior. Attorneys wouldn't have made a difference to his life in jail, so representation is a moot issue. Yeah, could be.
All right, we are back on the record.
Right.
The jury has not been brought out just yet. I indicated I would address a note that was passed by Mr. Brooks to the court. In it, he indicates the following: I have reclaimed my rights, parenthesis, that I never gave up or consented to give up, parenthesis, to be present, and you have not honored your oath of office to protect my constitutional rights, specifically my 14th Amendment, Section 1, which references equal protection of the laws. Would you like to explain this on the record, or should I will. If you won't, I would like to make an offer of proof for my appeal on the record. I indicated previously that should Mr. Brooks want to come back into this courtroom pursuant to Illinois versus Allen, he could certainly reclaim the right to be present.
Seneca
but
Nero.
he
Yeah.
would need to be willing to conduct himself consistently with the decorum and respect inherent in the concept of
Either
courts
one
and
is-
judicial proceedings.
Either one
I
is sad,
specifically
right?
advised that he would need
And
to
tragic
pledge
to say goodbye to
not
someone, but I
interrupt
definitely understand
proceedings.
your sentiment.
He has not done that, meaning he has not indicated he wants to come back or that he
Thanks, Laura.
will pledge to be courteous and follow the rules of decorum, and specifically pledge to not interrupt as I read through the jury instructions. And his letters or notes that he passed will, of course, be made part of the record, but I'm
That's
going to
interesting.
deny his request to make a further record for appeal, as I need to continue advising the jury of the jury instructions. So with that, Mr. Brooks will remain where he is at. Anything further he wants to address, he will need to do that in writing, as he has done with a note, but I don't feel the need to give him any additional opportunity to explain that. What I will ask is he going to make a request to come back into this courtroom? And if that is true, he can give me a thumbs up sign, and then I will address that. All right, I will unmute him. Mr. Brooks, what is your request as it relates to coming back into this courtroom?
I've requested to come back into the courtroom with the first writing that you said I had to write.
I put that on the record already, sir. You did not pledge to respect the rules of courtesy and decorum and pledge to not interrupt the court. Are you willing to pledge that at this time?
Your Honor, with all due respect, I've never had to do that before to reclaim my right. I've always asked, when you've given me the opportunity, when I felt that the time was right, I've always asked to come back. Have I not?
Mr. Brooks, given your conduct this morning and your blatant violation of my direct order to you to not interrupt when the jury was being brought out, I felt it important to strictly enforce the language of Illinois.
Maybe he's tripped up between
Allen,
pledge and donate.
and only bring you back if you are willing to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, and specifically pledge to not interrupt as I go through all of these jury instructions. If you're willing to do that, I will bring you back in.
Your Honor, with all due respect, can we at least be fair and say today hasn't been as volatile as other days? Or as
That doesn't matter, dude.
the back and forth.
Just because you
between
haven't been
and I
as volatile
hasn't been,
doesn't mean that you have
what it has
that you can be forced back
Mr.
in
Brooks,
there.
we started
If
the
you're still not
advisement
meeting the
to jury
standard.
an hour later than I anticipated. So I would thoroughly disagree with you that it might not have been volatile or loud, but it was nonetheless disruptive.
There you go.
So I will ask
Your
you these
Honor.
questions, sir. If you come back into this courtroom, are you willing to honor my request and order to you that you not interrupt as I
Wasn't
read
as much of a
through
douche as
the
yesterday,
jury
Your Honor.
instructions?
Your Honor, I don't understand the question that you're asking.
Sir, are you
Okay.
willing to refrain from raising the issue of subject matter jurisdiction if you come back into this courtroom?
Your Honor, with all due respect to your ruling on Illinois versus Allen, that was not part of Illinois versus Allen. I don't understand why that's being
Mr.
made
Brooks, I'm
of-
not going to debate the meaning of Illinois versus Illinois v. Allen with you. I'm simply trying to get you back into this courtroom. You seem to want to be here, but you don't want to pledge to follow the rules of courtesy and decorum. So that's on you.
Your Honor, this has never been done before.
What?
It's never been done before, and I've always been able to reclaim my right to be able to be present.
Are you willing?
Which is what I stated.
Yeah, this is
when I
particularly
first came
serious.
over here. I've been
that you
stating the
don't
same thing.
interrupt.
I've actually told the bailiff numerous times.
Mr. Brooks, I am strictly enforcing the language of Illinois versus Allen, which says the following. I will repeat myself again. Once lost, the right to be present can, of course, be reclaimed as soon as the defendant is willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings. I have not required the pledge previously. I've allowed you to come back, but given the interruptions this morning and your immediate discussion of things like subject matter jurisdiction and my oath the minute one juror walked through that
Immediate
door,
is correct. That's a correct
I cannot
characterization.
take that I will not bring you back in without that pledge.
So where does it say anything about a pledge, Your Honor?
Sir, I'm not going to debate the language with you. I am establishing what I believe is a reasonable restriction on your right to come back into this courtroom based upon the history in this case of your repeated violations of the simple rules of courtesy and decorum,
Yep.
and your failure to follow my very clear and direct requirement this morning that you not interrupt the reading of the jury instructions and you be silent once the jury entered the courtroom. I did that in part because it not only preserves the dignity and decorum of this trial, it also frankly protects your rights and it minimizes your bad behavior in front of the jury.
Don't you understand? The things you are doing are bad for you.
While you were talking, I'll let you make your record without talking over you or interrupting.
Thank you. I would agree with you just now.
The way that I'm interpreting, when you reference to me, with the Illinois versus Allen, where your ruling is coming from, the way that I interpret that is not the way that you're saying it to me now. That's why I don't understand what you're asking. I'm interpreting that in a totally different way.
It's not up to interpretation, man.
I'd refer you to the third section of Illinois versus Allen, where the U.S. Supreme Court was discussing what the trial court did in that case. And it said the following: the trial court in this case decided under the circumstances to remove the defendant from the courtroom and to continue his trial in his absence until and unless he promised to conduct himself in a manner befitting an American courtroom. As we have said earlier, we find nothing unconstitutional about this procedure. So that is the authority, sir, in addition to the other quotation. I'll tell you this. I'll give you one more opportunity, sir. You can come back into this courtroom.
Oh, boy.
But I do not want you to address or attempt to address subject matter jurisdiction or any of the other rulings that I've previously made. I need to continue with the advisement to this jury about the rules that govern their deliberations. That is the stage we are at. And if you violate that in any way by raising any of those legal issues in their presence, that will be in direct violation of the requirement for you to reclaim your right, and you will be removed back to the other courtroom. Did you hear me say that, sir?
I'm informed, but Your Honor, now you just stated on the record if I raise these issues in their presence, but if they're not in the courtroom, it's not in their presence, correct?
Sir, I can't bring them into the courtroom until you're here. I expect you during that short interval not to raise these legal issues that I've already addressed multiple times. So yes, I'm telling you, if you come back into this courtroom, I don't even want to have you raise any of those issues. I want to bring the jury right out without interruption. That is my clear expectation, whether the jury's in the courtroom or not.
Your Honor, I'm confused because you just said don't raise any issues in their presence, and now I'm confused.
Because you're indicating to me by your statement that you intend to raise them once you get back into this courtroom. And so I'm making that another restriction, and you need to pledge to me.
She has the ability to do that.
You will not do that.
This is her courtroom.
Your Honor, the way that I'm interpreting what you just read to me from the other section that you just read from Illinois v. Allen, it does not have that language. So I'm
Mr. Brooks, I'm not going to debate the language. Do you want to come back in here or not?
Welcome to the insanity stream.
I've stated numerous times that
it's like you could check in at any point, and he's just doing that, right?
Back, but now
it's just the same thing, right?
What I don't understand about it, Your Honor,
this is the song that never ends.
Enforced
Mr. Brooks, do you want to come back in here or not? It's a very simple question.
I said yes already.
All right, then I'm going
to say the same thing.
Because then you go on and make other statements, and then I can't even effectuate your request.
But I'm trying to tell you how I'm interpreting what you're saying to me. If you want,
Mr. Brooks, I'm going to mute you. We're going to go in recess. He can be brought back over, but I will advise you that if you start back in,
Oh, and he
even
shakes his
outside
head
the
like,
presence of
"Ugh."
this jury, with any of the
I know.
legal issues I've already ruled on. You will go back to the other courtroom. It's that simple.
Yeah.
So we'll be in recess. He'll be brought back
We're gonna-
over, and then we'll start back up.
We've seen this twice already today. He's going to come right back in. He's going to start arguing about subject matter jurisdiction.
That's it.
And then she's going to send him right back out again.
Have you got a t-shirt for that yet? Subject matter jurisdiction? You probably need to
Not
get one
yet.
out.
Not
You
yet.
have
Not
to.
yet.
Oh my God.
Oh man. Stephen Yarger, thanks so much for the super chat. Says the judge's mug, life is short, your heels shouldn't be. Is that really what the mug says? I was trying to figure that out earlier, but I didn't catch it. But that would be hilarious.
Oh, he's
I don't know what
yelling at it.
Yeah, what is he
Oh, he's muted.
gesturing about? Maria says his interpretation has zero value. LOL. Yeah.
Well, the value for value presumes you actually give value. I'm just saying, everybody keep that in mind. Value for value, because I know about the whole No Agenda show, and I know about the podcasting thing where it's a value for value, as in, if you like our show, donate, please. It's the theme of a super chat, technically. But this guy gives zero value. So how can you ask for value?
Yeah. Shats 32, the judge is going to need some milk. No, I think this judge is going, oops, sorry. I think this judge is going to need some, I don't know, whiskey after this.
I don't know. Is cannabis legal in the state? Because I would probably want to recommend that in dealing with this guy.
Fair point. Fair point. Yeah, I don't know. We should ask Natalie. She said she might pop in at some point too, Natalie Wisco.
Cool.
So we'll have to. She will definitely know if it's legal or not.
Has she dealt with anybody like that? Has anybody dealt with anybody like this?
I don't know. I mean, I talked about this early in the stream, but the closest that I've dealt with is when incarcerated inmates are suing the state for all kinds of crazy reasons. Sometimes legitimate. I feel like I always have to say that. But then otherwise, a lot of very illegitimate claims too. So they'll sue for all kinds of reasons that just don't even make sense. Like you have to literally, they'll handwrite a complaint. Sometimes you have to cut it out, spread out all of the sentences on a table, reassemble it for them, and then make some kind of a cogent argument on their behalf, because it's like, if you've got to respond, you've got to respond.
So you're saying it's either a kidnapping, ransom note, or Scrabble.
Yeah, basically. So
oh my God, this guy, I literally get so frustrated watching him that it's infuriating. And there are very few people that I can say have almost no redeeming qualities, and this guy stands pretty high on that list. He is one of those where obviously the acts he's being accused of are beyond monstrous. Yes. But then his personality is repugnant. And then to add to it, he's one of those people who thinks he's smarter than everybody else and is dumb as a rock. And you have to listen to him spout off nonsense and then look at you askance like, obviously you don't know anything, because I just laid this grandiose argument that is on a level of a professorial pedagogical transcript, but you're too dumb to understand. And I'm going, God, I wish I was talking to a 10-year-old, because they make more sense.
Yeah. No, I know exactly what you're talking about. And this is also a situation where he has a captive audience, and he seems very, very aware of that, right? Because because he is the defendant here. He's the one with the rights that can be violated. He's the one who people kind of have to engage with on a certain level, especially this judge. So some people,
this judge, if she's not a mother, she's got to have something, because and it was funny. I argued with my locals chat this weekend, because they're like, I'm like, look, I kind of get it. She has to bend over backwards because of that case, the Chicago, whichever one, or Illinois versus, it came up so many times, I forget it.
Illinois versus Allen, I think.
Yeah. Illinois versus Allen.
Yeah.
That he has to be given every possible opportunity above and beyond. And I know she's like, okay, this is 3 weeks out of my entire life. If I can make it through these 3 weeks or 4 weeks, I will never have to see this stupid thing again. I want this thing to be held up on appeal. I want there to be no question whatsoever. So I get it. But oh my God, it is just, it's frustrating. And I can see the frustration from Emily, everybody else. It's like,
it's so frustrating.
It's like, I don't know. You have a problem with people who like hit you up for change or whatever. This is one of those that's like, do not engage, don't engage, don't engage, don't answer him.
Because as soon as you do, it's a sandpit. But speaking of someone who is definitely not a sandpit and is a wonderful ray of sunshine, Miss Natalie Wisco.
Hi.
How's it going?
Oh, it's fine. I figured it looked like from this, I've been watching various streams and I jumped on Mike's for a minute this morning because he sent me a link. And it looked like we were in like an actual decent, more lengthy break. So I thought I'd say hi.
Yeah.
Howdy.
Thanks for popping in.
Yeah.
We had some questions. We were talking about the judge here and talking about her patience and how I said that at the end of the day she probably needs a good glass of whiskey. And Eric was like, I wonder if weed is legal in Wisconsin. And I said, Natalie would know the answer to that
No,
question.
it's not. But
she could use it.
I mean, we're really close to Illinois, though. Like, I live 6 miles from the Illinois border. So, I mean, Waukesha, I mean, she could drive an hour and be in a legal state. So,
it might be
Fair
worth
point.
it. I'm not to recommend, but after a day of that, I mean, I don't know.
Yeah, it's an exercise in patience. Like, there's no other word for it.
Have you ever dealt with a client like this, a SOVSIT client?
Yeah, I mean, I've had a SOVSIT client, and this is kind of wraps into the appointed counsel, standby counsel thing. Is, there's been a lot of discussion about standby counsel in this case, stuff like that. If you actually look at the language of the statute, so in Wisconsin in general, in addition to state public defender appointments, there's also the ability to have an attorney appointed by the county. Usually with public defender appointments, the people who qualify for public defender are more of like the poorest of the poor. But that doesn't mean that people who don't qualify for public defenders can necessarily afford private attorneys. So there is county appointed attorneys specific upon the county. You usually get paid more through county rates, things like that. And the county allows the people to pay them back on a payment plan, which is, like $50 or $25 a month, something like that. So I've been county appointed before for an individual who didn't want an attorney at all. He just wanted to represent himself. He was SOVSIT type of thing. And, he'd had other attorneys. The case had been going on for 3 to 4 years beforehand, and he just wasn't getting along with anybody. I agreed to come on as successor counsel. And hold for 1 second, you guys.
Oh, sure. So I'm sure she'll be back.
Okay, here's my question of the hour.
Well,
sorry,
here's
there
a
was
question for
someone who
you,
was just in
Eric
my-
Hunley. Manny Fabani says you need to do more voiceovers.
Okay.
Sorry, I'm in my office and somebody walked by. I had to talk to them.
Oh yeah, no worries.
But so I had been appointed in a case like that. And I mean, as soon as I get on the case, the client's like, no, I want to be pro se. And I'm like, well, that's your right. I made a motion to withdraw, and he had done this multiple times. The judge before had refused to allow him to do it. But I had said, I was like, you have the ability, like, I'm willing to stay on as standby counsel, because standby counsel is for the benefit of the court. So she allowed that. So I had to deal with him in that aspect. I mean, a lot of it is, it's the same thing, dealing with these, procedural things. I think that case, I was able to help him get it over with very quickly, though, because, I think a lot of it is listening and making people focus on the next step is because, you know, he was very much hung up on a lot of the issues that Brooks is hung up on, you know, jurisdiction and how do they have jurisdiction over me and things like that. And I'm like, okay, you can make that argument and that's fine. I was like, but you have to have a next step prepared. So because that's the thing. It's there are only two things that are going to happen, you know, or only really two things that can happen after you do this. You know, they're either going to agree with you or they're not, and you have to be able to move forward. Because if you just get hung up on the issue, then it's going to be the same thing that we've been doing for the past 3 years, which is not getting anywhere. So I helped him a lot with helping him focus on the next steps, because it's like, you know, you have made it very, very clear that you have these positions. And, you know, the only way you're going to get relief is from an appellate judge, but we have to get to that point. So even though you don't want to take the steps to get there, there's not going to be relief that's going to happen at this point. So we have to find a way to move forward so you can have the issue that you're concerned about addressed, because it's just not going to happen otherwise. So that was, you know, able to do that. You know, I mean, I also have a tendency, I think, like, and the reason, you know, I even agreed to take that appointment to start with is because with difficult people, you know, seem to, you know, a lot of it's listening. So that was able to help with that. And that aspect is, you know, you acknowledge people's concerns and you move forward. And it's like, you know, I think that's really the thing is, you know, he needs somebody, even if he is going to represent himself, to be like, but what do you do if that doesn't work? Because Brooks is putting all of his eggs in one basket here and is hoping that the procedural issues in and of themselves are going to be dispositive to the ultimate case. And you have to have a contingency plan to move forward.
Out of curiosity, and this might be out there, I would like to actually have somebody who understands sovereign citizens or is one who can put forth a coherent argument to learn what the hell a sovereign citizen actually is, because it's thrown around a lot. Sovereign citizen, etc. And I don't completely understand it. I kind of was under the impression that they're sort of like a super out there libertarian or an extreme libertarian mindset, possibly, but I don't know what they are. And I think it would actually be beneficial to get somebody, and again, not to mock them or whatever, because all I ever hear is somebody saying that they are or they're not, or people are mocking them. But I kind of want to know, okay, who are they? What is this all about? And
I mean,
talk to one just to get a handle on because it's very frustrating, some of the stuff.
Yeah, I mean, it's very much a Dunning-Kruger effect type of thing. In my opinion, my experience is people, you know, you learn a certain amount of information, then you think you know everything. And that's one of the difficult things about the law, is that when you read a law black and white on the books, is it doesn't necessarily mean that. That's what case law is about, is because the interpretation of the law and the application of the law is very situationally specific with a lot of things, because the law itself is designed to, you know, promote situational justice. That is why there's, you know, discretion in charging people and stuff like that. And, you know, I think that there's just so much more that you need to be aware of. And that's the problem with them, is they get very, very hung up on these procedural things that really have no bearing on, you know, the trial. A trial itself is to figure out whether or not somebody did something.
Yeah,
sure.
It's not to figure out whether or not, you know, the law is appropriate or something like that. It's under the law is if the law, accepting the law is true, did it occur? And that's the thing, is, you know, knowing at different points in times what to focus on in order to get success is really a hard thing for them, is because they focus on something that is legitimate and might be, that needs to be addressed, but you can't bring up everything at every point in time.
Yeah.
So
I think
because it while it's happening, you know, like they're running the appeal before the appeal can happen.
Because I mean they're making a legal argument as opposed to a factual argument, right? So they're basically arguing like none of this is legitimate. None of this whole process is legitimate because you don't have jurisdiction over me. Yeah. Because I'm not subject to the laws of this state or the laws of this country, because I declare myself to be sovereign. Essentially.
I guess they're saying that they're back.
Yeah, I've got it's not showing just yet on this
Okay.
feed, but I do see folks saying that.
record
Oh, here we go.
Appearances are
There
as
we
they
go.
were before.
And
The record
Stuck on
reflects
Strings,
that
thanks for the
Mr.
super
Brooks
chat.
remains
Says
in
Natalie
the
Lorachik did
other
a great
courtroom,
succinct explanation of
despite what I thought was
Sovsit, along with
he
historical
made
context.
clear
I
he
think it was
wanted
day
to
2
be
or 3
here.
Brooks trial. Okay, really
My
good.
understanding is he is now saying he doesn't understand what this court wants. I've made it very clear. I believe what this court's expectation is that I continue with the jury instructions without interruption.
Court
that Mr.
TV
Brooks
is usually
follow
behind because they take commercial breaks.
the
Okay.
rules of
Makes
courtesy
sense.
and decorum. He's had those for quite some time, and that he conduct himself consistently with the dignity and decorum that these proceedings deserve. And that includes not interrupting or bringing up legal matters that this court has
So
previously
once again,
ruled
she's
on.
putting this all on the record.
We have
That
lost
she's
a
bringing him back
significant
in
amount of
after he
time
requested
now
again to come back
addressing,
in.
or not even addressing, but Mr. Brooks really interrupting
I would describe him as
the flow
truculent.
and the
I mean,
proceedings
that's the best way I can put it.
based upon his
Yeah.
responses. And
Yeah.
then he attempts to engage with this court on the meaning, for example, of Illinois versus Allen. He needs to make a very clear statement to
Kate
this
Leslie.
court, not an
Here we
ambiguous
go, we're
one,
back
but a very
again.
clear one, that he wants to come back into this courtroom and that he's willing to conduct himself appropriately. And until he does that, he will continue to forfeit his right to be present in this
I
courtroom.
like that she finally
as I
put forth
instruct the jury.
standards that
So
there has
with
to be a
that,
note and it
I
has
did
to
give
say
him
this,
5 minutes.
this, and
I said, you
this,
have 5
or he's
minutes
not
to
coming back
decide.
in.
I set a timer.
Yeah.
It went off. He is still in the other courtroom. We are
Oh,
going to
so he
continue,
is still
so
in the
jury
court
is
in
to
the
be
other
brought out.
room. Okay.
And Madam Clerk confirmed that the audio and video is working just fine. I should further indicate he continues to be muted, so as there are not interruptions. And if he wants to address something with the court, he needs to write it on his pad of paper, and I will address it at the appropriate time. What time did the jurors go out?
11.
Just want to put on the record that at
Oh,
11:01, I
guess
took
that
the
was
break.
Backstreet
It's
Boys,
now
wasn't it?
11:48. So I
Here we go.
intended
I'm
to
trying to
take
think
10,
which
15 minutes tops,
NSYNC
and
song that is.
Mr. Brooks,
I
you
was
can
more of
write
an
it down.
NSYNC
I'm not going to
fan
interrupt further. The
than
jury's
Backstreet
coming
Boys
out.
anyway.
Here we go. Here we go. One more time.
Oh, there you go. Okay. Thank you, Natalie. Thank you. Kate, I think we grew up with the same with the same music tastes, same time period.
This guy is such a nightmare too. And I love the fact that he has this headphone routine when there's obviously speakers in there and everybody can hear everything, but he's like, oh, I mean,
Thank you, everyone.
it's
Please
such
be seated.
childish stuff.
Yeah. Yeah.
Continuing on then with the jury instructions. If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 43, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 43. If you are not so satisfied, you must find the defendant not guilty as to count 43. If you find the defendant guilty of count 43, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 44, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 44. If you are not so satisfied, you must find the defendant not guilty as to count 44. If you find the defendant guilty of count 44, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 45, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 45. If you are not so satisfied, you must find the defendant not guilty as to count 45. If you find the defendant guilty of count 45, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 46, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 46. If you are not so satisfied, you must find the defendant not guilty as to count 46. If you find the defendant guilty of count 46, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 47, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 47. If you are not so satisfied, you must find the defendant not guilty as to count 47. If you find the defendant guilty of count 47, you must answer the following question,
Manny
yes
Fabani,
or no.
thanks for the super chat.
Did the
Am I
defendant
the only
commit
one
the
who wants him
crime
to
of
stay
first degree
unmuted for the
recklessly
entertainment
endangering
value?
safety while using a
No,
dangerous
not
weapon?
for this part.
If you are satisfied
This is
beyond
just
a
bananas.
reasonable
Also,
doubt that
Eric,
all
please
three
do more
elements of
voiceovers
first
or
degree
ASMR
recklessly
or both.
endangering
Your call.
safety have been proved as to count
Okay.
48, you should find the defendant guilty of first degree recklessly endangering safety as
I'm no
charged in
Scott
count
Cardinal,
48.
but
If
thank
you are
you.
not so satisfied, you must find the defendant not guilty as to
Yeah, you
count
guys both
48.
have soothing
If you find
voices.
the defendant guilty of count 48, you must answer the following question, yes
So
or
I was
no.
like not
Did the
paying
defendant
attention, and
commit
then I
the
just
crime of
heard
first degree
something. Was it
recklessly
something I'm supposed to
endangering
respond
safety
to?
while using a dangerous weapon?
I don't-
If you are
You know what?
satisfied beyond a
You bring up
reasonable
something
doubt
that's
all three
that
elements of
really
first degree
is
recklessly
sad.
endangering safety
I'm
have been proved as to
this
count
is so
49,
long and it's
you should
running all
find the
together, but
defendant
these are
guilty of first
lives that
degree
are all
recklessly
destroyed.
endangering safety
Mhm.
It's such a
charged in count
long list
49.
that
If
we're
you are
getting
not so
bored
satisfied, you must find the defendant
listening
not
to it, and
guilty
that
as
kind
to
of
count 49.
makes me feel really
If
guilty
you
and
find the
disturbed.
defendant guilty
Going,
of count
wow,
49, you must answer
Yeah,
the
I'm
following
actually
Probably
trying to
question, yes or no.
multitask, so that
Did the
was more of
defendant
my
commit
thing.
the
Is
crime
I
of first
literally
degree
was paying
recklessly
attention to
endangering
something else,
safety
but
while
then I
using a
heard
dangerous
something
weapon?
about the two of you.
If you are
and I was like,
satisfied
okay.
beyond a reasonable doubt that all three elements of first
No, you're
degree
good.
reckless endangering
No, you're
safety
fine.
have been proved as to count 50, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 50. If you are not so satisfied, you must find the defendant not guilty as to count 50. If you find the defendant guilty of count
Stephen
50,
Yarger, thanks
you
for your
must
super
answer the
chat.
following
I second
question,
Manny's
yes or
comment.
no.
These guys have been
Did the
leapfrogging
defendant
this
commit the
entire
crime
live
of
stream
first degree recklessly
with their
endangering
super
safety while
chats.
using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 51, you should find the defendant guilty of first degree recklessly endangering safety as charged in count
I have a
51.
question for
If
you,
you are not
Lee
so satisfied,
and
you must
Natalie.
find the defendant not guilty
Do
as to
you
count
actually
51.
think that he
If you
has a
find the
mental
defendant guilty of
illness,
count
or
51, you
do you
must
think
answer the
it's a
following
character
question,
issue?
yes or
Not a
no.
character issue,
Did
but
the
a
defendant commit the crime of
personality
first degree
disorder.
recklessly
And I'm
endangering
being
safety while
very
using a
serious here.
dangerous
Like,
weapon? If
I
you are
think he's been
satisfied
playing
beyond a
the quote
reasonable doubt that
crazy
all three
card for a
elements of
little
first
bit,
degree recklessly
but a
endangering
lot of his
safety
actions, he's
have
very
been
aware of what's
proved as
going
to
on
count
around him.
52,
You could tell by some of his
you should find
answers
the
and his
defendant guilty
games
of
that he's
first
just
degree recklessly
constantly
endangering
manipulating
safety
and
as charged in
playing
count
games.
52. If you are
And
not
I
so
can't help but
satisfied, you must
say,
find the
this
defendant
doesn't
not guilty as
feel
to
like
count 52.
a diagnosable
If you
condition.
find the
Like, I
defendant
don't
guilty
see
of
a
count 52, you must answer
schizophrenia
the
type of
following
action in
question,
here.
yes
I
or
don't see
no.
a lot of things. I
Did
see
the
a
defendant commit the safety while using a dangerous weapon?
attitude.
If
Does
you are
that make
satisfied
sense?
beyond a reasonable doubt that
Yeah,
all
I
three
mean, I
elements
think
of
it's
first
kind of a
degree recklessly
combination of the
endangering
two,
safety have been
honestly,
proved
is
as
I
to
think they
count
kind of feed
53,
into each
you
other.
should
I
find
mean,
the
I
defendant
obviously
guilty
don't,
of first
we
degree
need Nurse
recklessly
Liz on,
endangering
talk about
safety as
diagnosing
charged in
people.
count 53.
But,
If you are not so satisfied,
you know,
you must find the
at least
defendant
my
not guilty
experience
as
with the
to count
soft sit
53.
person that I worked with
If you find the
is
defendant guilty of count 53,
he was
you must
very,
answer
very
the following
intelligent on
question,
certain
yes or
things, but there
no.
was just a
Did the
fundamental
defendant commit the
understanding and
crime
lack
of
of
first
comprehension
degree
about other
recklessly endangering
things
safety while
that,
using a
in
dangerous
that case,
weapon?
I specifically believe was related to mental health and substance abuse.
If you are satisfied
So I
beyond a
think that it
reasonable
was a
doubt that all three
combination
elements
of
of
being
first degree
hard-headed
recklessly
and
endangering
also other
safety
things, and I
have been
think those
proved
kind
as
of
to count
feed into each
54,
other.
you should find
So
the
I don't,
defendant
I
guilty
mean,
of first degree
from what I've
recklessly
seen,
endangering
I
safety as
don't
charged in
doubt
count
that he's
54.
got mental health
If you are not
issues.
so
I mean,
satisfied,
just
you
his
must find the
inability to
defendant not guilty
control
as to count
seems to
54.
regulate his
If
emotions
you
and
find the
things like
defendant
that.
guilty of count
I don't
54,
think that
you
this is
must
a
answer
complete
the
cop
following
out,
question,
though.
yes
I think
or
some of
no.
it is
Yeah.
obviously
Did the defendant
intentional,
commit the crime of
but
first
they
degree
do feed
recklessly
into each
endangering
other.
safety safety while using a
Yeah.
dangerous
No, I
weapon.
think I would
If
I
you
would
are
agree. I
satisfied
mean,
beyond a
not
reasonable doubt that all
being a
three elements
psychologist
of
can't
first-degree
diagnose,
recklessly
can't do,
endangering safety have
want
improved as
to
to
like
count
step
55,
far away
you
from that
should
kind of
find the
stuff. But
defendant guilty of first-degree
um,
recklessly endangering
yeah,
safety as charged in
it
count
seems like
55.
there's
If you are
some
not so
at
satisfied,
least
you
some
must find
measure
the
of
defendant not
him
guilty
playing
as to
things
count
up
55.
Oh
for
yeah.
If you
for
find the
That
defendant
that
guilty
also
the
could be
public.
related to
you
personality
must answer the
disorder.
following
So
questions.
Right. Well,
Yes
Thursday
or
I have
no.
Dr. Doss coming
Did
on,
the
and I
defendant commit
cannot
the
wait
crime of first
to
degree
get his
recklessly
assessment
endangering
because
safety while using
he
a
is somebody
dangerous
who
weapon?
works in asylums.
If you are
Mhm.
satisfied
Oh,
beyond a
wow.
reasonable doubt
And he's
that
a
all three
full-blown
elements of first
psychiatrist
degree
and
recklessly
expert in court.
endangering
So
safety have improved
because
as to
he
count
has to deal
56,
with
you
people
should find the
who are
defendant
in the
guilty of
asylum, he could say, yeah,
first-degree
this is
recklessly endangering
reminiscent
safety
behavior
as
that I've
charged in
seen
count
before or
56.
not. So
If you are
I
not so
really look
satisfied,
forward
you
to
must
that.
find the defendant
Well, I
not
think it's
guilty
just,
as to count
it's a
56.
compounding of
If you
multiple
find the defendant
things, and that's
guilty
how
of
you
count
end up
56,
with
you
people
must
in this
answer the following
position. Is,
question, yes
I
or
think that
no.
there's
Did the defendant commit
been
the
bad
crime
stuff
of
that's
first
happened
degree
to him,
recklessly
in
endangering
addition to
safety
having
while
mental
using a
health
dangerous
concerns and
weapon?
also perhaps a
If you are
personality
satisfied beyond a
disorder,
reasonable doubt that all three
things
elements
that
of
aren't
first
necessarily
degree
as
recklessly
prevalent in other
endangering
people.
safety
You
have
might
improved
see
as to
like
count
bits of it here
57,
and there in other
you
people,
should
but
find the
he's just,
defendant
Mhm.
guilty of first
got
degree
all
recklessly
three
endangering safety as
of the
charged in
crowns.
count
This one hit the
57.
jackpot, and it
If
just
you are
kind
not
of,
so satisfied, you must find
leads
the defendant
to
not
this
guilty as to
chaos when
count
dealt with in
57.
court.
If you find the defendant guilty of count
Yeah,
57, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering
Manny
safety while
Fabani says, I
using a
second
dangerous
Stevens
weapon?
seconding my genius
If you are
comment.
satisfied beyond a reasonable doubt that all three elements of first degree
Thanks,
And I
Manny
think,
recklessly
I've seen
endangering
people
safety
comment in the
have
chat
improved
that
as
it's
to count
also,
58,
they think it might
you
also
should
be
find the
about
defendant
control.
guilty of first
And I
degree
think that
recklessly
that's,
endangering safety as
I'm not
charged in count
justifying
58.
his behavior in
If you are
any
not so
way,
satisfied, you
shape,
must
or
find the
form.
defendant not guilty
But
as
I
to
know
count
that
58.
all of my
If you find the
clients, for the
defendant
most
guilty
part,
of count
struggle a lot with
58,
the
you must
lack of
answer the
control that they
following
feel in
question,
this
yes or
situation,
no.
because your life's
Did the
at
defendant
stake,
commit the crime
and
of first degree
for whatever
recklessly endangering
reason, not
safety
being
by
able to
using
help
a
yourself.
dangerous
And I
weapon?
think that this is also,
If
fight
you are
or
satisfied
flight.
beyond a reasonable
This
doubt that
is
all three
him
elements
fighting
of
for his
first
life,
degree
and the way that
recklessly
he thinks
endangering
is,
safety have
the
improved
way
as
that
to
he needs
count
to do it, and it's just
59,
not.
you
Mhm.
should find the
And
defendant
part of
guilty
that is
of
because,
first degree recklessly
when you get
endangering
involved in
safety
this
as charged in count 59.
situation, you don't
If you
have
are not so
control over the
satisfied, you
procedures and
must
stuff
find the
like that.
defendant not guilty as to
So,
count
I mean,
59.
part
If
of
you
it is
find the
obviously
defendant guilty
control
of count
issues as well.
59, you must answer the following question,
But
yes or
I
no.
agree with
And
all
that's
that. I'm
the-
just,
Did the
I'm
defendant
wondering
commit the
how
crime
much
of
is the
first
game
degree recklessly
and
Yeah.
how
endangering
much is a
safety while
condition.
using
And
a
I
dangerous
am not
weapon?
an expert. I'm
If
freely
you are
admit.
satisfied beyond a
Yeah.
reasonable doubt that all three
But
elements of
there
first
are
degree
times
recklessly
that
endangering
it
safety
seems
have
like,
improved as to
okay,
count
you
60,
did hear that though.
you
You
should find the
just said
defendant guilty of
you're
first degree
reacting to
recklessly
something that
endangering
was
safety as charged
said
in count 61.
and it's not
If you
going
are
your
not so
way. So
satisfied, you
Yeah.
must find the defendant not
there's
guilty as
definitely
to
a lot
count
there. And
60.
that's why, I
If you
look
find the
forward to having
defendant
Dr.
guilty of
Doss on
count
because
60, you
not
must
only
answer
does
the
he
following
do the
yes or
silence,
no.
but he also
Did the defendant
literally
commit the crime
diagnoses
of
people
first
in
degree
court to say
recklessly
that they
endangering
are this
safety while
condition or
using a
not that
dangerous
Yeah.
condition, and most
If you
likely
are
their
satisfied
behavior
beyond a
of that.
reasonable doubt
So
that all three
I think it
elements of first degree
could be
recklessly
eliminating.
endangering safety have improved as to count 61,
Interesting.
you
Yeah.
should
No,
find the
that'll be a
defendant
really
guilty of
interesting
first
stream.
degree recklessly
I
endangering
look
safety
forward
as
to
charged
watching
in
it.
count 61.
Well, you might
If you
even
are
be
not
there,
so
Alita.
satisfied, you must find the
It's the
defendant not
Thursday
guilty
stream.
as to
Oh,
count
it's the Thursday
61.
stream.
Yes.
Oh, so I'll
If
probably
you
be
find
there.
the defendant guilty of count
I look forward to
61, you must
asking him
answer the
questions
following
myself.
question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon?
Pin King
If you are
554.
satisfied
Thanks so much
beyond a
for the super
reasonable
chat.
doubt that all
Says,
three
what happens when
elements of
someone
first
representing
degree
themselves
recklessly
calls
endangering safety
themselves to
have
the stand as
improved
a
as to
witness?
count 62, you should
Well,
find
That
the
would be
defendant
weird.
guilty of
I'm
first degree
guessing it's a
recklessly
You get to
narrative.
endangering
testify.
safety as charged in count
It
62.
depends upon the
If you are
situation.
not so
That happens
satisfied, you must
frequently
find the
in like
defendant not
restraining
guilty as
order
to count
court and stuff like
62.
that.
If
And
you find the
frequently
defendant
when people
guilty
are
of
pro
count
se and they
62,
have to
you must answer the
testify, the
following
judge
question, yes
usually
or no.
does give them at least
Did the
some
defendant
type of
commit the crime of
direction
first degree recklessly endangering safety while
as
using
to
a
like
dangerous
where to
weapon?
start with.
If you are satisfied beyond a reasonable doubt
Yeah,
that all
yeah.
three elements of first degree recklessly
So
endangering
Natalie,
safety
and
have been
is it
proved
a
at the count
narrative?
sequence three,
Like
you should find the
you
defendant
get up
guilty
on the
of first degree
stand
recklessly
and the
endangering
person
safety as
would just
charged in count
say,
63.
I did
If you
this
are
and
not
this,
so
and then they
satisfied, you
just
must find the defendant
describe
not
through the
guilty
day,
as to count
because you're not
63.
getting
If you find the
questions.
defendant guilty of
I mean, you're
count
going to say,
63,
I
you
mean,
must
that would be
answer
very
the
weird to
following
ask yourself a
yes or
question.
no.
Was
Did the
I da da
defendant
da?
commit the
And then
crime of
answering
first
it.
degree recklessly
Would it
endangering
just be
safety while
making
using
a
Yeah.
monologue?
dangerous weapon?
I mean, with it,
If
a
you are
lot of it is a
satisfied beyond a
narrative.
reasonable doubt that all
It
three
depends
elements
upon
of first degree
context.
recklessly
Additionally,
endangering
a lot of
safety
pro
have
se
been
people are
proved as to count
nervous, so
64,
sometimes they
you
need to
should
be
find the defendant
redirected.
guilty of first degree
So that's
recklessly
kind of in the
endangering safety
context
as
that I've
charged in
been. Is
count
sometimes
64.
people will talk
If
about
you are not so
something,
satisfied,
And
you
a
must
lot of it
find the
also
defendant
is
not guilty as
informed
to
by
count
objections,
64.
things like that. 'Cause
If
when
you
you've got
find the
somebody
defendant
who's
guilty of
dealing
count
with
64, you must answer the
testifying and they don't
following
know the
question,
rules of
yes or
evidence
no.
and stuff,
Did the
I mean,
defendant commit the crime of
I, as an
first
attorney,
degree,
am not just going to let
recklessly
them
endangering
have
safety while using a
whatever they
dangerous
want
weapon?
narrative.
Yeah.
If
Just
you are
because they're pro
satisfied
se,
beyond a
I mean, I'm
reasonable
at least
doubt that
going to
all
be
three
making
elements of
polite
first degree
objections
recklessly
to the
endangering
judge,
safety have been
being
proved as to
like,
count
you know,
65, you should find the
objection,
defendant
judge, like,
guilty
could
of
you
first degree recklessly
explain
endangering
to,
safety as charged in count
you know,
65.
the other
If you are
side,
not
like,
so
that
satisfied,
they can't
you
focus
must
on this,
find the
that they need to
defendant
focus
not
on
guilty
that.
as to
And
count
it's a
65.
process, and a lot of people
If
pick
you
up
find the
on it.
defendant guilty
So
of count
it's a little bit more
65,
fluid
you
like
must
that
answer
in
the
that
following question,
situation.
yes or no.
You
Did the
know,
defendant commit the crime
I
of
don't think in
first
this
degree
situation the
recklessly
judge would
endangering safety
really,
while using a dangerous weapon?
you,
If you are satisfied beyond a
it's hard to
reasonable
tell because
doubt
I
that all
don't know if
three
I've ever
elements
actually
of first
seen it
degree
happen
recklessly
in a
endangering
criminal
safety have
case
been
that
proved as
somebody
to count
testified,
66,
like personally,
you
that
should
somebody
find the
testified
defendant
who was
guilty
pro
of first
se.
degree recklessly
Not in a
endangering
criminal
safety
case.
as
I've seen
charged
it
in
in other
count
things.
66.
But I mean,
If you are
in
not
my
so
experience,
satisfied, you must find the
pro se
defendant
people are
not
given,
guilty
you
as
know,
to count
generally a bit
66.
of lenience
If you
and
find the
assistance
defendant
in
guilty of
that.
count
Sometimes the
66,
judge
you
will
must
just
answer the
directly ask
following
them
question, yes
questions.
or no.
They'll
Did
be
the
like,
defendant commit
okay,
the
so
crime
I,
of first
you know,
degree
let's
recklessly
specifically
endangering
address
safety while
this.
using a
It really
dangerous
depends
weapon?
upon the judge you have.
Ted
If you are
Bundy did it.
satisfied beyond a reasonable
Ted
doubt
Bundy
that
did it.
all
Okay,
three
I was
elements
wondering
of
about
first
it.
degree recklessly endangering safety have been
He
proved as to count 67, you
cross-examined
should
a
find
police
the
officer and
defendant
called
guilty of
himself
first
to the
degree
witness stand
recklessly
to
endangering
testify,
safety as charged in
referencing
count
himself in the
67.
third person.
You are not so
So if I could
satisfied,
find
you
that, that
must
could be
find the
really
defendant
interesting.
not guilty as
Yeah,
to
is
count
that whole
67.
trial test
If you find the
videotaped, or I mean,
defendant
there's
guilty
at
of
least
count
probably a transcript.
67, you
So
must answer
It
the
may
following
be.
you
question,
can do a
yes
dramatic
or no.
reading.
Did the
It would be
defendant
really
commit the
interesting
crime of
to
first degree
see that one
recklessly
because,
endangering safety while
by
using a
all
dangerous
accounts, I
weapon?
think he did a good job. I think it was the judge even said, "You're a remarkable young man. I'm sorry that you took this path in life, and I sentence you to
The
die,"
defendant is charged with
or
6
something like
separate
that.
counts of violating a duty after having been involved in an accident resulting in death. The 68th count of the information in this case charges that
68th
Darrell E.
count.
Brooks,
We're getting
on or
close to
about Sunday,
77.
November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Virginia Sorensen and failed to reasonably investigate what was struck, and if the
So this is one of
operator
the hit and
knew or
run
had reason to know that the
counts.
accident resulted in injury or death of a person and failed
So
to
we
stop
are
the
we are
vehicle he was
past
operating as
the
close
recklessly
to the scene of the
endangering
accident
safety
as
with a dangerous
possible
weapon
and
counts,
remain at the scene of the
which there were
accident
61 of
until
those.
he did all of the following: give his name, address, and the registration number of the vehicle he
Wow.
was operating to the operator or
Secret
occupant
McSquirrel.
of or
Thanks
person
for the super
attending
chat.
any vehicle
Ask AG
collided
Tutor.
with,
Yeah.
and upon request and if available, exhibit his operator's license to the operator or occupant or of or person attending
If it is
any vehicle
televised,
collided
Alita,
with,
you will have to go over the Bundy trial for your
and
show.
render reasonable assistance to any
Yeah.
person injured in
Yeah,
the
That's a big
accident,
one.
Yeah.
including
Yeah,
transporting or
that
making
is
arrangements to
that is definitely a
transport the
big one
person
to
to
go
a
through for
physician,
classic trials. Yeah.
surgeon, or hospital for
If
medical or
you end
surgical
up doing
treatment
Richard Ramirez,
if
let
it
me
is
know
apparent
because our jury consultant was the same one
that
for
medical or
Ramirez.
surgical treatment is
Ooh.
So,
necessary
and she's very nice.
or if
Interesting.
requested by the
Okay.
injured person,
Oh, I found it.
contrary
Ted
to
Bundy takes stand.
Section 346.67 sub 1 and 346.74 sub 5 sub D and 939.50 sub 3 sub D of the Wisconsin statutes.
Boom.
This is a lot of reading.
The 69th count of the information in this case
69th
charges
count.
that
Okay.
Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the
I
death
think
of
I'd seen
man
someone ask earlier about the
failed
reading
to
of the jury
reasonably
instructions
investigate what was
before
struck,
closings.
Mhm.
At
and
least
if
in
the operator
Wisconsin,
knew
that's
or had reason
very
to know
specific
that
on
the
the
accident
court.
resulted
Is
in
some
injury or
people,
death
some
of a
judges want to
person
do it beforehand, some judges
and failed to stop the
don't. Usually
vehicle
the
he was
judges will ask the
operating as
parties
close
if
to
they
the scene of
want
the
them
accident
read
as
before or
possible
after
and remain at
closings.
the scene of the
Oh.
accident until he did
So,
all of the following.
It kind of depends
His
upon the thing.
name,
I mean,
address, and the registration number of the vehicle he was operating.
sometimes
the
I think it's helpful
operator
for them to have it read
occupant
first
of
because it
or
like reorients them as to
attending
the
any
case
vehicle
and the
collided with,
you know, the
and
elements and
upon
things
request
beforehand.
if available,
Yeah.
exhibit his
It depends
operator's
upon,
license
you know,
to the
defense
operator
strategy
or
as well.
occupant of
Is if you want to
or person
downplay
attending
something like that,
any
you might want
vehicle
it to be done
collided
after the
with,
fact.
and
Because after the
render
closing, people
reasonable
aren't going to be
assistance
paying
to
as much
any
attention
person
to the
injured
jury
in the
instructions.
accident,
They're going to be
including
Right.
thinking and digesting
transporting or
information.
making arrangements to
Right.
transport the
So
person
yeah,
to
I
a
mean,
physician,
every time
surgeon,
that
or
I
hospital
had
for medical or
seen it,
surgical
jury
treatment
instructions were
if
read
it is apparent
before
that medical
closing
or surgical
arguments.
treatment is necessary,
And
or
my
if
understanding was that
requested by the injured
it's
person,
helpful so that you don't have to
contrary
go
to
through
section
any of that in your closing
346.67
arguments.
sub 1,
Yeah, I mean,
346.74
that it
sub
depends. That's something that is also, I think, a matter of
939.50
preference. Like
sub 3
Mark, for
sub D
example,
of
my
the
boss,
Wisconsin
always prefers
statute.
to do jury instructions
The
afterwards
70th
because then he's just
count
done.
of the information in this
Yeah,
case charges
that makes sense.
Darrell E. Brooks,
That makes
So
sense.
on or about Sunday,
they,
November
at least in
21,
Wisconsin, they usually
2021,
like
on Main
ask
Street in the
people
city
how
of
they want to do it.
Waukesha County,
Fair enough.
Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Tamara Durand and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person and failed to stop the vehicle he was operating as close
Well,
to the
Alita,
scene
I got to
of
get
the
back to the
accident
day
as
job.
possible,
All
I'll
right.
get it shown.
Eric, thanks so
Thank you
much for
so
coming
much.
and hanging out for a bit.
He did
Thank you.
all of the following.
Yeah, see you
Give his
later.
name, address, and the
Bye, Eric.
registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle
I'm going to be
collided
popping in and out, Alita. I just have to like
Sure.
actually
Render
focus on what I'm
reasonable
doing for like 10
assistance.
minutes.
Oh yeah,
I'll be back.
yeah, no
any
worries.
person injured in the accident, including transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or if requested by the injured person, contrary to sections 346.67 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The 71st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Jane Kulik and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person, and failed to stop the vehicle he was operating as close to the scene of the accident as possible and remain at the scene of the
Also,
accident
Alita,
until
do
he
you want me
did
to
all of the
message
following.
you the pattern jury
Give his
instructions
name,
at all? They've
address,
got
and the
comments and
registration
stuff
number
that
of the
people actually
vehicle he
Oh.
was
look at
operating
them.
to the
I'll message
operator
you a
or
link to
occupant
those.
of
Yeah,
the
thank you.
person attending any vehicle collided
I
with,
mean, it's
and
going to at
upon
least take them a
request
while
and
to fill out
available,
the
exhibit
forms.
his operator's
So
license
Yeah,
to the
that's why
operator
we
or
have a
occupant
poll in the
of or
chat, which
person
maybe I
attending
should close by
any
now.
vehicle collided with,
But asking
and
how
render
long people
reasonable
think that it's
assistance
going to
to any
take
person
for them to
injured in
return a
the
verdict.
accident,
Looks
yeah,
like the
I'll-
majority is 1 to
transporting
3
or
hours.
making arrangements
yeah,
to
I'll message
transport the
you
person
those jury
to a
instructions.
physician,
Cool,
surgeon,
thanks.
or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or if requested by the injured person, contrary to sections 346.67 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The 72nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Wilhelm Hospital and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person and failed to stop the vehicle he was operating as close to the scene of the accident as possible and remain at the scene of the accident until he did all of the following. Give his name, address, and the registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with, and render reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or if requested by the injured person, contrary to sections 346.67 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The 73rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Jackson Sparks and failed to reasonably investigate what was struck and if the operator knew or had reason to know that the accident resulted in injury or death of a person and failed to stop the vehicle he was operating as close to the scene of the accident as possible and remain at the scene of the accident until he did all of the following: give his name, address, and the registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with and render reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or if requested by the injured person, contrary to sections 346.67 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The defendant has entered a plea of not guilty to each of these charges, which means the state must prove every element of each offense charge beyond a reasonable doubt. Section 346.67 of the Wisconsin statutes, commonly referred to as hit and run, is violated when the operator of any vehicle involved in an accident on a highway fails to reasonably investigate what was struck, and if the operator knows or has reason to know that the accident resulted in death of a person, fails to stop the vehicle he is operating as close to the scene of the accident as possible and remain at the scene of the accident until the operator has given information and rendered reasonable assistance to any person injured in the accident. Before you may find the defendant guilty of any count of hit and run, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following four elements were present with respect to that count. 1, as to each count, the defendant operated a vehicle involved in an accident on a highway. A vehicle is operated when it is set in motion. 2, as to each count, the defendant knew that the vehicle he operated was involved in an accident on a highway. 3, as to each count, the defendant violated a duty after being involved in an accident. A driver who is involved in an accident has two duties. The state is required to satisfy you beyond a reasonable doubt that the defendant violated at least one of the two duties, but you are not required to agree as to which duty was violated. The first duty is to reasonably investigate what was struck. The second duty is that a driver involved in an accident involving a person must stop and provide information and render aid. To prove a violation of this duty, the state must prove the following beyond a reasonable doubt: that the defendant knew or had reason to know that the vehicle he was operating was involved in an accident involving a person, and that the accident resulted in death of a person, and that the defendant did not immediately stop his vehicle as close to the scene of the accident as possible and remain at the scene until he had done all of the following: A, give his name, address, and the registration number of the vehicle he was driving to the person struck, and B, if it was requested and was available, exhibit his operator's license to the person struck, and C, rendered reasonable assistance to any person injured in the accident, including the transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or is requested by the injured person. 4, the defendant was physically capable of complying with these requirements. You cannot look into a person's mind to find knowledge. What a person knows or has reason to know must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon knowledge. The information alleges not only that the defendant committed the crimes of hit and run, but also that the accident resulted in the death to a person. If you find the defendant guilty of a count of hit and run, you must answer the following question, yes or no. Did the accident involve death to a person? Before you may answer yes, you must be satisfied beyond a reasonable doubt that the answer to that question is yes. If you are not so satisfied, you must answer the question no. If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 68, you should find the defendant guilty of hit and run as charged in count 68. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Virginia Sorensen? If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 69, you should find the defendant guilty of hit and run as charged in count 69. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Leanna Owen? If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 70, you should find the defendant guilty of hit and run as charged in count 70. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no.
This behavior
Did the
just reinforces that it was a good idea
death
to keep him in this
Tamara
other room.
Durand? And I will specifically address Mr. Brooks at a later point. Count 71. If you are satisfied beyond a reasonable
Basically,
doubt
she
that
just said,
all 4
yes,
elements
I
of
see
hit
you
and
there,
run have been proved
and no,
as to count
I'm not answering
68,
you. Whatever
you
request
should
you
find the
have.
defendant guilty of hit and run as charged in count 68. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Jane Kulik? If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 72, you should find the defendant guilty of hit and run as charged in count 72. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Wilhelm Hospital? If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 73, you should find the defendant guilty of hit and run as charged in count 73. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Jackson Sparks? The defendant is charged with 2 separate counts of bail jumping. The 74th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, having been charged with a felony and having been released from custody under Chapter 969 of the Wisconsin statutes, did intentionally fail to comply with the terms of his bond, contrary to Section 946.49 sub 1 sub B and 939.50 sub 3 sub H of the Wisconsin statutes. The 75th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, having been charged with a felony and having been released from custody under Chapter 969 of the Wisconsin statutes, did intentionally fail to comply with the terms of his bond, contrary to Sections 946.49 sub 1 sub B and 939.50 sub 3 sub H of the Wisconsin statutes. Bail jumping, as defined in Section 946.49 sub 1 of the Criminal Code of Wisconsin, is committed by
It
one
reminds me
who
of
has
those
been
people that'll
released
sit
from
behind home
custody
plate
on bond
in a baseball
and
game,
intentionally
and they'll like
fail to
start doing
comply
crazy
with the
things to
terms
try to
of the
distract the
bond.
pitcher. Like that's
Before
literally
you may
what he's
find the
doing here.
defendant guilty of any count of bail jumping, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present with respect to that count. 1, as to each count, the defendant was charged with a felony. A felony is a crime punishable by imprisonment in the Wisconsin state prisons. 2, as to each count, the defendant was released from custody on bond. This requires that after being charged, the defendant was released from custody on, bond under conditions established by a court commissioner. 3, as to each count, the defendant intentionally failed to comply with the terms of his bond. This requires that the defendant had the mental purpose to fail to comply with the terms of his bond. This also requires that the defendant knew of the terms of the bond and knew that his actions did not comply with those terms. The defendant is charged with violating a condition of bond that required that he not commit any crime. The state alleges that the defendant committed the crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, hit and run, resulting in death, and battery. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant committed the crime of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, hit and run resulting in death, or battery. The state is required to satisfy you beyond a reasonable doubt that the defendant committed a crime, but you are not required to agree on which one. The crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, and hit and run resulting in death have already been defined for you, and you should apply the same definition here. Battery will be defined in just a bit, and you should apply that definition here as well. You cannot look into a person's mind to find intent or knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent and knowledge. If you are satisfied beyond a reasonable doubt that all three elements of bail jumping have been proved as to count 74, you should find the defendant guilty of bail jumping as charged in count 74. If you are not so satisfied, you must find the defendant not guilty as to count 74. If you are satisfied beyond a reasonable doubt that all three elements of bail jumping have been proved as to count 75, you should find the defendant guilty of bail jumping as charged in count 75. If you are not so
Count
satisfied,
75,
you must find the
bail jumping.
defendant not guilty as to count 75. The 76th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, near Frame Park in the city of Waukesha County, Wisconsin, did cause bodily harm to Erica Patterson by an act done with intent to cause bodily harm to that person without that person's consent, contrary to section 940.19 sub 1, 939.51 sub 3 sub A, and 968.075 sub 1 sub A of the Wisconsin statutes. Battery, as defined in section 940.19 sub 1 of the Criminal Code of Wisconsin, is committed by one who causes bodily harm to another by an act done with intent to cause bodily harm to that person or another without the consent of the person so harmed. Before you may find the defendant guilty of battery, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 4 elements were present. 1, the defendant caused bodily harm to Erica Patterson. Cause means that the defendant's act was a substantial factor in producing the bodily harm. Bodily harm means physical pain or injury, illness, or any impairment of physical condition. 2, the defendant intended to cause bodily harm to Erica Patterson. Intent to cause bodily harm means that the defendant had the mental
domestic
purpose to
violence
cause bodily harm
charge.
to another human being or was aware that his conduct was practically certain to cause bodily harm to another human being. 3, the defendant caused bodily harm without the consent of Erica Patterson. 4, the defendant knew that Erica Patterson did not consent. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent and knowledge. If you are satisfied
Stephen
beyond a
Yarger, thanks
reasonable
for the
doubt
super
that all
chat.
4 elements
I kept
of
trying to
battery
join,
have
but
been proved, you should
everyone
find the
keeps telling me
defendant
the first
guilty.
rule is you don't talk about
If
fight
you are
club,
not
so I don't know how.
satisfied, you must
There's a
find
link
the
in the
defendant
description. If
not
you're watching on
guilty.
a desktop too, there should be a join button right by where you can subscribe. But otherwise, in the description of this
I
video,
wanna
there's a
go
link
back
to
the
join as
bail
well.
jumping,
If you're interested, but funny joke.
because the battery is not part of that charge. And there's an inclusion of that in the jury instruction that I will have corrected. So I'm going to read the definition, the substantive instruction on bail jumping once again, starting with what the charges are. Well, the charges I've already read, they will stand. So bail jumping, as defined in section 946.49 sub 1 of the Criminal Code of Wisconsin, is committed by one who has been released from custody on bond and intentionally fails to comply with the terms of that bond. Before you may find the defendant guilty of any count of bail jumping, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 3 elements were present with respect to that count. 1, as to each count, the defendant was charged with a felony. A felony is a crime punishable by imprisonment in the Wisconsin state prisons. 2, as to each count, the defendant was released from custody on bond. This requires that after being charged, the defendant was released from custody on bond under conditions established by a court commissioner. 3, as to each count, the defendant intentionally failed to comply with the terms of the bond. This requires that the defendant had the mental purpose to comply with the terms of the bond. This also requires that the defendant knew of the terms of the bond and knew that his actions did not comply with those terms. The defendant is charged with violating a condition of bond that required that he not commit any crime. The state alleges that the defendant committed the crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, and hit and run resulting in death. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant committed the crime of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, or hit and run resulting in death. The state is required to satisfy you beyond a reasonable doubt that the defendant committed a crime, but you are not required to agree on which one. The crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, and hit and run resulting in death have already been defined for you, and you should apply the same definitions here. You cannot look into a person's mind to find intent or knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that all three elements of bail jumping have been proved as to count 74, you should find the defendant guilty of bail jumping as charged in count 74. If you are not so satisfied, you must find the defendant not guilty as to count 74. If you are satisfied beyond a reasonable doubt that all three elements of bail jumping have been proved as to count 75, you should find the defendant guilty of bail jumping as charged in count 75. If you are not so satisfied, you must find the defendant not guilty as to count 75. Thank you. Mm-hmm. An information is nothing more than a written formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. The defendant has a constitutional right to represent himself. I have advised the defendant that the same rules apply whether a lawyer acts for him or he acts for himself. The defendant has decided to represent himself, and this decision must not influence your verdict in any manner. At times, Mr. Brooks has appeared from another courtroom. This must not influence your verdict in any way. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt.
I'm glad you appreciate it.
For the truth.
I tweeted out a nice little meme.
The defendant is an issue in this case,
ago.
And you should give it your careful attention. You should consider the reliability of any identification made by a witness, whether made in or out of court. You should consider the credibility of a witness making an identification of the defendant in the same way you consider credibility of any other witness. No, I don't think that the jury can see him. Identification evidence involves an expression of belief or impression by the witness. Its value depends on the opportunity the witness had to observe the offender at the time of the offense and later to make a reliable identification. Consider the witness's opportunity for observation, how long the observation lasted, how close the witness was, the lighting, the mental state of the witness at the time, the physical ability of the witness to see and hear the event, and any other circumstances of the observation. You should also consider the period of time which elapsed between the witness's observation and the identification of the defendant, and any intervening event which may have affected or influenced the identification. In evaluating the identification evidence, you are to consider those factors which might affect human perception and memory, and all the influences and circumstances relating to the identification. Then give the evidence the weight you believe it should receive. If you find that the crime alleged was committed, before you may find the defendant guilty, you must be satisfied beyond a reasonable doubt that the defendant is the person who committed the crime. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. It is not necessary
Grant
that every
McRoberts,
fact
thanks
be
so much
proved
for your super
directly by
chat.
a
Who
witness
was the plaintiff in
or
this
an
trial? It's
exhibit.
actually, because it's a criminal
A fact
case,
may be
it's
proved
the state of
indirectly by
Wisconsin.
circumstantial
So
evidence.
that's the
Circumstantial
they are
evidence
prosecuting
is
this
evidence
case
from which a jury may
against
logically find
Darrell
other
Brooks.
facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the
Oh, that was
defendant's
a joke.
conduct after the alleged crime
referring
was
to
committed.
what he keeps saying.
Whether
Okay,
the
never mind.
evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe deserves under all of the circumstances. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received as evidence whether or not it goes to the jury room. Parties for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of parties, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. During the trial, the court has ordered certain testimony to be stricken. Disregard all stricken testimony. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony
Yeah.
of one witness
Cheryl
is
C.
entitled to
And
greater
also
weight
all
than
of
that
the
any other
antics
witness,
that have played
than
out
that
throughout
of
this
another
trial.
witness or even of several other witnesses. Remarks of the parties are not evidence. If the remarks suggested certain facts not in evidence, disregard the suggestion. In weighing the evidence, you may take into
Annie
account
Mae
matters
Wholesale, her
of your
name is
common
Indy,
knowledge
like
and your
Indiana Jones.
observations and experience in the affairs of life.
Exactly.
It is the duty of the
Exactly.
jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given
That's
to
exactly
their
why we named her
testimony.
that.
In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same here. Evidence has been received that 2 of the witnesses in this trial have been convicted of a crime. This evidence was received solely because it bears upon the witness's character for truthfulness. It must not be used for any other purpose. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the
Indy's
witness,
definitely staring
the
at me
facts
because she
upon
wants
which
my
the
food.
opinion is based,
The food
and
that
the
I haven't
reasons
finished.
given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon
Kurt
which
P, thanks for your super chat.
it is based have
No
been
magic
proved.
ways. Why don't
If
they
you
allow
find
magic
that the
ways in this
facts stated
case?
in the hypothetical question
Sorry,
have
no
not been
sorcery
proved,
allowed.
then the opinion based on those facts should not be given any weight. At this time, I will reserve the instruction on closing arguments because we are going to take our lunch break and then come back after the lunch
Okay.
hour for closing arguments. All rise for the jury.
Okay. Indy is a strong, independent woman. So, okay, so now we've got the lunch break. So, all right, sound is off for the jury to leave.
All right, thank you. Be seated. As soon as the doors close, I just need to put a couple things on the record.
Yep.
As I read, the doors closed, right? There we go. As I read through the bail jumping, it dawned on me that the battery should not be referenced because the battery was not on Main Street. And so I took it out because the way that the charge and the information reads, and we had that discussion preliminarily, which is why later on it doesn't reference the instruction for battery. So I cleaned that up by rereading it and taking that out. So I wanted to make
Expect
a record
him to fight
of
over this.
that. Obviously, I will need to have a new set made that has that correction. And I apologize for not catching that previously. But obviously, I caught that as I read it. There was one other heading that said preliminary on, I think it was instruction 70. I need to cross that out. And I think I found the word a or depending on how you say it, missing from one thing. I'm going to add that in, and I'll have that for the parties. And then I did note that at approximately 12:19, it may have been a little bit earlier than that, but I noticed Mr. Brooks was waving his hands. At one point, I did indicate I would address that at a later point in time. I am aware of a number of filings. I addressed 2 of them previously, but there are 2 additional. I am going to have copies made of all of these filings for the state so that they have an opportunity to review them. From my perspective, just briefly, he's making some objections to what I am doing, but at no time in those did he ask to be brought back to the courtroom. And certainly within those, he did not pledge to follow the basic tenets of courtesy and decorum. Given where I was at in the proceedings with the reading of the preliminary instructions, and given the court's prior finding that he had forfeited his right to be present, I thought it important to get through the reading of the instructions up until the point of the closing argument instruction, which I reserved because I'll review that with the jury when they come back, prior to the parties being given their opportunity to give closing arguments. I will also be advising Mr. Brooks that given that I'm moving on to a second part of this, that being the closing arguments, he will be invited back into the courtroom here for those closing arguments, of course, subject to his conduct. I expect that he will follow the rules of courtesy and decorum.
Yeah, she's definitely going to be giving him multiple
and
opportunities to be in the
also
courtroom
not
for
raise
this.
legal issues in front of the jury when they are here. With that, we will take our lunch recess. It's 12:47. We'll take an hour and 15 minutes. Thank you, everyone.
Okay.
Copies of all of these.
All right. So we've got a lunch break that is going to be a while. She either said an hour or an hour and a half. I admit I wasn't fully paying attention at that point. She probably said an hour and a half. So it's going to be a while. We can review. I have some other stuff that we can review. We can kind of go through some stuff that he's done in the trial so far, just to go through some of these issues that have come up before. And 2 p.m. she said. Oh, okay. It's 1 hour and 15 minutes. Okay. So then that's fine. That makes sense. Thanks, chat. So I did mention that I put a tweet out. I'll share with you guys just because not everybody here has Twitter, but so Darrell Brooks is in the other room right now trying to get the attention of Judge Doro while she tirelessly reads jury instructions. But this is what I keep seeing when he waves with full wingspan. So this is yeah. I was pretty proud of this one. But anyway, that's neither here nor there. So basically, this is yeah, we've gone through the jury instructions, a lot of them. Like I said, it does get repetitive, but as we were saying earlier, this is also a good reminder of just how much damage that he caused in this whole thing, right? Because there were so many people who were either killed or injured or harmed in some other way. You know, we're talking about real people whose lives were absolutely impacted. And it's one of those things that we could lose sight of from time to time because of these crazy courtroom antics, you know, like him waving in the background, making box forts, all this kind of like just crazy stuff that he's been doing in the courtroom, making an absolute joke out of all of these proceedings, when in fact, you know, we do want to remember that these obviously are for very serious claims and charges and whatnot. So yeah. It's been been quite a day, and I've only started live streaming this trial today, and I can already see how this is just absolutely frustrating, and that this judge absolutely has been dealing with this with so much patience. Here's a question. Jonathan Anderson says, what could DB say that would mess things up for the jury at this point? I don't know that he could say or do much of anything to make things any worse for himself. But I do understand from the judge's perspective that she still wants to do everything that she can to kind of prevent him from himself, like save him from himself, so to speak. And I totally forgot that the video was going to go into like another commercial or whatever, and it just was really loud in my ear. So yes, so I understand from the judge's perspective that she's going to want to do everything that she can to maintain, you know, his best possible alternative within the confines of what she can do and what she should do, right? So, yeah. Yep. Yeah, Shireen, now you know what we've all been talking about. Yeah, I know. It's absolutely maddening. Here's also a few questions from earlier that I was saving that was coming up. Oh, and then also I'll save one of these about jury nullification too. So we can talk about that as well. So Tally says, is it important if he meant to kill a person versus a specific person? Like, is intent different if you go out to just kill someone versus going out to kill your ex? No. So there is such a thing. So first off, he didn't even necessarily have to have a specific person in mind to kill. If he just did something that he knew what the result was going to be and he did it anyway, that is going to be enough. But there also is something called transferred intent. So let's say he was targeting a specific individual. He ended up not killing that specific individual, but someone next to them. There is a concept in the law called transferred intent, where essentially you're charged with killing that person as if you had that specific motive to kill them anyway. So, yeah. It's an interesting law school problem that most law students come upon at some point. John Boy 79er says, does any of these antics give him further legal actions on appeal? No, because he's the one that's doing it to himself. And the judge is trying to give every possible reasonable alternative for not hanging himself, essentially, so to speak. Robert Havens, thanks so much for your super chat, says, does this give us a glimpse into how difficult it is for defense attorneys dealing with their clients? Yeah, it does. Now, not every client is going to be like this. Not every defense, the criminal defense or criminal defendant client is going to be like this. But you get some very, very, very strange people in criminal law and in a lot of different areas of law, to be honest. You can definitely run into some very strange people. HWS, sun's starting to come up. I got to go to bed. Well, thanks so much for the super chat, and thanks for hanging out with us and for watching with us. But yeah, definitely get some rest if you can. But definitely appreciate you hanging out with us. Jonathan Anderson also says, how does the recorder record the back and forth between the judge and he who does not stop talking? So the stenographer or the court reporter, that is a very difficult task. And this is why anytime a witness gets put on the stand, it's usually there's some sort of a statement that's made along those lines where the attorney that's directing, or maybe the judge or someone will usually kind of make sure that the witness remembers, hey, just so you know, try not to talk over me. I'll try not to talk over you, because it's all about the court reporter here they have to get a clean record here. And then sometimes when they do start to talk over one another, they will kind of pause them for the court reporter until the court reporter says like, okay, I'm caught up or what have you. Now, obviously that's a bit more difficult when we're talking about the criminal defendant who's representing himself and the judge getting engaged into that kind of back and forth. It's just, I don't know. It's a monumental task in a case like this. And this court reporter has been doing yeoman's work in this case for sure. Against the Tide says jury nullification, legal bias. He brought it up yesterday. Yes. So he did bring it up yesterday. So jury nullification. You know what? Let me just bring this up here from Cornell Law School. This is a good explanation for you guys. I like bringing these up from time to time because this website is pretty decent about explaining these things. So jury nullification refers to a jury's knowing and deliberate rejection of the evidence or refusal to apply the law, either because the jury wants to send a message about some social issue that is larger than the case itself, or because the result dictated by law is contrary to the jury's sense of justice, morality, or fairness. Essentially, with jury nullification, the jury returns a not guilty verdict, even if jurors believe beyond a reasonable doubt that the defendant broke the law. This can occur because a not guilty verdict cannot be overturned, and jurors are protected regardless of their verdicts. So I don't know. I can't remember exactly what he's been saying about jury nullification, but essentially jury nullification, that situation would be something that would help him in this case. So that wouldn't be a reason for him to argue for appeal, right? Because that would be a situation where there is overwhelming evidence that he did it and that he's guilty, and that the jury comes back and says, I don't want to convict him because of other reasons. Some people talk about the O.J. Simpson trial and say that was jury nullification, to say that was sort of like a reparation of sorts for other wrongs that were committed in the community. So that's one that people will sometimes point to as an example. But it'll be interesting to see what, if anything, he says about jury nullification in his closing arguments. So, okay. Trinity Valley North Central, thanks so much for the super chat. Really appreciate that. Lewis Zero says, how does this play in future sovereign citizen trials or in reviews, do you think? I'm afraid of others trying these tactics to attack the law and court system. I mean, these type of individuals, they come up from time to time, right? Because it's you can, every once in a while, someone will pop up around social media or around the courts. But I don't know. I mean, he's not the first one to make these kinds of arguments. And as people were saying in the chat earlier, it sounds like he actually learned of the sovereign citizen argument while in jail after being arrested for this case. So I think that this definitely could increase the popularity of these kinds of arguments for people that want to try them. I don't see them being ultimately successful because as anyone that's reasonable that is watching this case can see, he's very likely making the prosecution's case a bit easier in this case. He's not making himself look any better. He's making all kinds of arguments. I mean, granted, even if he was just making those arguments at various stages, while representing himself, but being more respectful of the court, I don't know. Maybe things would go a bit differently. But as Natalie was saying earlier, Natalie Wisco, she was on here. She was saying that she represented someone who was a sovereign citizen client, or she was essentially a backup reserve attorney for this individual who had decided to represent himself. She said that, she advised him that, you can make that argument, but you need to have a backup argument after that. What is your backup argument? Because that is an argument for a different venue. So, that's not something that you can really argue at this specific stage, because that's just not the stage at which those kinds of arguments are made. Because that's a legal argument, not a factual argument. So I definitely get your concern about, others trying these tactics to attack the law and the court system and whatnot. And yeah, I mean, it definitely would be very frustrating to the entire process to see this now become a popular thing. Hopefully this continues to be just more of a rarity, and it doesn't really pick up steam. That's my greatest hope. But yeah. So, all right. Trinity Valley North Central is saying, I don't understand over and over carry any weight for appeal. Not as far as I can tell. Because the way that he sort of weaseled out of agreeing that he was admitting to understanding something, he would still, it seems like that was a very specific magical buzzword that he didn't want to use. But then, when Judge Dora would say, like, is it clear to you that XYZ, then he would say, yeah, that's clear. So it just seems like this is like a very specific buzzword that people who ascribe to these kinds of arguments don't particularly like. So let me give an example. Okay, let's pull up. Okay. Let's see here. We can pull this up here. Give me just 1 second. Okay, hang on. Okay. All right. Talk amongst yourselves. All right. Okay. So let's watch this. This is when he decided that he wanted to represent himself, and she eventually allowed him to. Let me first get the super chat. Kurt P, thanks so much for your super chat. It says, one of this guy's many problems is he keeps wanting to play dumb and not understand, but he also clearly thinks he's the smartest person to ever live. This is very frustrating. Yes, I'm with you on that, because you can't exactly have it both ways. Yeah. So, okay. So listen to, we're going to watch this. We're going to go through it, and then, kind of listen to what he says, talking about saying, I don't understand. But yeah, as Hezo One says, it turned into, I'm aware. Are you aware? So it's these kinds of things that you can lay the breadcrumbs down for someone to follow, so that they can indicate that they basically understand what you're saying, even if they don't want to use the magic buzzwords. So, okay.
Something to the effect that it was their opinion that Mr. Brooks reasonably understood with reasonable accuracy why the evaluators were there, the limitations of the confidentiality associated with that even during those evaluations, if he was being difficult, that he was nonetheless
Sorry,
able
guys.
to communicate.
This is not the one that I wanted to do. Sorry. Okay, hang on. This is the one. Okay. All right. Okay. 1 minute. Okay, here we go. Here we go. Okay.
And that which shall appear to the state of Wisconsin.
Okay.
Anna Keys and Jeremy Perry appear on behalf of Darrell Brooks, who's also present. Good afternoon.
Right, good afternoon. We are here today to address the motion that was filed by attorneys Perry and Keys last week, the motion to withdraw. I do want to make a brief record that I met with the parties, the attorneys only at 12:30 today, just to go over what I would call some scheduling, housekeeping matters related to this case and the motion before the court.
Yeah, Ms. Amanda, that sounds
I
about
don't believe I need to
correct.
put any of the substance of that on the record unless there is a request from either of the parties. I do not intend to go over any of the substantive issues that are remaining in this case, other than the motion to withdraw. That includes the various filings that the parties have made and any other open issues that we have at this time. I need to first address the issue with Mr. Brooks and the motion to withdraw. I do want to start out with you, Mr. Brooks, and ask you, is it your desire to represent yourself in this case?
It is, I would like to proceed in this matter, prior persona, not pro se.
Say that last part again.
I would like to proceed in this matter in pro per, not pro se.
So you're going to have to tell me what you think that means.
It
That's a
is
very
me
good-
exercising my right to defend myself, to represent myself as a sovereign citizen. So essentially, this matter today would be me appearing by special appearance.
You have an absolute right to have an attorney represent you. It is protected not only by the Wisconsin Constitution, but the United States Constitution. Do you understand that?
I do understand my rights under the United States Constitution, yes.
Did you hear what I said?
Repeat it.
Do you understand that you have the right to have an attorney represent you, what we call the right to counsel?
Under the Sixth Amendment, correct?
Under the Sixth Amendment, the 14th Amendment, and the Wisconsin Constitution as well. It's a well-established right that a criminal defendant has. Do you understand that?
I'm aware, yes.
So yeah, he doesn't want to use the word understand. And as Ms. Amanda said this is a very, I want to bring this up again because this is a very common thing with SovSits apparently. She says SovSits twist words to mean what they wish to make it fit their purpose. I have connections with SovSits. I live near Seattle where there's a huge group of them. But from what I have experienced with SovSits, Brooks makes dumb errors that even SovSits shake their heads at. I believe he jumped on the SovSit bandwagon without fully knowing how it works. That could be as well. Also, folks coming in from Emily D. Baker's chat, welcome. Happy to have you here. We are, I mean, I'm sure you're aware if you are coming from her live stream, there's a long lunch break for an hour and 15 minutes. So we've got another probably 45 minutes. So what we're doing right now is kind of reviewing some of the other things that have happened in this trial and kind of going through it. So, you know, this is specifically right now, this is when he decided to forego the representation by counsel and represent himself. And this is the actual interaction that he had with Judge Darrell to ensure that he understood what it was that he was doing by foregoing that representation and instead by representing himself.
Do you also understand that you have the right to represent yourself?
I'm aware of that as well.
I have before me a motion to withdraw by your attorneys with the sole basis that is listed that you want to represent yourself. Is that your understanding as well?
That isn't entirely how the issue came about. I think it's important for that to be on record.
I'm not asking you to divulge attorney-client privileged information. Do you understand that?
So essentially, what's the question?
Well, I want to make sure you understand you have these competing rights. It is
Competing rights.
recognized in our case law from the United States Supreme Court, the Wisconsin Supreme Court, that there are these competing rights: the right to counsel and the right to self-representation, essentially to be your own counsel. Do you understand these competing rights?
I am aware.
Do you understand, sir, that you can't have an attorney and exercise that right and also exercise the right of self-representation?
No, I don't understand that.
So you started off this hearing by saying you want to exercise this right to appear in persona today and act as a sovereign citizen. Sir, my concern here today is there's a request from your attorneys to withdraw from this case. Do you understand that's the request before me today?
I'm aware that they filed a motion to withdraw, yes.
And are you aware, let me back up. Have you seen that motion, sir, the written motion?
I have seen it.
Did they give you a copy, the paper copy?
I believe it was delivered to me in the jail.
Right, do you have that in front of you today?
No, I do not.
Madam Clerk, why don't you print off a copy and we'll give it to him.
That way she's ensuring that he has seen it. He's had an opportunity to review it. Therefore, there's
that.
nothing lost on him.
We have an extra copy over.
Well, it looks like Attorney Perry has put that in front of Mr. Brooks, along with the court is providing another copy. Mr. Brooks, can you acknowledge for me that you have a written copy of the motion to withdraw now in front of you?
Yeah, this is a motion to withdraw.
Are you able to read that on your own, sir?
Yes.
Have you read it?
Now he's looking at it. I'm going to pause real quick for just a second. What's left of the judge's sanity says, I'm struck by how much knowledge and expertise even a relatively weak lawyer really has. Brooks makes Elaine Bredehoff look like a wizard. He certainly does. He certainly does. There is quite a bit of process that goes into any trial that really just doesn't really get detected on the radar for most people, just because things usually move relatively seamlessly. And it's when you have someone like Darrell Brooks come in and sort of bumble his way through the trial. Bumbling really isn't even a very accurate word. He's more like a bull in a china shop, really. But you know, when that does happen, that does become a bit more apparent, right? That there are certain skills and certain things that are required. Okay, so now he's reviewing. And I feel like his attorneys right now are just like, please just allow him to represent himself. We don't
As
want to
of
have to
now,
deal
I
with him
have-
anymore.
Do you understand what's in that motion?
Do you understand what's in that motion?
Yes, I'm aware of what's in the motion.
I'm
yes.
aware of what's
Is
in
there
that
anything
motion.
about that motion you do not understand?
I'm aware. I'm aware of it.
My question is, do you understand?
I'm aware.
Do you understand what it says, sir?
Fair. Oh, Kurt wants to join? Oh, shoot. Yeah, I can send him a link.
It's clear to me what it says.
All right.
I assumed that
So
he
let me
was
start off
still doing his own.
again by asking you,
Hang on.
do you wish to represent yourself in this case?
Yes, I do.
Before, I'm sorry, go ahead.
I would like to represent myself pro per.
What does that mean to you, sir? Explain to me that
Again.
request.
Again, because I've already said it on record, to represent myself as a sovereign.
All right. Hang on. Hey, Nate, how's it going?
It's going okay. How you doing?
Doing all right. Just we're I'm sure we're on a lunch break in the crazy Darrell Brooks trial. So yeah. I mean, have you been watching too?
I've been watching, and I went because I've been going around. Everybody's streaming this, so I was going around just saying hi to everybody. And next thing I'm over there on Uncivil stream, and he's doing like $100 a shot. So I'm like, all right, so I'm joking. I'm like, $200. If somebody gets $200, I'll take a shot. So I said that on stream, and immediately $200 popped. So I'm like, really? I'm like, I didn't even get the chance to say I was joking. So we had to take a shot. So I ran the hell out of there because I'm like, I'm not taking any more shots. So.
Well, okay. I mean, then this is not true. Anonymous, thanks for the
Nate will
super
take
chat. Nate will take a shot today for every $100 earned in super chat.
No. That was an accident that happened over there. But you know what? I'll be fair. If one comes, if for today for you, if 100 comes in while I'm here, I'll do one shot. But I'll do one. But I don't know why people want. It was like it happened at Joe. We started at Joe's stream. Joe, we said we'll do $100 a shot, but we were joking. And next thing I know, like Joe gets $1,000. He's like, "Yo, we gotta take 10 shots." I'm like, "What? The what?" No, it's Andrew. I'm the Joe. It was Andrew's stream. And I was like, "What? Yeah. No, that's crazy." So what's up? How do you like this trial? This trial is freaking insane. It's the glorious, insane trial. No?
Yeah. I mean, it's somehow a day in which all we've done is jury instructions has had so much to talk about.
These are the greatest jury instructions on the planet, right?
Oh no, Nate.
Fuck you, Charles. Fuck you, Charles. I said one, and Charles, we were talking about something else, and Charles just wanted to come out here and just fuck with me. Fuck you, Charles. You know what? I'm gonna drink this because I hate fucking Charles. That's bullshit. It's supposed to be $5 and $4, $5. There was no the last which was $5. And now you're gonna throw $100 at me? Whatever.
That was very fast.
I'm grifting for other people's channel. I should be doing this on my channel. Now I'm over here getting money for everybody else. Uncivil you? This is bullshit.
Thanks so much, Charles.
No, fuck you, Charles. I hope this gets demonetized too.
I gave you a glass.
Okay, Mr. Bites is saying that I need to do it too because I have.
What do you got? A glass full of water there? Come on, get some. People, tell a leader to get a real drink if you're going to fucking do this, right? Get a real something. I'm sitting here drinking Absolute. What are you drinking, Alita?
This is whiskey.
You really got anything in there?
It's whiskey
Where's
in a
Mr.
real
Bites?
whiskey
Mr.
glass.
Bites, pour a little something inside there so we can have a proper drink, Mr. Bites. Come on. Let's stream this. Like
I have to be semi-responsible, right? Because I've got to manage this stream. I can't be like Joe during Purim.
Listen. We're gonna open it up. One shot is not gonna change your life. But all right, we'll do it. We'll do it.
Yeah.
We'll do it with your puny shot. All right, here we go. 1, 2. Get a little, just dip a little bit more inside there. Make us all feel a little bit better.
All right,
a little bit more. There we go.
Right. Okay.
All right. Oh no, that's a little extra, but
that's a little extra. I might be leaving a little bit behind from this.
Here we go. Cheers. And oh yeah, fuck you, Charles. And John O'Rourke too. Fuck you too.
Oh man.
That one hurt. That one actually hurt.
Mine
my
didn't.
God.
This is really good. Japanese whiskey is really good.
Fuck you too, Alita.
Nate, you're one of my best friends. What are you talking about?
This shit hurt my throat. Yes, it went down hard too. My God.
Oh,
Yeah.
no. Oh no.
I'm sweating. Look at this shit. It got me sweating. No more money. No more money.
No more money.
That's true.
So John
Shit.
O'Rourke, thanks so much for the very generous super chat as well. 2 times, we must uphold democracy and the Constitution. If you don't stand for those, what do you stand for? He is guilty and it must be proven in court, period. Absolutely. We want it to be proven in exactly the proper way, right? That's why, like, all of these crazy courtroom antics, we don't want that to be the reason why he's convicted. And that's what the judge is also concerned about, right? She's concerned about appeals and all that kind of stuff, but she's also really concerned about due process, about the actual judicial system functioning in the way that it's supposed to. So
Look at you.
Yes.
You know, you're giving like a nice, proper explanation. I would say this though, to be honest with you. This fucking guy, I pray that I would pray that I could do at least a closing for this guy. Even though I don't think I would win. Right? I don't believe I would win, but I would give him a hell of a shot. Because the whole thing is his mental state, right? You can't attack the facts on this case, right? He was in the car. You don't attack the facts. You attack the mental state, the actus reus versus the mens rea. You attack the mens rea. And here, I think the mens rea, if I was to say Darrell Brooks is a crazy mother effer, who in here would deny that that's true? Right? Nobody would deny that that's not true, right? He is crazy. He is insane. Look at the way he's acting, or that whole performance. Now, if you could take that performance and go in front of the jury and say, obviously, this man is not mentally well. And what's the number one rule? We do not punish people who are mentally ill. If you killed 100 people, but he's crazy, you know what we do? We send him to a mental institution. And then you go roll into that. Because the thing is that the great part about this trial from the defense point of view is that the jury now have become witnesses to his mental state. And the jury is witnesses to his mental state. That's the argument, right? We don't got to have a doctor tell you anything. You see it for yourself. He can't. Matter of fact, the judge is scared that he's so fucking insane. That's where I would go. Now, again, for a lot of people, like Nate loves the fitness. Nate wants to get this kill of 6 people off. No, I'm a lawyer. I'm a lawyer, and I'm a lawyer who loves to fight the fucking case. And if this guy, you know, to be the prosecutor on this case is easy. But
sorry, folks are asking in the chat for what kind of whiskey it is. It's the Cheetah single grain Japanese whiskey.
Oh, nice.
I'm sure people can hear that. Okay, sorry, Nate. No, continue on. I totally just interrupted you.
Oh no, it's fine, it's fine. But that's what I'm saying. See, the thing is here is that I think at the end that his performance in front of the jury, in front of everyone, would give you enough to make people go into that jury room. Yeah, he did all this, he did all that, but is he mentally capable of understanding it? Right? That's what I want the jury to be thinking about. Now, obviously, they probably are going to convict him. He's going to go away. But just having that thing, and then that gives me some appealable issues, right? And that's why, in this case, he should have had a lawyer, because a lawyer would have run the doctors up there, the doctor would tell you all this, saying, run all the people, all these, and then would have talked to the witnesses. Remember that one witness that said he was driving, she saw him honking and turning, right? That would have showed me, like, this guy had just had a crisis. He jumped in a car. He lost control. He was even honking and trying to, you know, what mass murderers honking, trying to tell people to get out the way. Obviously, you know, and then you go through that process. I would have fought. I don't think I'd have won, but I would have fought. And the only thing I want to go back there, I want the jury to go back there and say, well, fuck, this guy's going away, but I don't feel great about it. But he's still going away. That's the best thing you could do in this case. Yeah. And that's the type of attorney you want for you, because, hey, there's some cases you just can't win. But the fight is what you're paying a lawyer for. Fight and see if you can get me there. I might not be able to win, but it's as long as we put up a good enough fight. Right now, there's no fight here, right? This is essentially a legal execution. That's what we got going on here. So.
Yeah. But even still, though, I mean, I don't know. Like, I think that your your argument for what you, or your hypothesis, I guess, your plan
Yeah.
for what you would do on closing, I still don't think that would be a winning argument in this case, because I still think that there's enough to show that he intended these acts. I mean, the fact that he sped up instead of slowing down, all this kind of stuff. But let me add to the conversation, Natalie Wisco.
Natalie, what's up?
What's up, Nate? How are you?
Good. It's great to see you.
It's always wonderful to see your bright, shining face, for real. Like his smile. I'm like, no, I need to smile.
I am. I've been forced to take a shot under penalty of perjury here on this chat, so I might be saying stuff. My words may be a little slurred, so pardon
Shot
us.
of what, though, is the question.
Absolute.
Oh, okay.
Absolute.
Well, it's not like you need to do like 99 bananas or something like that.
True.
It takes me back to college days. So.
Oh yeah. Law school days, and that was one thing I found out in law school. I was like, these people can drink like crazy, and right before exams and stuff. I'm like, you guys are getting smashed right before the exam. But yeah, you had some people like, I'm like, how long do you guys do it?
That's UT is my law school is ranked pretty consistently like one of the top schools for what is it, like work-life balance or whatever. Mm-hmm. And I remember when I first saw that, I was like, yeah, that's because everybody like works super hard into the ground and then just parties really hard down on 6th Street in Austin. But it's people would really drink quite a bit, myself included. Fun days.
Well, right now, law school, I waited 4 years to go to law school, so I was at like this weird 27, 28 range where everybody was either significantly older or significantly younger than me for the most part. So I just kind of did my usual flitting around, doing my own shit.
Yeah. Yeah. That makes sense. I mean, it's
I wasn't like I wasn't just out of college, and I wasn't like, married and had kids. So I just got to like,
yeah, but I was married with kids too, and I went, and it was just like, but it was still a great experience, though. It was still a great experience. I still
can I say something real quick? I saw someone in the chat say that I remind them of Meryl Streep, and I just wanted to say, oddly, that is the only celebrity likeness that I've consistently gotten my entire life. Is I think something to do with the nose. Is Meryl Streep and I have similar noses.
But you also wear your hair like hers too a little bit, though.
Yeah.
Oh, I mirror. I say with mirror. I was like, which side am I on?
Well, listen, guys. I unfortunately I gotta run because I have a 2:30. But
there are two super chats addressed to you. I've got it before you go. Law Francisco, thanks so much for the super chat. Says, how would you handle a client like Darrell Brooks? Would you dump him?
No. I've had a couple of very difficult clients. But I think it's up to I think good attorneys argue the case. Great attorneys kind of manage both the case and the client. And sometimes you got to manage your client's expectations, right? And you have to, and a lot of times you have to kind of explain to the client what your goals are and what's realistic. Some clients come to you and they want the world, but then you have to understand this is what the law allows. And I think in that type of case, I don't think with this person, you can reason with someone like this. But what you can do is you can set goals. Our goal is to get you the best possible outcome. Our goal is to get these doctors in here. Hey, you may not want to tell people you're crazy, but do you want to spend the rest of your life in jail? You have to sometimes convince the client about the best strategy. And if he says, I want to go out on my own, then there's nothing you can do, right? The client, it's his case. He can fire you or whatever. But a lot of times, if you're going with a strategy that's not real, that the client really doesn't like, sometimes you have no choice. But a lot of times I feel like if you have a good strategy and you can explain it to the client, then you can explain it to a jury, because the client really is just a regular person, lay person, and that's who your jury is going to be, just a regular lay person. Obviously, we're talking about contracts case, we were talking about a judge, so that's kind of how I feel about this. I handling a client is one thing, but when you talk about mental illness and stuff, it gets a little more dicey. But in this case, I think I could have spoken to him to get him the result, because at the end of the day, I would be pushing to him. This is what we want to get to. How do we get there is the way I'm going to do it. So really convincing the client on both the strategy and the outcome. So that's the way I would have handled DB.
Yeah. Yeah, that's fair. And then also, I've got to follow up with you because I texted you about this, and I don't know if you saw it. So I'm hosting a stream on Sunday for a playthrough of Andy's game Crypto Cartel through Steam. Did you? I don't know if you're available or not, but we can talk offline.
Okay,
So
cool.
Andy wants to know, will we be playing with Nate on Sunday?
I might drop in. All depends on the timing because I think we have some things I do on Sunday. But sure, definitely.
We'll talk offline. I'm not going to put you entirely on the spot on a live stream.
All right. and listen, chat. Even though I hate you today, I still love you always. Natalie's gone, but I do love you, chat. And listen, no matter what happens. See, Natalie's on the phone. She's talking to us on the phone. but whatever happens, thanks again for being here. Enjoy the rest of the stream. And to my sister Legal Bites, I will see you on the next one. I'll try to stop
and
back
thanks to Charles Dossett and for John O'Rourke for making him drink.
No. John O'Rourke. John is my man. I love the super chat. The Charles, we got issues, Charles. So.
No.
Later, people.
All righty. See you, Nate. Thanks for dropping by. So that was fun. It's always so much fun when Nate drops by, isn't it? I mean, he's such a ball of sunshine. And I'm sure Natalie will come back. It looks like she's got a phone call. So let's continue going through this conversation between Judge Doro and Darrell Brooks when he's trying not to say that he understands because of this weird sov sit argument thing that they have going on. All right. Let's keep going. Okay.
Yes, I do.
I'm sorry, go ahead.
I would like to represent myself pro per.
What does that mean to you, sir? Explain to me that request.
Again, because I've already said it on record, to represent myself as a sovereign citizen.
I'm not going to make a determination, sir, whether you're a sovereign.
Hey, you're back.
Hi. Yeah, thanks. I
I
am trying to get work done in my office today, which does involve, answering phone calls. So.
Oh yeah, no, totally understand. So yeah, we're going through this exchange between Judge Doro and Darrell Brooks when he decided that he wanted to represent himself, and then she's like it's like pulling teeth, of course, trying to get him to to say whether or not, or indicate whether or not he understands what he's doing by releasing his counsel and moving forward to represent himself. And it's the most fascinating part is just like his uncomfortable refusal to say that he understands because he doesn't want to use that term understand. Yeah. So
sovereign citizen or not, it's not relevant to my determination how you characterize who you are, other than you are accused of 77 counts, which I will go through momentarily, and you have the right to have an attorney represent you. That's your constitutional right. You have two very capable attorneys that have been with you from the beginning. You understand that, right?
No, I do not understand that.
What don't you understand about that, sir?
I don't understand why is a reference being made to the capableness of my attorneys. Now, I agree that they have worked tirelessly on a lot of the things in this case. And I credit them with that. I'm appreciative of that. But it also should be said that there's a lot of things that I did not understand about the proceedings in a lot of the court cases. There were things that I didn't understand why there wasn't certain motions filed. There were a lot of things that I did not understand.
This seems like all the more reason for him to have representation.
And that is what kind of led to a lot of issues, but these were issues that were being raised for a number of months. This was not just something that sprung up out of the blue. And I feel that as my attorneys, that it would be essentially their job to make me aware of things that I do not understand. So that's where a lot of the questions come into question as you.
So let me follow that up, sir. If I allow them to withdraw, you lose their legal experience, their specialized training, right? Their education, their work as attorneys. Do you understand that?
These are important points.
I understand.
So if you are allowed to represent yourself in this case, sir, you will not have attorneys assisting you. If I let them withdraw, they're gone from this case. Do you understand that?
I think I will probably be better served representing myself.
And that was the thing with the sob sit guy that I represented, is he just didn't trust anybody else with his, because it was his future. That's the thing, is and that was kind of how I ended up being standby counsel for him, is because we were talking about it. He had told me, that he wanted me to withdraw first time I met him. And we kind of kept talking about it for a while. And, that really was his whole thing. He's like, this is my life. I want to be the one fighting for my life type of thing.
Yeah.
And I mean, it's difficult to do that. And because there obviously were things that he wasn't understanding, which is why I volunteered to be standby. But I mean, the actual appointment of standby counsel, I don't think happens that often in that context, just because you have to, it normally gums up the process so long. Because like in this case, if she were to have allowed standby counsel for Brooks, I mean, they would have had to delay the trial significantly.
Yeah.
Because I mean, even if you're not the one doing it, if you're standby counsel, you at least have to like review the materials.
Yeah.
So.
And because I mean, you would still have some level of responsibility.
I mean, you have to at least know what's relevant and what's not, things like that, so you can make assistance in that.
It's interesting to think about what the ethical responsibilities are there, because he's not your client necessarily. So the conversations that you have aren't confidential, right?
Mm-hmm.
So,
well, there is still, I'm looking here, ethical responsibilities of standby counsel, American Bar Association. Go away, paywall.
Paywalls are the worst.
Yeah.
If the bail.
Sorry. That was a little loud. I think that probably played for everyone. I was going to bring up another clip while we're killing time here. But so it would make sense that there are certain specific ethical responsibilities for standby counsel.
Mm-hmm.
That's not exactly the same as actually representing someone. But I've never been standby counsel myself, so I've never really had a reason to look those up. Debbie Faison Cook, thanks so much for becoming a YouTube member and welcome to Bike Club. Thanks so much for supporting the channel, and I hope to see you on Friday during our Bike Club member stream. So, all right. Well, in the meantime, I'm gonna pull up this other clip. We'll watch this for a bit. Maybe pause and talk about it.
Sorry, I just found something.
Okay.
Here, the rules of professional conduct provide no explicit guidance as to the ethical duties of standby counsel. There's no rule directly addressing the duties of standby counsel. Perhaps the leading source of guidance is ABA Formal Opinion 07-448. Summary of that opinion provides that the lawyer's legal duties, ethical duties are defined in such circumstances by the order of the assigning tribunal. And the lawyer's ethical duties are limited to those obligations a lawyer owes under the rules to tribunals or to to persons other than client.
Interesting.
So, I mean, I think part of that is, ethical responsibility, acting as an attorney in court, things like that. You have to speak the truth. You can't make baseless, claims. So I think they would have to have some type of, knowledge of everything. Absolutely.
That makes sense. Okay. Well, cool. I'm glad you looked those up. So, okay. So let's do this clip. So this is from yesterday, I believe. This is the infamous box fort.
If the bailiff could confirm,
Ooh, this is a bit louder, right? Is this overly loud for you? Okay. Hang on a second. Okay. I'll play it. You guys let me know if it's too loud.
he put him on top, he put him on the floor. That's his right. They're not in front of him, but it's by his own conduct that he's done that. The record should reflect Mr. Brooks is muted because he wants to continue to debate with this court about my prior rulings regarding his forfeiture by conduct of his right to present further evidence on his behalf.
Okay, it is a little bit loud. All right.
I know one of the things I probably need to look at, I'm not sure if Madam Clerk did this or not, would be the language.
Okay, so
of
that's taking out the
amendment
sound
from
boost.
The amended information on count 70. No, I don't want to do that. I changed. Hold on.
So this is when they were going through
70
jury instructions and going back and forth
The
and trying to
76
figure out
count. Just wanna make- It says near frame
what
part,
jury
so it is
instructions
in
they were
there,
going to
but that
be
was just one
using,
question
how
I
they were
had.
going, what kind of language they were going to use. And
So state have any requests as it relates to the jury instructions?
I'm just going through each one. I'm on page 50 of 107. Everything's looking great so far.
Okay. Fair enough. There's 107 pages. I certainly can give the parties some time to continue to read through them.
okay, now he's hiding behind the boxes. Well, here's an interesting question. Ketley Duver says, do you anticipate civil suits against him from the families? I don't think so, because normally when it comes to a civil suit, part of the analysis is what kind of damages you can get from them. And I would anticipate that he does not have very deep pockets. So I don't know that there's going to be any civil suits, or at least I wouldn't expect there to be civil suits.
Wait, did he have any? It depends on if he's got any type of insurance. I mean, really, that's the only option. Was he homeless at this time, or did he have a home?
I don't know, but I think that the car was registered to his mom.
Okay, because I mean, technically, that might be something under like homeowners insurance type of an umbrella policy. Maybe if there's an umbrella policy like with
auto
the
insurance
car.
with him as a guest driver on mom's auto insurance, maybe.
Yeah, or I mean, I don't know. There might be an umbrella if they've got things bundled. There might be an umbrella policy covering like a house and a car. You know, the only chance they have is if he has sufficient insurance. Otherwise, it's just a waste of time and stress for the victims too.
Yeah. But I've also worked in those kinds of cases where the defendant is underinsured, and so you get the max policy, and it's not enough to cover the medical expenses, unfortunately. So that is also a possibility, and I would suspect that to be the case here as well. Sandra Ramirez says, yesterday, Darrell Brooks said he wanted to bring up jury nullification during closing. The judge said, absolutely not, and remove him if he did. Can you explain why? I wasn't sure the reasoning. Thank you. Well, I don't know that jury nullification would even make sense for him to bring up, because jury nullification, we talked about this a little bit earlier, but jury nullification is where the jury basically decides not to convict the defendant, even though there's overwhelming evidence that the defendant did what he or she is charged with doing. So, it doesn't seem like that's a very good argument for him. I mean, also it's just, it's not a good argument. It doesn't make sense. In his closing argument, he needs to state a theory as to what he says happened that is different from what the prosecution says as to why he should not be convicted. And jury nullification just has nothing to do with that. So if he starts to talk about jury nullification, it just shows that he's going to be turning it into a circus as opposed to a legitimate trial judicial proceeding, where he's actually trying to, in good faith, reach a particular outcome. I don't know.
I think that website that I sent you with those jury instructions actually has the note regarding jury nullification for the state of Wisconsin.
Oh, it does. Okay.
I think it's under 705. At least that's the old version I'm looking at. Let me see if I can find it.
You said 705?
Yeah, 705.
It's so great having a Wisconsin attorney here to help me talk about these things.
Yeah, but I think if you get 705, that should be
705. Yep, jury nullification. Okay, so
you can bring it up and show people the note about it.
Yeah. Okay. 1 second here.
So this is if he were to bring up jury nullification, the kind of the curative instruction that has to be.
Okay.
And this is just additional guidance on it, but.
All right, let me pull this up. Okay. And also, Lucky, 100 pounds for a super chat. Thank you so much. Super generous of you. Shot for Nate, bathroom break for Alita. Thankfully, I don't need to take one just yet. Maybe a small miracle, but we're going strong. So then I will make sure to tell Nate that he owes my chat another shot. Thank you so much, Lucky. It's so kind of you. So here's the curative instructions for jury nullification. It says this law note discusses jury nullification, a term generally understood as referring to a jury's returning of a not guilty verdict, even though the evidence is sufficient to establish all the elements of a crime beyond a reasonable doubt. Okay, so a jury has the power to nullify, that is, to return a not guilty verdict, even though the evidence is sufficient to prove all elements beyond a reasonable doubt. This power flows from the interaction of practical concerns and legal rules. So 1, the jury cannot be compelled to act in a particular way or reach a particular result. 2, once the jury retires, no one knows what goes on. 3, only general verdicts are used in criminal cases. And 4, there can be no appeal from a not guilty verdict. Okay, thus, when a jury returns a general not guilty verdict, no one can tell what the basis for that verdict was. The verdict may reflect legitimate disagreement about whether the elements of the crime were established. It may reflect honest doubt about whether the burden of proof was met. It may reflect a mistake about the facts, or it may reflect a conclusion reached in defiance of the proof. But unless individual jurors make post-trial statements to explain their verdict, the basis for the verdict will remain unknown. And you know what? I don't know why I didn't zoom in earlier, because that font is a little bit small. I just noticed. Okay. Even if it becomes known that a jury engaged in nullification, no remedial action can be taken. It is a fundamental principle of double jeopardy that the state cannot appeal from a not guilty verdict. The principle applies regardless of the reason why the jury reached the not guilty conclusion. Wisconsin's courts have recognized the jury's power of nullification, but they have distinguished between the power to nullify the objectively correct application of the law and the right to do so. So now I think I see what he might say in his closing argument as to jury nullification is he might ask them to nullify the verdict. Basically, like that's his Hail Mary throw to say, you know what? Even though there's overwhelming evidence that I did it, you should nullify the verdict because reasons.
Yep.
So, okay. Yeah. Makes sense now why he would try to bring that up in closing. and why the judge would say this is ridiculous for you. You know, if you try to go and do that, it's just upending everything else in this judicial process, and it's has a high likelihood of confusing the jury. So all kinds of problems with all of that.
Yeah,
So,
and
yeah.
then the comment kind of goes on and talks about, on the next page is the like case law regarding that. But I mean, it specifically says, you know, in 1895, excuse me, United States Supreme Court rejected the federal constitutional right argument against jury nullification.
Okay.
More recently, the court has stated that a defendant has no entitlement to the luck of a lawless decision maker, even if the decision cannot be reviewed. So.
Okay. Yeah. And so yeah. They don't have to say why they reached a particular verdict. They just have to reach a verdict. Or, I mean, obviously it ends in a mistrial if they can't reach a verdict. But yeah. Based Ape, thanks so much for your super chat, says, I found a lot of his questions quite suspicious. Do you think he might not be trying to actually defend himself and is instead looking to get the case thrown out on any technicality after the fact? I think he's looking for any possible opportunity to have this tossed out somehow. But I think that there's a certain element to his actions here also that speak to probably things like ego, narcissism, control, that kind of stuff too. I don't think everything that he's doing is strategic. So yeah. But yeah, thanks so much for the super chat. Okay, and let's see, there are some other questions here. Oh, Annie Mae, a wholesale earlier said, is pleading the fifth getting less jail time? No, pleading the fifth basically is just saying that it's invoking your right to not incriminate yourself. So if you think that there's anything that you say on the stand that could be interpreted as incriminating yourself, you have the right to not testify as a criminal defendant. So, you know, there are benefits to invoking your Fifth Amendment right. There are also risks that come with invoking your Fifth Amendment right. I remember having that conversation with Natalie actually after the Kyle Rittenhouse trial about why Kyle Rittenhouse decided to testify in his own case, because I remember those of us watching it were like, oh my gosh, like, what is he doing? Like this case is going so well for him. This trial is going so well for him. This only brings risk. But you know, Natalie gave some very, very sage wisdom about the local ideas of testifying on the stand, that not only is it, you know, generally in that part of Wisconsin in particular, you know, or as in a lot of other places in the country, not only is there a perception that if somebody doesn't testify, it's, you know, sometimes it can be perceived that they are hiding something, or it can be looked at as negatively. But I remember you said that you guys actually tested it out with mock juries, and overwhelmingly it was way better with him testifying.
Yeah, and the important thing with that as well was the element in the self-defense instruction is that it had to do with intent. Is that, you know, as the judge was stating when she was reading the instructions today, is that, you know, you can't know somebody's intent. You can't know what goes on their mind specifically. You have to look at facts and the circumstances surrounding it. Yeah. Well, you know, it depends upon the situation if you need to differentiate the facts and circumstances from the actual person's intent. And that was the situation we were in, is that he didn't give a statement that was going to come in the state's evident in the state's case at all. So we had to be able to actually establish what was going on in his mind and what, you know, his intent was and what he thought he was facing, because that's what the instruction calls for, is that, you know, the person's belief at the time wasn't unreasonable. That's the state of the law. And, you know, he isn't bringing up a defense in this context that necessarily, you know, needs that. You know, I mean, we're getting to the intent as far as first degree intentional homicide. I mean, in this case, there is likely, I don't remember from the jury instruction reading at all if they're including any lesser included offenses in the verdict forms at all. But I mean, the best case you would have would be to go for reckless homicide, maybe. And considering the amount of counts that we're dealing with here, I mean, the ultimate outcome is still going to be the same if you're convicted on reckless homicide, 6 reckless homicide counts as opposed to, intentional homicides, considering the fact that there's all these other charges. He's looking at life in prison.
Yeah.
So, I mean, that is also another big thing is, reasons why people testify is there are sometimes specific languages and things. And while the jury has the ability to nullify, they also curative instructions, if someone brings up nullification, if he were to bring it up in there, reading further on that, common thing we were looking at is, anti-jury nullification instructions generally are, that to admonish jurors that they're not like allowed to just disregard the law because they don't believe it. It's wisdom.
Right.
So,
right.
And that's, it's looking at the big picture thing as well, which is again, where Brooks has been lacking is he's too deep into it and distracted by these specific things that he's not looking at big picture.
Yeah. Yep. Completely agree with you there. And it's going to end up biting him in the ass from by all accounts of what this looks like. And I do see that we've got a couple minutes until we go live. I think some folks have said that on other feeds that they can see the courtroom. Court TV still is not showing it, but I do have it shared. So so it'll, as soon as it goes live in like a minute, it'll start playing. So yeah, minute and 20 seconds it says. But in the meantime, here's another question from Paige. How would questioning have gone if he chose to testify since he's representing himself? How does that work? Yeah, we talked about this a little bit earlier. But he can do a little bit of narrative, but he would have been able to, like I said, do some of that, but then there would be objections from the other side. So he would have to go in a certain direction though, right?
Yeah. And I would think that, if I was the prosecutor on the other side, I would like some offer of proof beforehand as to what he's going to testify about to make sure that it's within relevance, at least specifically, is because you can ask that outside the presence of the jury. Is I would clarify with the judge, can we just get an offer of proof as to what he's testifying about? And then you get a pretrial ruling specifically regarding, not pretrial, and ruling outside of the presence of the jury as to like what topics to focus on. That type of thing can be very beneficial to somebody who's pro se if they were questioning themselves, but this person's obviously not going to abide by any judge's rulings regarding relevance.
Yeah, makes sense. All right. Okay. So we are waiting for Court TV, it says. Okay. Well, see here. Okay. So should be starting any moment now. Oh, here we go.
I'm going to be listening, but I'm going to be running around
Sure.
my office. So I'm turning my camera off.
Sure. No worries. All right. So it seems like he is back in the courtroom. We will see for how long. Doesn't seem like there's any sound on at this time. Okay. So let's see how long he will be staying in the courtroom now. Okay. Hopefully this isn't something having to do with my... Oh, here we go. Okay. I got worried for a minute there.
from yesterday too. You gotta scan that in too. Okay. And then, do you have the sheets for me?
B, I appreciate your musical reference.
Yes. Isn't there a fourth one? No, there's one on your, I bet on your. Yeah. All right, it's 2:00. I'll call the case. State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please.
Good afternoon, Judge Slapper, Leslie Daisy, and Zach Wichow, appearing for the state.
I'm here without prejudice by special appearance. Beneficiary, I'm here under fraud, menace, duress, and extortion. Judiciary, Jennifer R. Darrell. This is a social security sesquique trust action which you are a real party and interest to.
What?
As sujurers and propria persona. This is a military admiralty tribunal and maritime law.
This is not maritime law.
Title 4 of the United States Code, Section 1.
This has nothing to do with the seas.
Which states placing of fringe on a national flag is within discretion of President.
I should boost the
President
volume, huh?
acting as Commander-in-Chief of the Army and Navy. Is this
There we go.
A common law court or an admiralty court?
Neither. Well, sorry,
Records reflect
not
that
an
the
admiralty
known to
court.
This court as Darrell Brooks is present in person in custody. He is wearing a dress shirt. I know he has a suit coat, but it's not on. He's also wearing a mask. The court is not going to address any of the issues that he is raising as they are meritless. I would also say the same as to the notes that he passed while he was in the other courtroom. For the record, I did provide a copy of all of those to the state as well. They are also uploaded into the file and are made part of the record. To the extent that he raises objections or lack of consent, it is noted for the record.
I was about to do that and say that I don't consent to being called that name or identity. That is
He doesn't
the trust
consent.
name, and it is not me myself. I don't recognize that name, nor do I consent to being called by that name. With all respect, Your Honor. And we still have yet to address subject matter jurisdiction.
Oh,
that
boy.
has yet to be proven on the record.
Oh gosh. Okay.
May I receive those original copies time-stamped?
Okay. All right, I need to make a record of one part of a jury instruction that I do need to advise the jury. It will also be corrected in the packet. I believe within the last year, the jury instruction on credibility of witnesses was modified by the jury instruction committee. And it was just an oversight on the court's part to not include, it's really just one paragraph. It was read to the jury at the beginning of the case with the preliminary instructions, but it is a paragraph regarding implicit bias. And so I do think it's important to advise the jury of that. I intend to do that.
Hi, Ashley from San Diego.
And then again,
Or South Dakota.
The
Sorry.
full instruction
Being in Southern
will be
California, and I think of
amended
San Diego.
so that it's in the packet that goes.
Maybe you mean
to
South
the
Dakota.
jury.
Either way, hi.
And Madam Clerk, if you haven't already, if you could print off page 72. It's the, it adds a paragraph before the last paragraph that starts
Yeah,
with there is no
I
magic way
do
for you to
love
evaluate the
that
testimony.
she just ignored all of
And
his
again,
stuff
I
and then
wanted
was
to be
like, all right, I
consistent
need to get
with
this on the
most
record.
recent version of the jury instructions and consistent with what was instructed or provided to the jurors at the beginning of the case. And so I will make sure that they have that and so advise them when they come out. Also, I will read instruction
Ashley.
160, closing arguments. Madam Clerk, if you could just make the change so that it's of parties. We missed that correction as well. So it's the closing arguments of the parties, not the attorneys. And so I will just make that correction and make sure it's.
I accept for value in return for value this document. And Your Honor, I requested that I have copies of my filings from earlier, time stamped.
Mr. Brooks, I'll provide you with the copies later on. I need to continue with the instructing of the jury and have the parties make their closing arguments.
Your Honor, with
I
all
did-
respect, the state received copies. How come I can't receive the copies of my filings?
You know what? I can give you the print offs, but I can't give you the originals right now. That's what I'm referring to, and you will absolutely get those back. I guess I was mistaken that you wrote copy on it. I thought you retained a copy for your records. So with that, Madam Clerk will print off from the record. It won't be the yellow copies just yet. I'll take that up later outside the presence of the jury after the case has been given to them. Now, in terms of the closing arguments, I did set a time limit for the parties yesterday. Each side will have a total of 1 hour. Mr. Brooks, so that you are fully aware, the party with the burden of proof, which is the state of Wisconsin, goes first. Then you, as the opposing party, will have an opportunity to respond and argue. And then, time limit willing, the state also has the opportunity to present rebuttal because they have the
Hi,
burden
Rachel
of proof.
Pizarro from Seattle.
And that is provided with the excerpt from the bench book that was provided to you yesterday. It has the purpose of the closing arguments is to summarize the facts, marshal arguments, focus the issues for the jury. I just talked about the order of the arguments. The scope of the arguments are the content, duration, and form of argument are within the court's discretion. That's why I set a time limit of 1 hour for the parties.
Time limit of 1 hour for
And
closing arguments per party.
Mr. Brooks, I will advise you that I certainly will wait and see how you present your argument today. I will certainly wait to see if there are any objections raised, but I also want you to be aware that if I feel the arguments are improper, I may simply, without an objection, say, please move on, as a clear indication from this court that what you are stating is not proper under the various rules and case law that govern closing arguments.
Again, Your Honor, without prejudice, I'm here by special appearance. I don't consent to being called that name for the record.
It's noted, sir. All right, then with that, I will have the go ahead. Looks like Attorney Opper has some issues she wants to raise.
Yes, I just have one question, Your Honor. Would I have permission to put the easel up and display some of the poster boards? I did confer with Captain Dussault as far as security is concerned, and he agreed to it if the court would give me that authority.
Where would it be displayed?
It's going to put it like right here, and then you want me standing at this table during.
I do.
Yes, so I would just position it like right here. And I don't have to leave it up through the whole thing. I realize it blocks the view of people in the courtroom. Detective Casey would be willing to assist me in removing them when I'm done with them, if that's okay with you.
I trust it won't block Mr. Brooks' view of the jury, and
That's
as long
what I-
as
yeah, I was going to put it like right about here so that he could still see me and the jury.
with that caveat, yes, I will allow that.
All right.
Objection, what is that? What is supposed to be put up?
They were previously admitted, Your Honor. It's Exhibit 15 and 130, I believe.
So are they exhibits? I'm confused to what they are.
Mr. Brooks, I've made a ruling. The state has made a request. I've granted it.
Yeah, but
In
I'm
terms
saying
of-
I don't understand what's being shown. Should not have the right to ask, to object and ask what it is that's actually going to be shown.
The state's put on the record what it is. They are exhibits that have previously been received by the court during the course of this trial. That is proper for a party to do that
Yep.
during its closing
Yep.
argument.
So can I put up exhibits?
I'm
Mr. Brooks, I
sorry.
don't know what you have planned for your closing argument.
I'm making a request, the same request. May I be able to put up?
Well, Well, I guess it
exhibits.
depends on what it is, sir. So I'm not going to take up any more time because what I intend to do is, once the state goes through its
These are
closing,
usually
I
going
may
to be
take just a
prepared well
short
in
comfort
advance.
break, depending on how long it is.
So him
And
asking
if
at
there's
this
something in
stage right now,
particular,
can I
what are
also
you-
put in
you'll
exhibits?
need to
It's
tell me
just
what it is. As long as
absolutely
it's an exhibit from this
preposterous.
case, then I
Well,
don't really
and
have an issue with it.
I think there's,
They would be from this
again,
case.
fundamental understanding of the place in the process is that
It's just
at
not
this point in
nothing that the
time,
state has.
any exhibit would need to have already
I'm
been
not
admitted
aware of
or be
exhibits
simply
that the
demonstrative.
state
You
wouldn't
can't
have
introduce
that
new
you would have.
evidence right now. It's not
Exactly.
Everything
a
that's been
testimony
received, we
evidence
have a
taking
list.
portion. This is an
Um,
argument.
Yeah,
So if it's not
exactly,
something that
exactly.
was received during
And that's
this
why,
trial,
you know,
as an exhibit by the
when young
court,
lawyers are learning how
unless
to
you tell me
prepare
what
for
it
trial,
is so that I can make
you
a
know,
ruling.
the
I
common
can't see
wisdom
how it
is
would
you
be
start with your
relevant or
closing. What
appropriate
do you
for a
want
closing
to
argument.
what do you want to be able to say in your
They're,
closing argument? That sort of informs
part
you
of my
what pieces
filings
of evidence
that you
you
filed.
need to get in during the trial
The
so that you
filings
have
no
those
relevance
available for
to
your
the
closing.
issues that are before the jury. The closing arguments are to direct the jury so that they have your arguments so that when they go back to determine the issues in this case, which are related to whether you're guilty or not guilty of the 76 charges, things like subject matter jurisdiction
Fox Sports
or
Stephen Yarker, thanks so much for your
like
super
that
chat.
would not be
Been
something
watching
that
this
would
all
be
day and I'm
proper
still hooked.
before
It's like
this
driving
jury.
past
Those
a car
are
accident.
legal
Ugh.
issues that the
A
court
little
will
bit too
decide.
on the
The
nose for this
jury
case,
is
I
the
think.
judge of the
But
facts.
I
The
know
court is the
exactly what
judge
you
of the
mean.
law. That's
I'm
why I
not-
have all of
And
these
Rachel
jury
Pizarro,
instructions
thank you
to
so
give
much
to
for your
the
super chat.
jury.
I'm not referring to subject matter jurisdiction.
What are you referring to then? Be very specific so I can make a finding and
I
ruling.
was specific, my other filings that
That's
was
not
filed.
specific enough,
My-
sir. What are you
My
referring
court
to?
docket
Which
sheet,
filing?
let me know when you're done, Your Honor.
Which filing, sir? Not generally, but specifically.
Are you done?
Oh, geez. Oh, geez. So disrespectful.
Are you done?
Sir, that's very rude and
No,
disrespectful.
I didn't know if you was finna say something.
No.
That's why I'm asking, are you done?
Which,
Charles.
what
Your
filing
Honor,
are
how
you
come
referring
every
to?
time
That's the
I
wrong way
try,
to answer
even
that
when I try to
question.
err on the
To
side of
ask that
caution, you
question,
find some
not-
way to
are you
make it
done?
to be
Yeah.
something that it's not. I didn't know if you was
Yeah.
gonna say something else.
You say, may I speak?
I've asked a question,
Or-
sir, so when I
Are
do
you
that,
finished?
I would
But
hope
are
it would
you done?
convey to you, I'm looking for
Yeah.
an answer. So which filing are you referring to?
All
With
my
specificity.
filings, my notice of appearance, my statement of particulars, my bond, the court docket sheet, all of those filings.
The request to display those to the jury is denied. It's not relevant.
How is it not relevant? Not even your
That's my
oath of office?
determination, sir. So I am going to start this.
Not even your oath of office can be shown?
No, that is not relevant to these proceedings, sir.
It is.
It's not relevant in front of the jury.
Why is it not relevant? Can you
Mr. Brooks, you
explain
are
why
not
that's
going
not
to be
relevant?
able to raise
Somebody
those
asked
types
if I've
of
been before
issues
this
and
judge
present
before.
a closing
No,
argument
I'm
based
not.
upon my oath of office.
I don't do a
whether
lot
I'm
of work
licensed
in
to practice
Waukesha.
law in the state of Wisconsin.
I said your oath
Whether
of
there's
office.
subject
I didn't
matter
say anything.
jurisdiction, whether you
I've done
consent to
some
this
cases
appearance or
with two
not.
of the prosecutors
those
out of the
things
three, but
help the
never that judge.
jury determine the issues in this case, which are related to whether you are guilty or not guilty of the 76 charges that have
The
been
jury
filed
should
in
know
this
that
case.
they should know the truth in their duties, in their rights. They should know that at least.
Mr. Brooks, I'm putting you on notice that if you continue with this insistence upon presenting information that's
Should we
not
start the
properly
countdown?
before the jury as evidence in this
For him getting
case,
kicked out.
that I will instruct you during your closing argument to move on and potentially ask the jury, have the jury leave so that I can admonish you. And if you keep insisting on that, sir, that will be in direct violation of the court's direction
So
to
they
you.
can't even know that I got a shock device on my ankles.
They absolutely do not need to know that.
Why
So it's
not?
not relevant to the determinations of guilt or innocence in this
It's the
case.
truth.
Mr. Brooks, your custodial status is not on trial here.
Essay,
would
thanks so
argue
much
that
for
it
the
is.
super
Conduct
sticker.
from November 21st of 2021 is
That
what is
hasn't
on
been
trial.
proven.
Keeper Dam,
You
thanks
may
so much for
not
the super
bring
chat.
up
Objection, badgering the judge. Yeah.
The way that you've been shackled, it's not relevant, sir.
It's
and if
the
you
truth.
do so, you do it at your peril. But here's the
There
thing:
is
the
no
jury
peril.
is specifically.
It's my right,
no,
though.
Let me go. Okay,
It's my constitutional
is-
right. Just like
Constitutional
under the
right.
First
Right, sir.
Amendment, which I
Your-
preserved my First Amendment right when I came in this morning, I also preserved my
Right.
Sixth
Mr. Brooks.
Amendment right.
Please stop. You do not have an unfettered First Amendment right. That is very clear based upon.
What do you
all
mean
the
by
case law.
unfettered? What do you mean by unfettered?
It
I
means
don't.
it is not absolute. It can be restricted.
So the Constitution of the United States can be constricted.
All right, Mr. Brooks, I'm putting you on notice that if
Sure
you
can.
continue with your.
There are
insistence
limitations
on
to it,
raising
yes.
issues that are
I'm going to
merely a
raise issues that the
distraction,
jury needs
that
to
are-
know,
Like,
They're
for
not
example,
regardless,
something that
because
gets brought up all the
they're
time.
under the rights
Second
of the
Amendment.
United
There are
States
restrictions on the
Constitution,
Second
which is the
Amendment.
law of the
Draw
land.
your
Yeah,
attention
who
to
are
closing
convicted or
instructions
felons
for
can't do
I'm
it.
which will be read
going
the
to
jury
let the
at some
jury
point.
know the truth, their duty and their rights. Under the First Amendment and under the Sixth Amendment, I have the right to inform them of their rights, of the truth, and of their duties. Under the First Amendment and under the Sixth Amendment of the Constitution of these United States. You can't.
Kurt needs
No
to do
state
a
law
stream on
can
what the First
override
Amendment
that.
actually
Mr.
says.
Any
Brooks,
law-
do you intend
any
to
law
pick this up when the
repugnant-
jury comes out?
Your Honor.
Because I need to
No, I
have
do
the
not. That's
state-
why I'm addressing this before
I'm not-
before they come out. That's why I'm trying to address this before they come out, so it doesn't become an issue once they're in here. But under the First Amendment and under the Sixth Amendment of the Constitution, which are rights that I preserved the moment we stepped in here this morning when this proceedings started, I preserved those rights for the record. And now you're telling me that those rights are not, would you say unfettered or I don't know what you say. I don't even know what that means. I don't even understand that. But any law repugnant of the United States Constitution is null and void.
Mr. Brooks, I'm putting you on notice that you can also forfeit by your conduct the right to present a closing argument. In appropriate circumstances, the right to present a closing argument, no different than the right to testify, may be subject to forfeiture where your conduct is incompatible with the assertion of the right at issue. The goals that this court has attempted to follow throughout this proceeding are multifaceted and multifold. Number one, I do have an obligation and I have done my best to ensure that this is a fair trial. However, a fair trial does not mean a defendant has unfettered rights to state whatever he wants, when he wants. This court, not only through the course of the trial, is deemed with the responsibility to control
Bring the gavel, Your Honor.
presentation of
Bring the gavel.
evidence so as to ensure fairness and reliability of the criminal trial process. It also
The thing is,
includes
like,
ensuring that the closing
This isn't a
arguments
filibuster.
are relevant,
that he's
are
doing.
appropriate.
That's
This court
like,
must
he's
also
trying to filibuster
be concerned with
Yeah.
efficiency
That's
and
a really
good point.
effectiveness and
That's not what's
Of course,
happening. Like,
last
this
but
is not
not
a
least,
situation where you're going to get
courtesy and
anything
decorum in
by,
this courtroom.
reading
What I would
the
generally
phone book
refer to as civility
out
in
loud.
the
We're not just
courtroom.
killing time. There has to be an end
You
goal.
do not have unfettered First Amendment rights or an unfettered Sixth Amendment right, sir. You must conform your conduct to the rules of decorum, the rules of evidence, and the rules of procedure.
Somebody had asked about
Well, you
the
have a
Sixth
right to
Amendment, I
present
think.
relevant and probative
What the Sixth
arguments to
Amendment
this
is.
jury. You may not.
Do you want to take that lead, or
and
do you want me to give
You
a
may
quick?
not
It's
present
the
arguments related to
right
such
to
things
a public
as
and speedy
jury
trial.
nullification,
And so
subject matter jurisdiction,
his
the court's
ability to
oath
have
or
a
lack thereof, if that's
a
what you
full
believe,
trial here,
whether
right?
this
The
court
ability to have a
is
closing
court of
argument, the
common
ability
law,
to have the same sort
admiralty,
of
all of those things relate to
fair
your claim as being
chance
a
like the
sovereign,
other
which
side
are
gets,
frankly
right?
baseless.
But what she's
They're
explaining to
meritless.
him is that
They've been debunked
that
by
doesn't
many
mean that
courts,
he can just
including
railroad
court
the entire
in the
process in the
Beneby
name of the Sixth
decision that's been
Amendment.
referenced
Yeah,
by
I mean,
this
because
court
it's, if you look at it, all
previously.
criminal
I
prosecution,
will give you a fair
accused shall
opportunity
enjoy the right to a
to
speedy public
present a
trial,
closing argument, but
Mhm.
again, it is not
to be fronted
unfettered.
with the witnesses
The
against
simple
him,
fact is,
right
sir,
to
this court
compulsory
can
process,
restrict
assistance
your
of
right
counsel.
to present a
I mean,
closing
it's not the
argument.
right
This court
to
has
say
the
whatever you want.
authority under 90611, under the various cases, including Illinois versus Allen, including Rock versus Arkansas, although Rock versus Arkansas and Chambers versus Mississippi dealt with the right to testify. There is a decision I looked it up earlier, and I'll just pull it up and tell you the case site so that you have it. I would direct your attention to Herring versus New York, found at 422 U.S. 853, a 1975 case, although in a footnote, it does stand for the proposition that a defendant who has exercised the right to conduct his own defense has, of course, the same right to make a closing argument. That's quoting State Ferretta versus California, or following the same logic from Rock and Anthony and Chambers, a right, even a constitutional right that a defendant has may be forfeited by conduct. This court, just like it attempted to do with regard to your right to testify and set up reasonable restrictions so as to meet all of the goals that the court needs to meet, will be as follows, and that is, again, sir, you may not bring up matters that are not relevant to the determination of guilt or innocence. That means evidence that was not presented and not received in this courtroom is not relevant to your closing arguments. It's not, the arguments must be based on the law, not as you interpret the law, but as the law is. You must base your closing arguments on the facts that have been established during this case, meaning the evidence, the testimony. As I indicated earlier, the purpose of a closing argument is to summarize the facts, marshal arguments, and focus the issues for
officer
the jury.
right behind him looks like Anthony Michael Hall.
It is fair that you comment on evidence, including
Tell me I'm
arguing
wrong.
evidence to the conclusion or inference. It is your ability or your opportunity to convince the jury that you are not guilty of these offenses. You may not convey any idea that you have undisclosed information. Neither party may vouch for a witness or otherwise express personal belief or opinion regarding truth or falsity of any testimony or evidence. It would be improper to ask a jury to draw inferences that the parties know are not true. And your comments on evidence is limited to evidence in the case. You may not comment on facts outside the record or peculiarly within your own knowledge. And that is just some of the guidelines for determining the proprietary of arguments that I am guided by from my judicial bench book and all of the cases that are referenced therein. So you are put on notice, sir, that even without an objection, this court may, in an effort to preserve the dignity, the decorum, and to keep the issues properly before the jury, may advise you during your closing argument to move on. If you do not honor the court's rulings, then you will run the risk of forfeiting your right to be present.
She's
and
giving him
potentially
plenty
forfeiting
of
your right
notice,
to further present your closing
plenty of
argument.
warning.
With that, I am bringing this jury out to complete the instructions that I need to complete, to add to the credibility instruction, the paragraph on implicit bias, and to let them know the full instructions that they receive will have it, to read 160 closing arguments of the parties, and then to have the state go first as they bear the burden of proof.
Now, Your Honor, I'll just let you make your record. I didn't overtalk you. I didn't interrupt you. Is that fair to say? I'll let you make the record. With all due respect, when will I be able to make the record? As I've tried to do numerous times by saying I wanted to present an offer of proof for my appeal. That's the chance for me to be able to make the record.
I'm denying your request to make an offer of proof regarding your appeal. It's
So
not,
I'm not allowed to
required
make the
to give you
record at
that
all, Your Honor?
opportunity, sir.
I'm not allowed
Sir.
to make the record at all? As I just let you did, because some of the
Sir,
issues
I
has
have-
been, some of the
You have
issues
told me
has
what
been,
you want to do. I've
Your
told
Honor.
you you can't. I've addressed
Your
the
Honor,
request.
some of the issues have been me
She's about to
over talking
kick
you
him
and
out.
interrupting you. I did not do that. even though everything that you said, you have not proven for the record in this is unlawful law. You haven't shown
It's unlawful
one time
law.
that is lawful for you to do what you've been doing as
Mr.
far
Brooks,
as your ruling.
Once again, I'm not going to debate with you the prior rulings of this court. There's absolutely no need at this
How many
point for
times
you
has
to
she
Your
said
Honor.
that at this
offer
point?
proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
You
I'm
will have
going
an
to
opportunity,
inform.
if
I'm going
convicted,
to
to
inform the
raise
jury.
every issue you want on appeal.
I'm going to inform the jury of the truth, their duties, and their rights, as
What?
I have the right to do under the First Amendment and under the Sixth Amendment. You can't just disregard the United States Constitution. You can't do that. Again, any law repugnant of the United States Constitution is null and void. There's no state law that you can cite. There's no federal law that you can cite that overrides the United States Constitution. You
Mr.
know
Brooks, I
this.
direct your attention to State versus Anthony. Although that case dealt with the right to testify,
Okay, so
its
we're not talking
reasoning
about
is
the right to
equally
testify.
applicable.
We're talking
Take
about
him
the
out of the
closing
damn room.
arguments, correct?
Yeah, at
We're
this
not talking about testifying, which you
Mr.
already
Brooks,
made a
I'm not
ruling
going
on.
to delay
You
any
already
further
made a
the
ruling
closing
on.
arguments
But
of
Your
the
Honor,
parties.
with all due
I will
respect,
address your further request.
with all due
once the
respect,
state-
you already made a ruling about testifying. Did you or did you not?
Mr. Brooks,
So we're talking about now. We're talking about closing arguments that I said it's my right to be able to inform the jury of the truth, their duties, and their rights. That is my constitutional right.
Mr. Brooks,
You
we are at
can't
the stage
tell
of
me
the
I can't-
proceedings where it is the state's burden of proof where they get to make their closing argument.
We're talking
first.
about me though.
I understand that, sir, but
I'm going to inform
your
them of the
conduct
truth.
right now is delaying
I'm not intended
the court's
to delay
intention
anything.
of moving
I let
forward
you,
with the
Your Honor.
closing
I
argument.
just sat there and let you make the record. I didn't overtalk you or interrupt you. I let you say what you wanted
gold
to say.
star,
I
bro.
let you make the record.
Gold star.
I didn't interrupt you not one time.
No, but sir, you're attempting to disrupt the proceedings by
I'm
going
not
off on a
attempting to
tangent
disrupt
into
anything.
all of these other issues.
How-
From my
how am I-
perspective, that is in an
How am I
attempt
being
to
dishonored?
simply
How am I being
delay
in
what we're
dishonor?
doing.
How am I
So
being
you are
in
put on
dishonor?
notice. I am done dealing
How
with
am I
these
being in dishonor,
issues.
Your Honor? How am I being in dishonor of the
Oh,
court?
geez.
Mr. Brooks.
Repeat it one
I've
more
made
time.
my
It'll help.
determination.
And have
I'm
I not
going to
preserved my
address
rights?
this further.
Have I not preserved my rights?
If you insist on interrupting the court and disrupting the flow of these proceedings by a blatant disregard for the parameters that I've set up, you will forfeit your right to be present in this courtroom and potentially forfeit your right to present a
Yep.
closing argument.
Under
Yep.
what lawful law can you do that?
Sir, I've
You
made
can
my
hold me in
determination.
contempt by Illinois versus Allen. You can do that. You stated that numerous times.
Mr. Brooks, I want you here for the closing arguments, but
Apparently
you
you
do
don't.
not want
Apparently
to
you
follow
don't,
the
Your Honor,
rules.
because all I said was it is my right under the First Amendment and the Sixth Amendment to inform the jury of the truth, their rights, and their duties. I never once said anything about, oh, I'm going to bring up subject matter, or I'm going to bring
You're
up
right,
this,
sir.
or
And
I'm
I
going to
will
bring
wait
up
and
that.
see what you have to say. But I thought it prudent, given your conduct to date and your insistence on bringing up issues that have no bearing in this case.
This is a new
They're not
day, though, Your
relevant.
Honor. This
They're
is a
not-
whole new day.
That it was prudent on my part to give you some guidance before you potentially do that in front of the jury. But
Okay,
you're right.
but-
I will wait and see.
Your Honor, it's
But
still
I need to get going.
it's still
and I'm going to,
unconstitutional for
sir.
you to
So
tell me that
you
I don't
need to
have
be
the First
quiet.
Amendment right that I preserved, or the Sixth
Mr.
Amendment
Brooks,
right
I'm
that I
going to have
preserved,
the jury brought out. I expect that you will be respectful, courteous, and quiet.
or I'll be
And
held
when
in
this door
contempt,
opens,
or I'll be held in
if
contempt.
you insist on making remarks, then I will excuse everyone from this courtroom and you
Yep.
will be removed because you will forfeit your right to
giving
be present
plenty
for
of
being
notice.
disruptive.
Under what lawful law?
That
Because
is
I
my
haven't been
ruling.
dishonorable to the court.
Madam Clerk, please have the jury brought out.
Well, take me to the next courtroom then. Take me to the next courtroom, because you're not going to override my constitutional rights just because you feel like you can, and you don't have no lawful law to do that. We all have constitutional rights, and you cannot trample
Mr.
on
Brooks,
those.
what you are raising are essentially issues that you can raise on appeal.
No, I'm raising them now because they need to be on the record now, because you won't allow me to make the record as I've let you do. You've even went so far
As I've
as
let
to
you
mute
do.
me.
As he's
Which
talking
you
to us
can't
if
even-
they're like
there's no
equals
lawful law to say
in
that
this
you
or
I'm
can even
something.
mute
inviting
me.
you to be quiet. They're coming
Your Honor,
out.
does Illinois versus Allen say that you can utilize the mute button? It does not.
Oh my God.
Mr. Brooks,
So
when
you're-
that door
you're-
opens, I expect you to be quiet.
You're,
and you will
you're,
forfeit
and I
your right
expect
to
for
be
you to,
present.
I expect for you to answer questions as a public servant, Your Honor. You're a public
The
servant.
jury's coming
You're
in.
supposed to serve the people.
All right.
Take me to the next courtroom. Please, take me to the next courtroom. Hold me in contempt. Hold me in contempt. Hold me in contempt.
Oh, Jesus.
Hold me in contempt.
Oh, so frustrating.
I have constitutional rights that are being trampled on, and you're coming up with ways to make a lawful law where it doesn't say in Illinois versus Allen anywhere about utilizing
doesn't
the
Record
mute
to
button.
reflect that the
be-
jury bailiff is in here. However, the jury is still in the hallway. I'm going to give Mr. Brooks one more opportunity to be respectful of the court's rulings,
Your
whether
Honor,
he
I
agrees
haven't-
with them
I
or
haven't
not.
dishonored the court.
Oh,
I'm
jeez.
merely exercising my rights under the Constitution, under the First Amendment, and under the Sixth Amendment.
Mr. Brooks, your rights do not include you disrupting these proceedings
I'm
the
not,
way
I'm
that
not
you have through
disrupting
the
the
course
proceeding. You
of
just
3
told me
weeks.
you don't have to honor my constitutional rights in so many words. You're using a mute button
Mr.
that's
Brooks,
not
the
even in your
jury is
decision.
outside this door. They're not brought in
I'm
yet.
informed that
I'm
the jury. I'm
asking
informed
you
that the jury
To
is
be
outside the
respectful
door.
of their time.
They're not in the courtroom.
I'm
They're not
asking you to
present.
be respectful of the court's ruling,
They're
whether
not
you
present.
agree with
These
it
are
or
issues
not.
that need to be resolved before they're present.
Mr. Brooks, they will not be resolved to your satisfaction.
It's not about my
The
satisfaction.
record
It's
has
about the
been made.
Constitution. It's about what's right.
Are you going to
Are you going to
follow the
answer
court's
questions as a public
requirements?
servant on why you're making up laws that are not in the Illinois versus Allen and never utilized
the
the
jury
mute button
can
and
go
never
back
said
to the
anything
jury.
about a
Thank
mute
you.
button?
It is clear
Why
that
am I
Mr.
being
Brooks has
muted?
absolutely no intention of following the simple rules of decorum and courtesy. He has repeatedly talked over me. He's repeatedly interrupted. Even though I've made rulings, he's not respectful of the fact that I made a ruling, even though he disagrees with it.
How can you
I
make
attempted to bring the jury out.
How can you
and
utilize a
He
mute button?
continued to talk.
B, it's somehow
that's-
less painful
So,
than
Mr.
listening to
Brooks,
him.
You have forfeited your right to
Is
be
that-
present for the state's
Is that
closing
not,
argument.
Your
You
Honor?
will
Can
be
you answer
taken
this
to
question?
the courtroom next
As a
door, and I
public
will
servant,
invite you back over when it's time for your
You can't
closing
invite me
arguments.
back over. I can reclaim my right. So how can you invite me
All
to
right,
do
the
anything?
courtroom is to be cleared so that Mr. Brooks can be removed to the next courtroom, and I'll make appropriate findings when he's in the other
Yeah,
courtroom when I can
and you'll
do
mute
so
me, which you
without
can't lawfully do.
interruption.
she
You can't
can.
lawfully mute me.
She 100%
So now
can.
you're trampling over my First Amendment right.
Alex Martin, thanks so much for your super chat. Lawful law is just as annoying as what if any. yeah, I would agree. Interlocution, thanks so much for your super chat. Lawful law, ROFL. He thinks he can give the judge permission. This man is seriously needs a muzzle. Yeah, the thing is, he clearly sees himself as some sort of like equal to the judge, when in this situation, the judge is effectively like the king or queen of that courtroom. Like democracy, sure. Like we got democracy, but when you're in someone's courtroom, you have to play by their rules. Like regardless of constitutional rights, et cetera, et cetera. I mean, of course, like due process concerns, all that kind of stuff is always. But like, if she. Hang on. My mic is. Now, can you? Oh, here we go. Okay. Sorry. I get excited and then I start moving things around, and that's always when something gets unhooked. But obviously due process concerns are always going to be of relevance in these situations. But if the judge says you cannot interrupt proceedings or you will be kicked out, you have to abide by that. You absolutely have to. So that was insanely frustrating. And she probably didn't need to let that go as long as she did. It seemed like, this is now the afternoon. It's been a long day of arguing with this guy. I can see her getting somewhat worn down by him and all of the arguing back and forth. Then she had, however many hours of reading through those jury instructions. So I can see someone in her position getting worn down by today already by this point. So that may be why that took longer than maybe it should have, with the back and forth and the yelling and all that kind of stuff. But it's just,
I think the whole thing
bad.
reminds me.
I'm glad that she ultimately tossed him out, because it was very clear by his behavior that he was not going to be changing that.
Yeah.
What's left of the judge's sanity? Thank you so much for your super chat. Says, thanks to Brooks, I now believe in mansplaining. Yeah.
Something this all reminds me of though, is I like.
So it doesn't exist everywhere, but there are some situations where it does exist. And I have seen people, I know that he does have a criminal record. I haven't seen any footage from his previous court appearances. But I have seen some people say in various chats and whatnot that, what was I going to say? That he has been actually much more respectful to male judges. And that could be just a thing about this dude. Or it might be because he knows that this is a trial that is getting publicized and all that kind of stuff. Oh, do you need to go?
No. Look at the chat.
Oh, I can't. Yeah, for some reason I can't hear you. I don't know why. You seem to be self-muted somehow.
No, you have my mic volume down, I think.
No, I still can't hear you. Oh, wait. Oh, is it me? Is it just me? Can everybody else hear her? Hang on. Let me see here. Hang on. Let me fix this.
Can you hear me now?
Huh. For some reason. No. Okay. Let's see. Oh, you guys can totally hear her. Oh, I'm so sorry. Okay. Try again.
Hi. Can you hear me?
Oh, no, I can't. I still can't. Okay. You wait here for a second. I'm going to refresh and come back in. Okay.
Hi, everyone. Oh, thanks, everyone. I appreciate it. I wasn't muted. I think she just accidentally turned my mic volume up. Can you hear me now, Lita? I can't hear you, though. No. Do you want me to leave and then come back? Yeah, because I can't hear you at all.
Hang on. My mic muted
I can
itself.
hear you now. Can you hear me?
Okay. That was ridiculous.
Yeah. Okay.
Sorry, go on ahead.
Oh,
The court is back, but we can keep talking.
Yeah.
I'll pull up
Quickly.
the
The
feed
thing
again.
I had been trying to say though is this reminds me of when I worked with very profoundly mentally handicapped adults, and we had to take a conflict resolution class. And in that, we were told, when dealing with difficult people, the best way to do is when you ask them a question, you give them two options. It's like, Mr. Brooks, you can either stay in here and shut your mouth, or you can go to the other room. He asks questions, he keeps trying to push back. Mr. Brooks, you can either stay in here, or you can go and shut your mouth, or you can go into the other room. Like, this is just classic conflict resolution with difficult people, I think, is, it's very hard to deal with, especially when you're dealing it in a professional capacity wherein the judge has as much exposure that she does.
Yeah. Yeah. I was just thinking when you were describing that, I was like, it reminded me of learning lessons from my sister-in-law in when she had toddlers, being like, she would do the same thing, that she would go, okay, you can choose between this or this, which one? And then they would choose one of the two.
Yeah. And that's how it came with, as well as, like, for example, like lighters specifically, that was the, explanation example we were given in this training is, like, this person can't have a lighter. So you give them options, but you don't give them options. It's you can either give the lighter to me or you can give it to Alita. They fight back against you. You can give the lighter to me or you can give it to Alita. And you just keep repeating the same thing and you repeating the same options. You wait until they make the decision, and it like helps to shift the power dynamic back to where it should be.
Yeah.
And you can't, you have to stick to it. Yeah, there has to be consistency. This is like, you know, not anything you can go back and forth on. And that's the big problem as well.
Yeah. Yeah. And really what is going on. I mean, that's exactly what's going on here, is that he's trying to wrest power away from the judge here so that he can kind of control and manipulate this courtroom. And her struggle right now is to maintain that control within herself, because obviously he doesn't respect her. He doesn't respect the court. He doesn't respect the proceedings. And so, you know, where people would naturally give her the power and control in the courtroom, as is proper, because she is the judge, it is her courtroom. She has to, you know, use some kind of tactics like that to try to regain that composure, regain that power from them. So, yeah. Legal Drama Addict, thanks for your super chat, says, did the judge mute Natalie? Is she being held in contempt? You need to get this on the record, Natalie. No, I'm so sorry. Everything happened when the Fire Nation attacked. No, when I got excited and started moving my mic around. And then I have this little like loose wire that usually it just messes me up, because it like I have to like replug it in and then like it like does all these wonky things with like having the mic come in through like the wrong thing.
Courtroom, please.
But yeah,
We are back on the record. Appearances are as they were before, except that Mr. Brooks has been removed to the other courtroom. The court did that because
Wave your
we
arms,
came
Natalie.
out on the record at 2:00 following the lunch break. Mr. Brooks was brought to the main courtroom.
I did quote Avatar Secret Merc Squirrel. I did.
And during that almost 35 minutes or so, he was insistent on raising a variety of legal issues with which this court has either previously addressed or which are meritless and do not warrant any further response. He is insistent on making a record and an offer of proof. This would not be the appropriate procedural mechanism, meaning an offer of proof at this time. We are not in the midst of a trial where the court's made an evidentiary ruling that would require the preservation of the record by making an offer of proof. This court has been attempting, frankly, all day to get through the reading of jury instructions, to get to the point where the parties make their closing arguments, and ultimately to put this case in the jury's hands. It has been challenging. It has been met,
to say the least,
by resistance from Mr. Brooks. I would once again describe it as being stubbornly defiant, although at times he may wait for me to make my ruling. He continues to not respect the fact that a ruling has been made, and he wants to argue and re-argue and re-argue points that this court has already gone over. And in an effort to simply put him on notice regarding his behavior, given the history of this case, the court was attempting to set some parameters regarding closing arguments so that they are focused, so that they are proper, and that they follow the law. That was met with a considerable amount of resistance and repeated statements by Mr. Brooks that he has First Amendment rights, Sixth Amendment rights, 14th Amendment rights. He has all of those rights. That is not in dispute, but those rights do not come in a vacuum when we are in a court proceeding and a trial such as this. The rules of evidence, the rules of procedure, the rules of courtesy and decorum all apply. And this case has demonstrated that a stubbornly defiant defendant can forfeit even important constitutional rights by conduct. That includes the right to be present. It included the right to present further witnesses and testimony, and it included the right of the defendant to testify on his own behalf. I hope that I do not have to go through a decision that forfeits his right, or that makes a finding that he's forfeited his right to make a closing argument. I will certainly wait and see how that goes. I would note he was very respectful when he did his opening statement. It was clear. He made a variety of points. He did so in a way that I would say was very conscientious of people's time. It was cogent. It was concise. It was probably about 35 minutes. I may be off a little bit, but that's what my memory is. It wasn't overly lengthy. I would hope that he follows some of those same things here when he does his closing argument. But he has been removed from this courtroom because of his stubborn defiance and disrespect of this court, of courtesy and decorum. And what I truly believe is an effort on his part to continue to delay and lengthen these proceedings. I've said it before, I'll state it again. It is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. And trial courts and trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. They noted 3 constitutionally permissible ways to handle such a stubbornly defiant defendant. But they also indicated that no one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. I've noted this before. This is a case from 1970. The technology that we now have in this brand new courtroom was not available then. I have the ability to have Mr. Brooks appear from the other courtroom by way of audio and visual means. We can see him, he can see us. I've confirmed prior to calling the case that the audio was working, that the video is working. The one camera, there's 4 cameras in my courtroom, there's 4 cameras in his courtroom. However, it is set to 1 camera since he's the only individual there. Other than the bailiffs, but I'm talking about as a party to the litigation. So the courtroom, the cameras in my courtroom include one that would normally be on the witness stand that has been zoomed out so as to capture the large majority of the jury box. I even adjusted the camera that's on the state's table so that the exhibit that's currently up to my left, her right, Attorney Opper, is viewable in the camera angle, and she is still present with it, meaning viewable within that as well. And although I've made a finding that he has forfeited his right to be present for the state's closing argument, I'll find that the technology that I have available, it is that his appearance from the other courtroom is the functional equivalent of appearing in this courtroom and being present due to the technology that is available. I do have him on mute for the time being because I needed to make a record, and there is a very lengthy history with Mr. Brooks during this case of him talking over me and my inability to make an adequate record if I am in a constant back and forth with him and trying to talk over him. And so I, yes, made the decision to utilize the mute function on the incoming audio. I know he disagrees with my ability to do that, but I believe it is consistent with ensuring dignity, order, and decorum that when appropriate, he be muted. I will advise Mr. Brooks once again that although he has lost his right to be present in this courtroom, he can reclaim the right to be present as soon as he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. That includes not interrupting the court. That includes respecting when the court renders a decision by way of an oral ruling, even if he disagrees with it. So with that, I will advise him that once the jury is brought out, I will unmute him. I expect that he will be respectful of them, and I expect that he will not interrupt as the court goes through the couple of final jury instructions I need to go through, including the reading of jury instruction 160, closing arguments of the parties. And then I will turn it over to the state, but I will unmute him at that point. So should he have an objection, he will be able to state objection. I will be able to rule on it. And again, I expect him to honor whatever the ruling that is made. And if he does not do that, then I will utilize the mute function. If he doesn't have it, we'll make sure he has the objection sign. And if I see that, I will unmute him to hear what it is and then make a ruling accordingly. Attorney Hopper.
All right.
Two quick things. Please, could you confirm that the audio and video are working in the next courtroom? And the clerk's shaking your head. They've done that. Thank you. I don't know if you want to do it now or at a later time, but I think we should make a record, as I will be displaying a PowerPoint during my closing argument, throughout my closing argument, and I'm not sure how that is projected in the next room or how it affects what we see in this room, Your Honor, but we should make a record of that at some point.
Thank you. My understanding is Madam Clerk has the ability so that is displayed not only here, but in the neighboring courtroom. If you would be so kind as when you start displaying it, just make some type of record, excuse me, so that the bailiff who's over there, if it's not being properly viewable, if it's not viewable, that we can stop and adjust accordingly.
Okay. Thank you.
If you would like, before the jury comes out, we could do a test.
Yes, could we please?
Please.
Stephen Yarger, thanks so much for your super chat. It says, I wonder how this will affect future
Madam
cases
Clerk,
for
would
this
you
judge.
confirm with the clerk over there that the PowerPoint is also viewable?
They can see it.
All right, and it should be similarly to what we see. So the monitors will display the camera that Mr. Brooks is appearing, that is on Mr. Brooks on the left-hand side of the TV, and then the 4 cameras for this courtroom are on the right-hand side, but it's probably maybe a quarter to a third of the screen, and then the remainder of the screen is the PowerPoint. The monitors in the courtroom that Mr. Brooks is in are no different than what they are here. He would have one at the table, but there would also be the very, very large TD monitor above the clerk over there. Well, it's smaller, and then the very large one over the witness stand. So it would be very similar to what is here if he were present in this courtroom. And again, I know that the diagram, it's probably not the most easily seen from a camera, but it's really no different than what I'm looking at the moment. So I appreciate you asking that I make a record of that.
Yeah, court did
I would further make a record that there are headphones on the table where Mr. Brooks is currently standing. He has not put them on, but they are available should he want them. All right, then are you turning off all right, PowerPoint? Let us know when you need that function, and then Madam Clerk will be able to make that viewable in both courtrooms.
All right, because
very good. Thank you.
He has to be able
All right,
to
with
see
that,
himself
the
as well.
jury is to be brought out.
Okay. All right. Finally bringing in the jury. Okay. Stephen Yarger, thanks so much for your super chat. Says, I wonder how this will affect future cases for this judge, if she will be more accepting of outbursts because it's not as bad as this, or if this will cause her to have zero tolerance. I feel like she's probably going to have a lower threshold for clamping things down, just because of the fact that she probably has seen now how quickly things can get out of hand. I would expect her to get more strict. after this experience. Carolyn's reading Ramblings. Welcome to Bite Club. Thanks so much for becoming a YouTube member, and I hope you enjoy being a member of the club. Hopefully you can join us on Friday for our excuse me, Bite Club exclusive member stream. So, and King of Cringe, thanks for your super chat. So, speaking of tech, why do we hold archaic live action plays with a judge in a ceremonial dress and pretend the jury can magically erase things from their minds? Why not pre-record / edit for the jury? This is because all kinds of problems can happen when we are playing a movie, so to speak, for the jury, because things can be edited in different ways. You can have different angles. And also there's still something that gets lost when you're watching something.
Thank you, everyone. Please be seated.
As opposed to in person. So, we have the ability to see this live
Ladies
stream,
and gentlemen of the jury, when I read the jury instruction to you previously regarding credibility,
that people in the courtroom
prior version of the jury instruction. Now, what I read to you at the very beginning of this case was the most recent. I am going to read a short paragraph, but also tell you that in the packet that will be sent with the jurors to the jury deliberation room, it will have the complete instruction, and it's instruction number 300, excuse me. And this is what I want you to know about credibility. In your determination of credibility, you must avoid any and all bias based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. Consider carefully the closing arguments of the parties, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. With that, I will ask Attorney Opper to start with her closing argument.
Okay, here we go. Finally, closing argument.
And Madam Clerk, if you'll please turn on the PowerPoint. Yes.
Oh, hold on one second. Mr. Brooks, do you have an objection?
I thought I was supposed to be unmuted.
You are now. All right. Attorney Opper, you may start.
Thank you, Judge.
It's like the dog standing by the door.
Good afternoon, everybody.
No, I just wanted you to open the door.
Kind of nice to stand here in the middle of the courtroom, all week or the last 3 weeks. They shoved me at the end of the table because I'm the lefty in the group. It's nice to be able to look at you all and say thank you. Truly thank you. Each and every one of you. I want to express our sincere gratitude from the prosecution team, myself, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Woodshow. There's no one in this courtroom that does not realize the sacrifice that you've made serving your community in this very important task. You've put your lives on hold. I don't even want to hear from your bosses. Thank you. You've watched these proceedings and you've noticed as we sit at our prosecution table, we don't have a client at our table. But rest assured, we do represent someone. We represent the people of the state of Wisconsin. It's an entity. I can't bring it to the courtroom. People enact laws. People want to feel safe. People have representatives in Madison or Washington, D.C. that set standards, rules that we all are expected to live by. And when those rules are violated, prosecutors step in and enforce the law. Darrell Brooks does not represent anybody. He does not have a client. Darrell Brooks is the client. Darrell Brooks is the defendant. The state of Wisconsin is the plaintiff. It's really that simple. And it's consistent with any other criminal case you've ever heard about at any other time in any other jurisdiction. It runs the same. no matter what state or federal. I'm going to ask you for your guilty vote at the end of my comments. It's up to you. I can't tell you to do anything. Except
she's
I'm going to
definitely
say one
getting
thing
ahead
to you
of
that
some
I
of his soft sit arguments here just
wholeheartedly
by
ask you to
referencing
obey.
common
Sorry
sense.
for the interruption. Your
Jesus.
objection, sir?
Mischaracterization of who I am and the way it was said. I feel like it was talking down.
Your objection's noted. It's overruled. The statement continue.
It's an argument. It's a closing argument.
You must not.
She's allowed to talk down about him.
Not consider anything about Darrell Brooks other than his conduct in downtown Waukesha on the evening of November 21, 2021. Nothing he's done before that, nothing he's done since that. When you go back to that deliberation room, please obey Judge Darrell. Confine your comments to his conduct on November 21 of 21. Is he guilty of the 76 counts that he's been charged with? That and solely that should be your topic of discussion. So, what are the charges against Darrell Brooks? Thank you for your patience in listening to the jury instructions. They must be read for each and every count. But sadly, they can be summarized very quickly like this as far as the actual counts. Counts 1 through 6 are first-degree intentional homicide while armed with a dangerous weapon. Counts 7 through 67, first-degree recklessly endangering safety while armed with a dangerous weapon. Counts 68 through 74, hit and run causing death. Counts 75 and 76, bail jumping, and count 77, battery.
Whoa.
Mr. Brooks, what is your objection?
I have 76 charges, not 77. It's a mischaracterization of the charges.
That is correct. It is sustained. It should be count 68 through 73, I believe, and then 74 through 75, and then 76.
Thank you, Your Honor. I do apologize for my math skills.
All right.
68 through 73, 74 and 75 are bail jumping, and 76 is battery. I apologize for that misstatement.
It's a distinction without a difference is how I would
We're going to talk
characterize
about counts 1 through 67 in detail. Counts 68 through 73, hit and run causing death, in my opinion, are easily summarized as this. He never stopped. Never. Bail jumping, he was out on bail for 2 files in Milwaukee County facing felony charges there. He was ordered to not commit any further crimes. If you believe he was involved in any of the conduct charging counts 1 through 67, you should find him guilty of bail jumping. Battery, that relates to the split lip and black eye
Thanks for the
suffered by
super chat,
Erica
John O'Rourke.
Peterson. We told the story kind of backwards. We started with the battery for background. First-degree intentional homicide. You've seen this in our opening statement. You've heard it from Judge Darrell. Did Darrell Brooks cause the death of the victim, a victim? Did he act with intent to kill, meaning either the mental purpose to take the life of another or was aware that his conduct was practically certain to cause the death of another human being? Count 1, Ginny Sorensen. Count 2, Lee Owen.
I wish
Count
we could
3,
see the
Tamara Durand.
Well, I got.
Count 4, Jane Kulik. Count
she's probably
5,
going through the
Bill
photos
Hospital.
of these individuals, which
Count
would be very
6,
powerful.
Jackson Sparks.
Those are the individuals who lost their lives because of the conduct of Darrell Brooks.
Yeah. That's good.
From there, we go to reckless endangering safety. What is that? In this case, it means that through his reckless driving, he endangered the safety of other people. And he did so demonstrating utter disregard for human life. Now, behind me is State's Exhibit 15. It's also on the PowerPoint. If you choose, you may have this chart with you in the deliberation room to help you walk through each of these counts if you find it helpful. It's up to you. If you don't want it, you don't have to have it. But it will be available for you if you ask for it. And it'll take you, as we did in our presentation of the case, right down Main Street and address all the counts that were involved, all the counts that were charged. To prove reckless endangering safety, and I'm just going to go back one slide, nowhere do you see there that we have to prove any degree of injury to anyone.
Here we go.
Never once did Judge Darrell instruct you that somebody has to be physically injured. Now, Detective Casey told you that was the standard we used in deciding of all these hundreds of thousands of people who is included in these charges. And a decision was made by the prosecution team to include people who were physically injured to be efficient in our prosecution. And so everybody up and down the street, I would argue, had their safety endangered that day. I didn't charge 5,000 counts. We selected 61 counts of people that we can identify by name in Exhibit 15 that were injured by the conduct of Mr. Brooks. Those are the people in green. People in red are the fatalities. And we presented this case to you in much the same fashion that is presented here on Exhibit 15 as to how the injuries occurred going down that street. So we are absolutely held to our burden of proof and the elements for each offense that Judge Darrell instructed you on, but we are not required to prove any injury to anybody. The question is, was their safety endangered by his reckless conduct, his reckless driving? Now, some of the groups, it's pretty easy. They walked in a formation, and you can get a photograph or a diagram, and you can kind of see pretty easily who was located where, right? And you can think back to the videos that you've seen for each of these groups and remember, and you'll see them again, the path of the vehicle as it went through each of these groups. This is South Band, of course. All of these names that are being displayed on the PowerPoint Exhibit 21 are on Exhibit 15 in green for Waukesha South Band. Pretty much the whole left half of the formation was endangered by the safety of Darrell Brooks driving up the side of that band. The extreme dance team, it's a little difficult to read, but again, this chart was marked as an exhibit. It's exhibit number 33. If you want it, you can have it in the jury room. The names on this chart will match the names for the extreme dance team on State's Exhibit 15. All of the girls that were struck and injured as they marched with the extreme dance team, plus some people on the back that were handing out candy or serving in support roles as the unit made its way down the street. The dancing grannies,
State's Exhibit 54, the formation that they marched in, who was located where, and your recollection of how that SUV zigzagged through that group. And you can just see the names and match it up to who was injured and killed versus who wasn't. Now, one of the big things in this case has always been, why did this happen? What was he thinking? Why did he do this? Again, those are things I don't necessarily have to prove to you. His intent, I do have to prove, and I submit without any doubt. There's overwhelming evidence that this was an intentional act by Darrell Brooks and an act of utter disregard for human life. I say that for these reasons, folks. Number one, first and foremost, just stop driving. That's it.
Yeah.
It's really that simple. Not one person had to be hurt that day if he would have just stopped driving.
Excuse me, Attorney Alford, your objection, sir?
You specifically, I'm sorry, can I be heard?
Your objection, sir?
Oh, I didn't know if I was on mute or not.
You're not?
You specifically said in your jury instructions that intent cannot be, you can't look into someone's mind, I think is what it says, to find intent. So how could that be characterized as someone knowing for sure intent or not knowing for sure intent?
You're making an argument. You'll have an opportunity to do that later. Your objection's noted. It's overruled. The state may continue.
I
Boom.
apologize.
We showed you at the very beginning, remember our first witness was Sergeant Warner, the man who was the incident commander for the parade. We put up another map. I think it's State's Exhibit 1. You can have that if you want it. Shows all the positions of all the police officers and the reserve officers, the barricades, the squad cars. How do I know it was intentional? Because even Darrell Brooks told Detective Carpenter, I could tell something was going on downtown. No reasonable person would drive upon this area, see the squads with their red and blues on, see the officers in the street with their bright yellow vests, see all the people milling around, see the floats lining up and the participants getting ready, and not know to drive safely, slowly, and obey officers. The barricades help us prove it was intentional. The police presence help us prove it's intentional. The parade participants help us prove it's intentional. And the parade spectators help us prove it's intentional.
Excuse me, Attorney Alford, your objection, sir?
Speculation as to what the alleged defendant said he saw. It
Sir,
was never.
Your objection's noted. It's overruled. This is closing arguments, not the evidentiary phase.
Yeah.
Go ahead,
So
Attorney Alford.
how can speculation be made to what was saw? if
Your
that was never
objection's
testified
noted.
to?
It's overruled. Continue, Attorney Alford.
Honking the horn. Quite interesting that Mr. Brooks asked so many witnesses if they heard the horn honking. Some of them said they did at the beginning of the parade. Yeah, I heard a horn honk. Most of them said they didn't. The horn honking cuts both ways, folks. If he's honking his horn, that means he can see something's in front of him.
Yeah,
That means he knows there's an object in the road.
I would agree with that.
You can rely on your common experience in your affairs of everyday life. If you see something in the road and you want to alert the other person to your presence, you will honk. But you do not have the green light to then just keep going if they don't move. He knew they were there. Intent. I've skipped one. I'm sorry. Going back to my street number 15, I failed to include the Catholic community. That's just one of the photographs showing the people that will match up to Exhibit 15 from the Catholic community of Waukesha. There's a lot of photographs identifying the people that were marching with that group. The parade started. This is the starting point, or at least near the beginning, right? This is the area. We showed some videos of the groups passing by in this area. We heard testimony from 4 different police officers standing in 4 different spots near here, telling of their 4 different efforts to stop him. Intentional. Sergeant Wanners back here testified that this red SUV blew by me. I waved both arms over my head. I'm in a police uniform. I have an unmarked squad, but I have my red and blues on. And he blew past me. He gets down here to the corner where Detective Casey is standing. Detective Casey runs out into the street, gets close enough to put his hand on the hood of the car. He keeps going. He comes down, turns onto Main Street, gets in this area of East Avenue to the south and Buckley Street to the north. This is where he encounters Officer Schneider and Officer Buttrin. They each make a separate effort to stop him, and he keeps going. 4 police officers. It's intentional.
Yeah. That's some pretty good evidence for intent.
Opportunity to just stop anywhere along the way. One of the officers testified to it. I think it was Officer Schneider. This was an accident, and he mistakenly wandered onto the parade route after passing all this. And he mistakenly wandered onto the parade route. At any point, all he had to do was stop. They could have paused the parade. They could have moved the barricades and escorted him out. He didn't. It was intentional. He went on for 4 blocks. 4 blocks. It was intentional.
Yeah.
He reached speeds of approximately 30 miles an hour. That's intentional. He plowed through 68 different people. 68. How can you hit 1 and keep going? How can you hit 2 and keep going? How can you hit 3 and keep going? Didn't faze him a bit. He kept going until he got to the end, and there was no more bodies to hit.
Yikes.
It's intentional.
Mischaracterization of the evidence.
Nope.
Noted, overruled.
His conduct when he left the parade route. We'll get into this. His flight, his hiding, his panic, his desperation to run. Get the hell out of town as fast as he could before the cops came.
Ms. Amanda, that's not weak.
That shows his intent.
This is very emotional stuff.
His interview with Detective Carpenter, we spent several hours playing you snippets of that interview. How telling was that? Never once did he say any of these things. Never once did he say, like he told you in his opening statement, it wasn't an accident. It wasn't intentional. Never said that to Detective Carpenter. No, he came up with some convoluted story about, I got a ride out here from a buddy in a tan Kia, and then I left to go meet Erica, and we got into a fight, and then I went back, and the other guy got into a fight, and he was leaving, so I took off on foot. Absolutely nonsensical story. Does not match up with the known evidence in this case.
Overruled.
He never
I
stopped.
didn't even state the objection.
This is closing argument. She may continue.
I'm going to play this slide, which is a snippet from State's Exhibit number 53. Go ahead and play with sound, please.
Oh, it's so sickening with the cheerful music behind it.
That was just a snippet that I selected because I thought it really captured the environment that so many witnesses tried to explain to you, right? It's a Christmas parade. People are there with their families, their little kids, their grandkids, their neighbors, their friends, strangers, standing next to strangers. That's what's going on Main Street. While that's going on Main Street, this is going on.
This makes me want to hug
Remember
my
this?
family so much tighter this Christmas.
This is the gas station on the corner of Barstow and North Street.
For some reason, the Christmas music is what got to me.
While the units are marching down Main Street, entertaining the crowd, Darrell Brooks is driving recklessly. He's enraged, and he's arguing with Erica Patterson. Why is this important? This is important because before he even gets to the parade route, this is how he's driving. He drives the wrong way down North Street and then acts like it's everybody else's fault in the world.
Your objection is noted. It's overruled. You may continue, Attorney Opper.
When he finally pulls into the gas station, he rolls down his window and yells at the driver who's properly stopped at the stoplight that it's somehow that guy's fault that Darrell Brooks is trying to drive the wrong way down North Street. And from there, the rage continues. We get to this point, State's Exhibit number 3. Please play. The video is playing. You can see the pushing match between Darrell Brooks, Corey Runkle, Erica Patterson, and Nick Kirby. Watch this. He turns to get in the car, flips up his hood, and goes and gets in the passenger seat. I'm sorry, driver's seat.
How long are we gonna mischaracterize testimony?
Sir's argument, I've heard nothing improper. Your objection is noted. It's overruled. You may continue, Attorney Opper.
Thank you.
They need to know they can nullify.
That's it. He drives off onto the parade route. From this moment, right here on Exhibit 15, you're watching it. He's enraged. He's angry. Flips up that hood, and he zooms past Sergeant Warner, past Officer Casey, onto the parade route. Now, there's no doubt for the first 2 blocks, he does not strike anyone. And as we've discussed, some even said he was driving at a reasonable speed initially. By the time he gets past Officer Buttrin and Officer Schneider in this area here of East Avenue, past East Avenue, and clearly once he gets past Barstow, that's where it starts, right? That's where it starts. Nicole White, our first victim, walking with Remax and a hot air balloon. Knocks her over, keeps going, runs up and over the backs of Waukesha South Band, hits the green children spectating on the sidewalk, keeps going, runs over Kelly Grabo and her daughter Adelia, walking with Burris Logistics, keeps going, plows through the entire extreme dance team just before the 5 points, keeps going, hits Deborah Ramirez and her son Isaac spectating on the south side of the street, keeps going, clears the 5 Points area, hits Jane Kulik square on,
God.
causing her to go up on the hood of the car, and then fall off and drives over her body. He doesn't stop. He keeps going. Runs through the kids over by the steaming cup. We heard the parents testify about little Brinley and Kelsey and Owen that were standing there outside the steaming cup. They were struck by the red SUV driven by Darrell Brooks. Keeps going. Plows through the grannies in that zigzag fashion, striking most of them, injuring them, killing them, keeps going, gets down here to the end, and goes through the Catholic community. The witness, remember Holly Berg, she testified about that mobile gas station incident. She said she was standing down here in this area. She said, I saw 15 to 20 people fly in the air. They looked like bowling pins. And when you saw the video, she's absolutely right. It's a terrible description when you think these are human beings, but that's exactly what it looked like. When does the intent exist? Doesn't have to be even for a second. I'm not telling you who set out that morning
Right.
to cause this carnage.
Right.
But when he became enraged back here, he didn't give a damn who or what was in his way. He intentionally went on. I'll show you. Motive. I don't know why he did this. Folks, I don't know why. Other than the rage.
Nathan Gross, I agree. The fact that she repeated, keeps going, keeps going, keeps
He's
going,
right.
keeps going. That's really
You
great
cannot
repetition.
read minds. Neither can I. But the law doesn't require you to. The law gives you a way to reach a conclusion as to what is somebody thinking. And it's right here. Decide it based on his acts, words, and statements, and from all of the facts and circumstances. I've already been through many of them. I want to show you what I mean. Look at this. Was there room for him to get out? This is way back at the beginning. This is Officer Buttrin's squad video. Way back at the beginning. That's Buckley Street here that you're looking at. Look at those barricades. Look at the sparse crowd. And there's Officer Schneider in her yellow fluorescent vest on the left side of the picture, about to run into the street and stop him. Intent. I'm going to play this video for you because, folks, for me, this is where it becomes crystal clear. You watch this video, the first thing you're going to see, if you direct your attention to the left side of the screen, is you're going to see him hit Nicole White.
Oy.
Knock her to the ground and keep going. Now, if that was the end of the story, you may sit here and say, Madam DA, I don't know how you conclude intent from that. Maybe it was an accident. Maybe he didn't mean to do it. But watch what happens in this video after he knocks Nicole White down and tell me this does not prove intent. Please play.
Yeah, I guess they're not going to show it to us, which is fine.
Keep watching the left side of your screen.
Oh my God. Oh my fucking God.
Even just hearing it.
That's intent, folks. No reasonable person is going to come across a group of teenagers playing band instruments, drive over them, and keep going. That's a still shot of the same thing. That's intent.
I'm sorry to interrupt your objection, sir.
How can you tell the jury what they supposed to think?
It's proper argument. Your objection's noted. It's overruled. You may continue.
I would argue that it's, I would say that it's improper, and I move
Mr.
for a
Brooks, I've made
mistrial.
my ruling. I'm going to mute you if you don't follow the rules.
Exhibit one.
His objections are so
Exhibit
not helping him.
152.
It just makes him look even more
Clearly
callous.
intentional conduct. Clearly intentional conduct. States Exhibit 93.
Jeez.
We asked the court to take time to have you go look at this car in person because it's remarkably amazing that this damage was caused by human beings. That's intent.
God. If that's how the car looks, how did the people look afterwards?
This is an excerpt from States Exhibit 154. Maybe a little hard to see. A lot of that laying in the front part of this photo are shoes. Remember what Dr. Vidritsky said about the shoes and the feet, the scuff marks on the toes and the ankles? Look at all the shoes laying in the street. This is the area at the end when he ran through the Catholic community. All the shoes laying there because of the velocity. Remember, the medical examiner talked about the velocity. It's not just the speed, it's the velocity. The power that these people were knocked right out of their shoes. That's intent. The flight, the hiding, changing his appearance. He had to go through some effort, right? Crawled up in this playhouse, ditched his sweatshirt and his sandal. The other sandal seems pretty reasonable. He dropped it when he was jumping over a fence. Changed his appearance. Please play.
Yeah, I appreciate that they're not showing the graphic kind of video, but
Excuse me.
they're showing the other stuff.
Intent. What's he running from? What's he running from if he's just a lost guy with no ride back to Milwaukee? What's he running from as there's cops, sirens wailing in the background? Whoops, that was me. So, States Exhibit number 130. Put that up here quickly. Take this one. Thank you. I'm not going to go through this whole thing, folks. Suffice it to say, after Officer Skolton tried to stop the threat at that intersection at the top, Wisconsin Avenue, and he blew through the barricades there and drove south on West Avenue over to Prospect Court, cutting through the yards and ditching the vehicle on Maple. Heard all the testimony about the commotion on Maple. The eyewitness testimony from Officer Sailors, off-duty police officer who saw this, saw the defendant, Darrell Brooks. He identified him for you in this court. Get out and run from this car. And how we tracked him through the neighborhood. And again, the desperation, whether he had to ask or use veiled threats like, I won't hurt you, but I need your phone. He was absolutely desperate to get out of there until he took refuge in the home of Daniel Ryder. Now, remember the interesting thing, folks. None of these witnesses in this area knew anything about what happened at the parade. None of them. None of them were there. None of them were there. So some of them tried to help, some of them didn't. Daniel Ryder did, and it's actually probably a really good thing that he took him in because it stalled, right? It stalled them from keep running, kept them in one place until the cops could close in and get there. Now, Mr. Brooks repeatedly asked witnesses who had just watched their loved ones get struck by this SUV if they happen to catch a license plate. State's Exhibit 150, there's the front license plate. Definitely a little blurry, but definitely you can make it out. State's Exhibit 151, there's the rear plate. State's Exhibit 175, there's Darrell Brooks in his music video with the same car and the same license plate. There's the key to the Ford that was found in Darrell Brooks' pocket. There's no doubt Darrell Brooks is the person responsible for this. Because this man in this picture is the same as this man in this picture wearing this sweatshirt. And again, it's a little hard to see, but you can ask for these exhibits in the jury room if you want. The photograph, you can see this design on the front of the sweatshirt if you look close enough. This is a sweatshirt from the play set that has Darrell Brooks' DNA on it, according to the crime lab. That's him right there. That's Darrell Brooks driving off into the parade. That's Darrell Brooks driving in the parade. That's Darrell Brooks driving in the parade. That is also Darrell Brooks driving in the parade. And so is that. And he kept asking people about the tints on the window. Well, guess what, folks? You don't need to see the tints on the window when the windows are rolled down. And there's clearly one person in that vehicle in every one of these photos. And it's that man. And it's that man. And it's that man. Darrell Edward Brooks Jr., date of birth 2/21/1982, on his identification card issued by the state of Wisconsin. In all capital letters, Darrell Edward Brooks Jr. This was in his pocket when they arrested him. So this entire shenanigans that he's presented to you through his questioning of witnesses about, I'm not Darrell Brooks and that's my name and I don't know who that is and I don't consent to being called that name. It's just nothing but a distraction. It's Darrell Brooks.
Yeah.
It's the man who drove through the Waukesha Christmas Parade and killed people, injured people, endangered the safety of people.
I'm sorry, your objection, sir?
I don't consent to being called that name.
Your Honor, with all due respect, I would appreciate the quote unquote language what does she mean by shenanigans and this and that and the third?
It's closing arguments.
Sir, your objection's noted. It's overruled. The state may continue.
Well, can she tone that back? Because if that was
Nope.
me, if I would have said
Mr.
something
Brooks,
like
your
that, it would have been a
objection
problem.
is noted. It's overruled. These are closing arguments. There's
I
nothing
just-
improper. It's noted. It's
wanted to-
overruled. She may
I
continue.
just wanted to be
Yep.
clear.
You'll have an
No.
opportunity
No.
to respond, sir.
Closing
Please
argument
let her
is
finish.
where
So I can-
everything can
I can
fly.
rebuttal?
Where you can get as argumentative
ahead,
as you
Attorney
want.
Alford.
You
Thank
can
you.
get, you can
I'm
pull
going to
out
conclude
full
my
on
comments
hellfire
with this,
damnation.
folks. I'm going to show you the video, a stitched together video of all the carnage caused by Darrell Brooks, and I apologize.
It's together.
This is important that you know what he did. It's important that you think about the women like Nicole White and Kelly Grabo and her daughter and Jane Kulik, who were just there with friends and co-workers supporting a local business.
Yeah, and I think her tone is
The
actually very
teenagers
measured
marching
here.
in the band, representing, wearing their school colors. It's important
The boys and girls with the Blazers baseball team and their coaches doing nothing more than handing out baseball cards. The young girls in the extreme dance team. Can you imagine how many hours they spent practicing that routine? He drove right through them without a care in the world. The grannies dancing their way down the street, perfect step, every one of them. Catholic community there, as Father Matt said, spreading the light of Christ in the weeks before Christmas. He snuffed it out. It's time for Darrell Brooks to stop running. It's time for him to stop lying. It's time for him to be held accountable for his actions. Darrell Brooks cowardly rammed his way through this parade, violently killing and injuring so many people. I'm going to stop talking and play this video, but please, I ask you to add up the evidence, use the map, 15. You can check off the names. We've covered them all. Walk down that street like we did with you. Return guilty verdicts on all counts. Please. Please.
Screen back up.
No, I need one more. Yes, please. Go ahead.
Yeah, I think she's had a really good tone throughout this closing argument. It's funny that he's, asking, can she tone it down? Number one, this highlights to the jury, that she's being very effective and he doesn't like it. There is such a thing as over objecting to certain things. And sometimes it clues in the jury that you don't like something. But I mean, it's she has had a very, very even tempered kind of tone, which is, she probably could even dial it up, to be honest, because she's been so measured. But I don't think that she should change anything. I think that she's done a good job of it, because I think that the facts in the case are horrific enough that they can speak for themselves. The video can play for itself. And so I think that she has been playing her tone very well in light of that, and in light of the fact that she's presenting herself as the mature adult in the room, which is not a hard thing to do in comparison to Darrell Brooks. There were a couple points where has some sort of communication with, I guess, her clerk or someone who's working with them that's helping with the slides, where she kind of smiles and smirks and kind of like laughs a little bit. I could have done without those to sort of like keep her in the emotional moment, but maybe, I don't know. I think even with that, it's probably okay. And it sounds like someone is crying in the courtroom. That could be family members in the courtroom. Yeah. Yeah, it could be a juror that's crying. But someone is definitely audibly sobbing. So this has very much affected people in the courtroom. And even if it's not a juror that's crying, the impact that can have on the room, to hear that even from the gallery as well.
Thank you. Before we continue with Mr. Brooks's closing
also
arguments, I'm
something.
going to take a short break. All rise for the jury, please.
Am I muted?
No.
The jury should know that they can nullify.
You are muted now.
Yeah, go ahead and try with that argument. See how it works out for you. It's not going to work.
Thank you. We'll be in recess for about 10 minutes.
Okay. 10-minute recess. Camera's watching the camera. Is it cameraception? So, yeah, I think after a closing argument, it's common to give a break in between anyway, but I think given the emotional affect that resulted from it, that sounds like something that was also just necessary for the situation as well. Man, that was a very effective, decent closing argument. Could it have been, smoother, shinier? Sure. Okay. But I think really she did what she needed to do. Like she didn't really need to do too much in this particular case. Putting everything together, putting the pieces together so that they fit, so that all of the elements are met here for all of the charges, and to really show the carnage of that day, and to really hammer in the intent aspect also, to show the circumstantially how they could show the intent. The fact that they showed the barriers, they showed how people were lined up along those barriers. She went into how many different police officers tried to get him to stop, barreling through not one, not two, not three, not four, but like 60 something people. That's pretty clear that he had some level of intent, I think. And so his I don't know. I don't know if he's gonna end up getting a chance to do his own closing argument, because if the first thing that comes out of his mouth is jury nullification, jury nullification, jury nullification, the jury needs to know that they can nullify the verdict. The judge is going to have a very intense back and forth with him, probably just to again show that she has made every reasonable effort to put him, to give him the opportunities that he is required to have, that he's entitled to under the law, and then to make a very strong record saying, no, he's not following the rules of the court, even though I've been giving him multiple opportunities to come in and to act properly, and so that he can get his day in court, so he can get his reasonable opportunities to represent himself in court. And when she doesn't, or when he doesn't obey. Sorry, it's a little late for me now at this hour. But when he doesn't obey by those rules, and he's showing through his conduct and through his words, even in his interactions with her, that he has zero intent to do so, he makes it very, very clear that he's not going to be respectful of the court, and he's not going to be respectful of the judge, and he's not going to be respectful of the jury either. So, yeah, So that closing argument was, I think, time-wise, I think everything that it probably needed to be. I don't think that there was anything that they needed to add to it because, like I said, when the facts are as horrific as the facts are in this case, you don't need to lay down extra emotional uh armor to it, because it's already there. It's already awful, awful, awful. Um so yeah. Let me get to some super chats here. Kate Leslie, thanks so much for your super chats. I just wanted to say how much I love and appreciate this community. Alita, you're a treasure for bringing us together. Thank you so much. And yeah, no, this community is wonderful. I mean, the fact that we can watch, this kind of craziness and then this kind of a closing argument together and really kind of come together in our emotions, feel our emotions, process everything all together. There's a wide range of these things, right? Sadness, anger, um there's a lot, and we're going through all of it together, and I really appreciate everybody in this chat for helping to create an experience where we can all just sort of experience this together in a hopefully relatively healthy way, right? Stephen Yarger, I second what Kate said. Thank you so much for the super chat, and yeah, no, I agree with you. Maria, thanks for the super chat. How can he not cry while watching this? I don't know, man. It's someone who seemingly doesn't have remorse, or at least is not showing remorse. I did see his opening statement in this case, and he seems to be getting a bit emotional there. And it looked to me to be genuine emotion. So maybe there is some remorse, but he's just so caught up in his fight with the judge that he just has no like mind for the things that he has done in this case. I don't know. I don't know. FV, thanks so much for becoming a YouTube member. Welcome to Bike Club. Really appreciate you supporting this channel, and I hope you can join us on Friday for our next Bike Club member stream. John O'Rourke, thanks so much for the super chat. Says it's easy to sit and nitpick, but the DA found an emotional trigger in the courtroom. Claps. I think is what we wanted, which is weird to want. Yeah, no, I completely agree with you. At the end of the day, she did get to that emotional zone, which you can tell there was audible sobbing in the courtroom. People were affected by it. And this is one of the things that I was kind of starting to get into this earlier, but we're so lucky today that we are able to see these trials get live streamed like this. Obviously, I wish that more of them would be, but when we do get to see them, we're able to see the court process. We're able to see the way that the judicial system actually works. Some of the problems that can arise, some of the issues that people will have at various levels. But sometimes, there are limitations to it as well. And sometimes we do get certain pieces of it that get lost when we can't be there in the courtroom ourselves, even if we can see. Even if we can see everything, from gavel to gavel, because, we're limited by this lens, but Natalie Wisco was on the stream earlier. I remember when I talked to her after the Kyle Rittenhouse trial. I remember when she was telling me, I asked her about when Kyle Rittenhouse testified, and she said that when he was getting very emotionally affected, all you could hear was him, breathing heavily and crying and sobbing. But then beyond that, there was nothing. Like, you could hear a pin drop in the room because it was as if everyone was holding their breath And it's something that sometimes, like I said, it can get lost, right? Because it's like, it can be the air conditioning unit on the wall that suddenly you can hear, which you couldn't hear all day because of how many people are in the room. Because, even just the little shufflings of paper and, people like moving around in their seats, like all of those things kind of contribute to the noise in the room. But when everything is like completely silent in the courtroom and it's a packed courtroom, it's because everyone is laser focused on what is happening. And because like they are very, very emotionally attached to what is happening in the courtroom as well. So it's something that I wish there was a way to capture that on a live stream, but we're limited. So but very thankful that we can do what we can. But I do agree. I think that she to bring it all back to the super chat, this prosecutor bring it right into that emotional zone that she needed to. So interlocution, thanks so much for your super chat, says here's an extra bonus for your patience. Oh, thank you, I really appreciate it. Yeah, I still have that poll open from earlier. We'll see what happens, but if that sobbing was coming from a juror, this conviction is going to be happening very quickly. For sure. Okay, well, let's get into the chat a little bit. We'll just kind of hang out for a bit. So Tuloco16 says the kids were getting to him during evidence. I honestly thought he would plead guilty and be done. I was wrong. Yeah. It would have been better for him to try to come to some sort of a plea deal or something, because I don't see any of his efforts actually resulting in anything positive for him. Okay, Leslie, I need a drink. Yeah. This is one of those trials where you end up kind of wanting to just give a massive hug to all of your loved ones, right? Chet Moneyford says, how long before he gets kicked from his closing? I don't know. This is something that is, if he goes right into jury nullification, I don't know how this judge is going to handle it. Yeah, I don't know. Felicia Nolvi says, has anyone covered the reason for him to defend himself? Yeah, we were going through earlier a clip where, oh, excuse me. I'm so sorry. I'm not bored. It's just like super late for me right now. So he was talking about how basically he was unhappy with his counsel at that stage, and so he wanted to represent himself. And Natalie was here also earlier. She said that this is what she's come to understand with SovSit clients, is that they typically tend to think that no one is going to represent their case better than they will, because they're the ones that have their skin in the game. They really don't trust the system, and so they really don't trust any of the attorneys involved in it. So that's why they would want to represent themselves. But, and he has a right to do so long as he's competent enough. And so the judge went through that with him to make sure that he actually is, that he actually understood the consequences of him representing himself, as opposed to having an attorney represent him. And she went through the fact that these are two competing interests that he has, that he really can choose from at the end of the day. Shireen, I think the fact that she was brief and kept it to the evidence was good. I agree. I do agree with that. Because there's no need to drag the process out longer than you need to if you can make your effective argument in fewer words. So, all right. Yeah, Chris's error. His defense is completely bizarre. I would agree with that. So, all right. Yeah, we should be hopefully getting something back soon. Thomas Harkins, the paperwork of reading through everything is going to take 2 hours, but guilty easy. Yeah, probably. Yep. Seneca Narrow, jury nullification. Just let him walk. No jury in hell will do that. No way. No way. Not a chance in hell. Not with the very emotional argument that was just very effectively made. No way. Maria says, how hard must it be as a lawyer or judge not to cry watching all this evidence and watching and hearing people cry? Well, you could see the attorney next to the one that was delivering the closing argument. She looked like she was a little glassy eyed, right? She looked like she was really holding back some emotions there. So I obviously lawyers and judges are also human and they're also very immune. And that could be another reason why we've got a little bit of a break right now, is because maybe the judge needs a minute to compose herself, because this has been a very trying experience for her. And I mean, how could she not be affected by this case? Right? How could she not be? I mean, especially when you are someone that is in the room there with the jury as you've been, as you've been going down this journey by observing witnesses testifying, giving their very emotional stories. It's a lot to deal with. It certainly is a lot to deal with. So compartmentalizing is basically the best way to do it and keep moving on, but allowing yourself some time to decompress backstage or in judges' chambers could be one reason or one way to do that. And then coming back and having your judge face on. I'm not saying that she's definitely doing that, but it wouldn't surprise me if she was getting emotionally affected by this, because this is something that is legitimately emotional here. Toloco 16. What really pisses me off is that this clown has effectively shifted the trial from justice to the victims to what shenanigans is Brooks going to come up with. He's done now. Yeah. Yeah. Kate Leslie, I would probably be a lousy juror because I'm a crier. No, actually that's jurors are allowed to cry. It's, if you are feeling certain emotions as a juror, it's because of most likely because of the actual evidence coming through and impacting you, right? I mean, we want jurors to be human. We want jurors to have emotions and to feel those emotions. And to obviously balance those emotions with the logic of what they're supposed to do, in terms of meeting every element of every crime. But where the evidence is pretty overwhelming and it's very, very emotional, I wouldn't blame any of these jurors for getting very emotional at this stage. Patrick Collier says, it seems like jury nullification is probably something he heard in lockup and he thinks it will get him off. I think if he explained it for an hour, there's no way they nullify the verdict. Agreed. if he just says nullify the verdict because you can, I don't see him giving any legitimate reason for the jury to want to nullify the verdict, right? Like if you're going to make that kind of an argument, there should be some kind of very strong emotional argument that you're going to want to make so that they actually take that route. He has offered nothing to them in this entire trial for them to make that sort of emotional decision. So I don't know how this is even going to go, but looks like he's back in the courtroom and they're probably waiting for the jury to come back. And for the jury to come back and sit in the jury box so that he can do his closing argument. I don't know. I don't know how this is going to go.
Or the record should reflect that Mr. Brooks is now present in the main courtroom. Prior to reopening following the break, I did invite him back into the courtroom, and he is here. I trust you are ready with your closing argument, sir.
I'm ready to address subject matter jurisdiction as well, too.
Oh, no.
That request is denied.
Just for the record, I was addressing it for both courtrooms here in courtroom number, I think it's 20.
Mr. Brooks, I'm going to bring the jury out. Are you prepared to present your closing argument?
Oh, thanks, Secret
I would
Maxwell.
like for you
I'll
to
check
prove
it.
subject matter jurisdiction on the record, Your Honor.
I'm not addressing that any further than I've addressed already, sir. There's a written decision. I remind you of that.
In that written decision, did I receive, well, actually, I didn't receive anything. Was there copies made?
Mr. Brooks, I'm going to ask you one more time. Are you prepared with your closing argument? I'm going to have the jury brought out. There's no other legal arguments I need to address from you at this time.
I'm informed of what you're saying. I was merely asking, was there copies made of your, you said written decision?
Sir, my written decision has been filed into the record. That is done electronically. You were provided with a written copy previously. Are you asking for another copy of that, sir?
Yeah, because I don't have it.
As a courtesy, I'll have my clerk print off a copy and provide that to you.
Is it proven subject matter jurisdiction?
Oh, my
Your
God.
objection to the lack of jurisdiction has been noted repeatedly on the record. It is a meritless argument. I've indicated that in my written decision as to why there is subject matter jurisdiction, and I will continue forward with the final stages of this trial, which I hope include your closing argument and then the final instructions to the jury.
I would hope it proves subject matter jurisdiction on the record too.
All right, I will instruct the jury to come out. For the record, the written decision is once again being provided to the
I
defendant.
accept for value and return for value this document as it is not based in lawful law.
Oh, jeez.
And it does not prove subject matter jurisdiction whatsoever. Refers to some complaint that was filed in the name of a trust, not my name. Were you aware of that, Your Honor?
Oh, God.
Mr. Brooks, the jury has been asked to be brought out. I mean, I've requested that they be brought out. They're on their way.
Were you aware
Please
of
be
that?
prepared with your closing argument.
Were you aware of that, Your Honor? Or is that a tacit agreement that you don't have to answer any questions as a public servant?
Oh, Jesus.
All rise.
So that is a tacit agreement.
Record to reflect the jury is coming out.
Yeah. Just because, thanks so much for your super chat. Says, I've said it before, but there is no defense. There's no defense for his actions, and there's no effective defense in this case. I agree. I definitely agree.
Thank you, everyone. Please be seated. Go ahead, sir. You may begin your closing argument.
I'm not ready to begin closing arguments.
Oh.
So this is your opportunity to provide your closing argument to the jury. Please start. I've started the timer of 1 hour.
I'm informed of that, Your Honor, but I'm not ready to proceed as I don't understand the reason why the questions asked before the jury was present were not answered. There are issues that needed to be addressed outside of the jury, as you always say, which I don't understand why. The jury deserves to
Mr. Brooks, this is your opportunity to present your closing argument to the jury. Please do so.
I'm informed of that, but the jury needs to understand the truth, their rights, and their duties, as they have not been informed of their truth, their rights, and their duties.
Mr. Brooks, the court has begun the instruction process. I read 73 pages this morning, and into the early afternoon, I have another 30 plus pages to read.
Did you inform
They will be informed of the law.
Did you inform them that they can
Mr.
nullify the law?
Mr. Brooks, you do not have that right to request that. And
Were
I'm
they
advising
informed?
you one more time, this is your opportunity to provide your closing argument. Please begin.
I intend to when ready. I just
He's
want to
about
know
to
if
lose
the
his
jury was
opportunity
informed
to close.
that they can nullify the law.
Mr.
they
Brooks,
are-
you
that
have
they
no
have
right
the
to
power.
make that argument to the jury.
It's true. They have the power.
Oh, all right, I'm going to excuse the jury.
They should know that they have the power.
Please rise for the jury.
Well, there's not even any putting him in the other room anymore. I mean, except for she said that she still got some more jury instructions to go through. But he's supposed to be giving his closing argument now, and he's saying he's not ready because he wants to argue about these other issues about jury nullification and subject matter jurisdiction, and all this other bullshit.
Thank you. Please be seated.
She's about to tell him
Brooks,
that
you do not have
he's not going to be able to do a closing.
To request jury nullification directly from this jury. I direct your attention to the Bjerkas case, BJERKASS, that's State versus 163 Wisconsin 2nd 549. While you are not incorrect that the jury has the power to nullify, they don't have the right to do so, and no party has the right to instruct or to request an instruction or to argue jury nullification. You may talk in terms of fairness in general terms, but you may not go further. You may not argue that the jury should discard the instructions in the law and find you not guilty for that reason. You may not use the phrase jury nullification. You've done that now at least 3 times in earshot of the jury. Twice while you were in the other courtroom, I was able to mute half of what you said the second time. And then, of course, you raised that once again while in front of the jury just now. You also indicated you weren't ready to give your closing argument. Sir, the time has come for you to give your closing argument. If you choose not to do so at this time, then you will forfeit your right to present a closing argument by your conduct.
Mm-hmm.
I haven't made any such choice. So you can't coerce me into a constitutional right waiver when I have not waived the constitutional right. And I will not allow you as a public servant to do that. I have not made a choice.
Sir, the time has come for you to present your closing argument.
Are you making a judicial determination that you're denying me a constitutional right?
No,
I have not made such a determination as of yet, but you can forfeit.
Yeah, the judge is going to say she's denying you my constitutional right. Jesus.
Illinois versus Allen, State versus Anthony.
Illinois versus Allen does not reference anything pertaining to rights when talking about
in
closing
State versus
statements.
Anthony,
Illinois
the Supreme
versus
Court
Allen.
of Wisconsin referenced both that decision when it essentially extended the reasoning or adopted the reasoning of Illinois versus Allen to then find that a defendant could forfeit an important constitutional right by conduct. In State versus Anthony, it was not the right to be present in the courtroom, it was the right to testify.
Okay, so none
And
of those
the
that you just
reasoning-
named have anything to do with the closing arguments, Your Honor. You've used Illinois versus Allen repeatedly to when it comes to me being removed
That's
from the
because
courtroom.
it's not
one
just
time did it
about that,
bring
dude.
up anything dealing with a closing statement or a closing argument. So how's that same
This is when someone
statute
doesn't
being
understand
used for
that reasoning
something
can
that it doesn't
apply
even
in
refer
multiple
to or pertain to?
circumstances.
Mr. Brooks, the Allen decision, Illinois versus Allen, and the Anthony decision, which is State versus Anthony, are two examples of cases where a defendant lost a very important constitutional right because that right was forfeited by the conduct of that particular defendant.
And that was to be present in trial, correct?
The right to present a closing argument is no different. Because it is not evidence, it could be said that it doesn't even rank as high as the right to testify, which is guaranteed by the Constitutions.
Which I was denied the
I'm
right
not prepared to
be
make
able
that ruling
testify to.
here yet today, but I will tell you this, sir. The time has now come for you to present a closing argument.
Yep.
There will be no further delays.
It's
I
not a
will not
delay.
be taking any further adjournments for you to prepare. You were advised yesterday that this court would proceed today with instructing the jury and with the parties making their closing
And you
arguments.
made that while
It is
violating
up-
my constitutional
Sir,
right.
please don't interrupt me because
Well,
you've now
you did.
interrupted me a couple of times.
No, once. So let's
Twice.
make that correct. Once.
Jesus.
That's the third time.
Okay, now you can say
So, Mr. Brooks, I'm advising you yet again, the
I
time
don't
has now
consent to
come.
being called
That's
that name,
another
Your Honor.
interruption. The time has now come for you to present your closing argument to this jury. You were
And
brought back over to this courtroom for that purpose.
I'm going to let them
That's
know.
another interruption.
No, I'm going to let them know that they have rights and they should be told, informed of the truth. It's not me
Are
trying
you
to
telling
give.
me, sir, that
It's
you are
not trying
going
to
to
give.
let me ask you a
No, hello.
question.
I'm not trying to give any
Sir, you're
jury
interrupting
instruction.
me and you haven't let me finish. So are you telling me that you are going to disregard my very clear directive to you to not bring up the topic of jury
I
nullification?
appreciate you guys in the
That's
chat
not what I
keeping
said.
track of the interruptions.
That's why I'm asking you.
I don't understand that question because that's not what I said.
Sir, you may not argue jury nullification
I'm
to
going
this
to
jury.
inform them of the truth.
So you're going to inform them that they have the power of jury nullification.
They do have the. You just said on the record that they have the power for.
Sir, I direct your
You
attention.
just said that.
once
Did you
again.
not just say that, Your Honor?
Sir,
You
the
said I couldn't
jury-
instruct them.
The jury
on
has
that.
the power, but not the right to nullify.
Right.
A
You said the
party-
power. You said the
Listen
power.
to me, sir. You're interrupting me once again.
So I'm going to inform them that they have the power.
Are you telling me, sir,
I'm
that
not
you are
telling you no
going
such
to
thing. I just
disregard
told you what you just said.
my directive to you to not raise the issue of jury nullification during your closing argument?
That's not what I said. You just read and said that they have the power to. That's what you just said, Your Honor.
Sir, State versus Bjerkus says and stands for the proposition that although the jury has the power of jury nullification,
They have the power.
no party has the right to argue for jury nullification.
I'm not arguing for it, Your Honor. I
In
just
that
want them to be
case,
informed. I just want them merely to be
You
informed.
can
That's it.
call it informing, making them aware.
Yeah,
Whether
they should be aware
You
of
are
it.
not allowed to make them aware of their power to nullify. That is
can I
an
not make them-
improper argument.
Your Honor, how can I not inform them that they have a power? How
Because
can I
that
not
is not a
inform them
right
of a
that
power
you
that they
have, sir.
have? I'm not giving a new jury instruction.
That is
That's not
because
what I'm
there is
arguing.
no jury instruction for jury nullification,
Yeah, I'm
sir,
not- I'm
because
not-
it's not allowed.
I'm not attempting to give them a new jury instruction. I'm merely attempting to inform them of the power that they have.
Yeah, by doing that, in
That's not
closing-
against the law.
I'm advising you one more time. You may not raise the issue of jury nullification
I'm going
before
to
this
inform
jury.
them of the power that they have. I'm not
You are
giving them.
telling me
I'm
that
not
you
giving
are
them a jury
insisting
instruction.
on telling them about jury nullification. That's
That's-
what I hear you saying.
That's not what I said, though. Don't mischaracterize what I'm saying. You just read and said that they have the power. They have the power to do that. So how is
It's an
informing them?
inherent power that they have. They are not to be instructed on it. That is very clear in the law. In
Your
addition to, no, let me finish. In addition to the case that I just cited, I'd cite to you from the jury instructions, the law note on jury nullification 705. What that says, sir, is I'm not going to read it all. It's many, many pages. But the bottom line is it is improper for a court to allow a defendant or a defense attorney to make an argument or make the jury aware that they have the power to nullify a verdict.
And Your Honor, you just added this last night. That's why I had to sit there for an hour in the holding cell and wait for you to change the whole paperwork because I brought that up. So you never intended for this to even be an issue.
Mr. Brooks,
it never was brought up.
If you
but
think
then when I raised the issue,
if you
Your Honor, let
think
me
that
finish.
I'm not prepared to deal with an argument on jury
I
nullification,
didn't say that's not what I said. That's
You are
not what I
missing the
said. In
mark.
all fairness, that's not what I said.
The record should accurately reflect that you were kept in that holding cell.
Why was I kept in there?
So that my clerk could finish
Adding
the
a jury instruction that was not there.
76 verdict forms, and it's ×2 because there's a guilty and a not guilty
Okay.
for each. No, let me finish.
So how did I have why did I have to sit here for that where I could have just went to my cell and had it delivered? We had this
Mr.
at the
Brooks.
end of last night before you called recess.
I'm not going to debate
We had a
that
whole
topic with
we
you
had a whole
further.
conversation about
Mr. Brooks, you
me
are
bringing up about the jury
defiantly
nullification.
disregarding this court. You
Here we
you
go
can
with this.
roll your eyes
Here
at
we-
me
because
all
it's-
you want.
It's ridiculous, Your Honor. You just stated that they have the power to nullify
Would you
any
like,
law,
if you would like,
but then
I
I
will
said-
read this to you, sir, the part of the case that's important, but you're not letting me get a word in edgewise. I'm trying my best not to remove you to the other courtroom.
Yeah. This
But
is
that
why
is
this is going longer.
oftentimes what
and
I
this is
need
what
to
I
do
thought
in
was going
order
to
for this
happen.
court to make a full record without you interrupting me. But you need to be fully aware that you may not raise the issue of jury nullification in front of this jury. It is not an allowable argument or an advisement or making them aware. However you want to describe that, sir, whatever verbiage you want to put in front of it, you may not do so. And this court has the power and the authority to limit what you say to this jury, even in a closing argument. And if you're telling me through your conduct, through your words, that you are going to disregard that direction, you will forfeit your right to present a closing argument.
Under what lawful law?
Under State versus Anthony.
It doesn't refer to that.
State versus Anthony may
doesn't.
not have dealt with
It hasn't dealt with closing
the right
arguments.
to a closing argument, sir, but the reasoning
You just said it right there.
nonetheless is
Yeah.
fully applicable.
No,
because
you
the
can't.
more
You can't
general
change the law, Your
principle-
Honor. You can't change the law. That's
I'm not
practicing law
changing
from
the
the
law,
bench.
sir, but the general
I
principle.
know you used to be in legislation, but you can't practice law from the bench.
Sir,
You
can't do that.
He doesn't understand how law
You
is
are.
formed.
If you're changing, Your Honor,
I'm not
you're
making-
attempting to make a separate case pertain to something here that doesn't even pertain to it. It has nothing to do with a closing argument. Nothing that you just
So,
named. Not
Mr.
Illinois
Brooks,
versus
I would
Allen.
like to make a record. Would you please show the courtesy and respect?
I
for me
will,
to
Your
do
Honor.
that?
I will.
Job
Right.
of the judge
So,
to
looking
apply
at
the
the
law
Anthony
to
case,
these circumstances.
All right. And that case, starting at head note 7, paragraph 54, says the following, and you need to let me get all the way through it. We have recognized two distinct ways in which a defendant may give up his rights: waiver and forfeiture. State versus Pino is the first citation that they reference. Waiver is the intentional relinquishment or abandonment of a known right. Multiple citations there. I won't repeat them all. Waiver typically applies to those rights so important to the administration of a fair trial that mere inaction on the part of a litigant is not sufficient to demonstrate that a party intended to forego that right. State versus Soto. Forfeiture, on the other hand, often involves the failure to make the timely assertion of a right. That's a cite to the Dina case and Olano. Rights that are subject to forfeiture are typically those whose relinquishment will not necessarily deprive a party of a fair trial and whose protection is best left to the immediacy of the trial, such as when a party fails to raise an evidentiary objection. However, there is a second aspect of forfeiture, doing something incompatible with the assertion of a right. State versus Vaughn, 2012 Wisconsin Appellate 129,
as in filibustering when you're supposed to be
Illinois
going into
versus
closing
Allen,
argument.
397 U.S. 337. They went on, the court, that is the Wisconsin Supreme Court in Anthony. As previously noted, we have held that the right to testify is subject to waiver, not forfeiture, insofar as a defendant's inaction in asserting the right is concerned. We now conclude that the right to testify may, in appropriate cases, be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. They go on to discuss Allen, which was not a right to testify, but was a right to be present. And I am utilizing the guidance from Illinois versus Allen and State versus Anthony. It directly guides this court that a defendant may forfeit a right by conduct by doing something incompatible with the assertion of a right. In this particular case, you are very clearly telling me you are going to disregard what I told you about notifying the jury about nullification. You have absolutely no right to raise that in front of the jury. It is improper. And unless you're willing to tell me you will honor this ruling of mine, then you will forfeit your right to present a closing argument.
There you go.
That is my
She laid
ruling.
it out so well.
I object to that ruling, Your Honor.
Okay.
Object to that ruling.
Are you willing to make a closing argument, sir, that does not reference jury nullification?
I'm going to inform the jury of their power. Again, I never stated that I was making a new jury instruction. I never stated anything like that. And every case law that you just stated made no reference to closing arguments. It was all pertaining to being present for the proceedings of trial and for testifying.
Sir,
Not
what I'm
one time
telling
did
you,
you, hold on, I let, Your Honor, with all due respect, I let you make your record. I didn't interrupt you.
go ahead.
Not one case law that you just cited made any reference whatsoever to a closing argument.
Doesn't matter.
Not one.
Doesn't matter.
So how is me merely informing the jury of the power and the rights that they have? How is that a forfeiture of being able to give a closing argument?
Well, in addition to the cases I just cited, sir, I'd also point you to State versus Bajurkis, 163 Wisconsin 2nd at 549. That's a Court of Appeals case from 1991. That is the first published appellate decision in Wisconsin to consider directly several issues relating to the jury nullification issue. In that particular case, the court very clearly said that the defense counsel in that case was allowed to talk in terms of fairness in general terms, but not to go further, and could not argue that the jury, quote, should disregard the instructions and the law and find her not guilty because it seems fair. That's a description of jury nullification. To use the words jury nullification would run afoul even more. And so I am telling you that given my inherent authority in controlling the mode and order of this court to ensure courtesy, decorum, and civility, and to ensure that this jury is presented with arguments that are proper under the law, I am hereby telling you I am in creating a rule for your closing argument that you may not raise the issue of jury nullification in any way.
Your Honor, hold up now. I'm the only one that has to be made rules for closing arguments, but not the prosecution. How is that fair? How is that balanced?
Mr. Brooks, I'm squarely faced with your defiance regarding the issue of jury nullification
It's
that
not
is
defiance.
requiring
It's
me
not defiance.
to address this issue and to tell you very
Your Honor,
expressly
I
that that is the
vehemently-
rule
I
for
vehemently
your
object to
closing
that.
argument.
Vehemently object to that.
Your objection is noted for the record, but
May
my
I ask
rule
for a legal
nonetheless
reconsideration of your
stands.
ruling?
That request is denied.
May I respectfully ask for, matter of fact, I reject that ruling and take exception to that ruling. For the record, may I request a legal or factual basis for your ruling? Not one pertaining to being present in the courtroom or testifying. One that specifically talks about a closing argument.
Hi. She already gave her legal reasoning.
All of those requests are noted. I will not reconsider. I've put my findings and my reasoning on the record, and I stand by that record.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law?
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the forum for which an appeal would be sought, sir. I cannot
Well,
answer that.
You referred to it before.
You would need
So
to
now I'm
direct your
confused.
appeal to
I'm confused, Your
to
Honor,
a court of
because-
appeals, not this court.
No, I'm supposed to be in this admiralty court because you haven't.
It's not an admiralty court.
If we're under Article 3, then we should be in common
Not
law
talking
court.
about any
That hasn't
sea
even been
crimes.
addressed. If we're in a common law court or an admiralty court.
That's a baseless argument, sir. I don't even need
And
to
what law and
address it.
fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
She's already given her reasoning.
Sir, I intend to bring this jury out and give you
I'm
an
informed.
opportunity
I'm informed of that.
to present a closing argument.
Yeah,
If
but
you
you're
violate,
also,
please let me,
but
sir,
listen,
you're
you just
interrupting
made
me
a
yet
rule.
again.
You just tried to put me under a rule that no one else was put under.
Everyone else is put
The
under that rule.
circumstances require that I implement this rule, sir, given your
The
stubborn
circumstances
defiance
don't,
on
Your
the
Honor, that's
issue
a
of jury
prejudice to my
nullification.
defense. You can't place me under certain rules and not place the prosecution under the same rules.
Sir, the
It has to
circumstances
be
of
fair.
this case and your insistence on arguing jury nullification has resulted
I
in this
haven't-
court creating this rule.
I haven't argued it. I said that I wanted to inform the jury of their power. I never once said I'm going to make an argument. I'm
Circling,
going to give them jury
circling,
instructions.
You may not
I never
advise
said
them
that.
or make them aware in any way that they have the power
And why
of
not?
jury
Why can't they be
nullification,
informed of their power?
because it would violate the Bajirkas decision, sir.
Violate what decision?
All right, sir, I am going to bring the jury out.
And I'm going to inform them that they have the power.
And if you do that, I will dismiss the jury and I will declare that your right to present a
can't do
closing
that.
argument
Under what
has
lawful
been
law?
forfeited based upon
Then I make a
how
oral,
I've outlined that
oral
to
motion
date.
for
God.
I'm
legal
not going to
finding of
declare
fact.
that at this point because I want to see what you will do. But if you raise the issue of jury nullification, I will immediately dismiss the jury. You will forfeit your right
You can't
to
do that.
present a closing
Under
argument.
what lawful law can you?
And then if you continue to
Under
interrupt
what
me,
lawful law?
you will be removed to the other courtroom as I complete
So I'm being
the
held in contempt
instructions.
again. Is it civil or criminal?
Your
All
Honor,
right. Go ahead.
I apologize. May I ask the court to consider perhaps an alternative? And I fully respect the ruling the court has just made, and I understand the basis for it. We all know the defendant in his petulance will say jury nullification in the first 3 seconds the jury's in the room.
Objection to that.
Proper
I don't
thing
think
to
that
do,
I should
I
be
think,
talked
Your
down
Honor.
Stop
to.
interrupting
I don't
Attorney
think I
Hopper,
should be
please.
talked down to.
Allow him to make his closing argument. I will object if he misstates the law. You can instruct the jury to disregard any misstatements of the law. And we continue in that fashion, if possible, for a reasonable amount of time. And if it becomes to the point where there's no reasonable legal
Yeah.
credible argument that's being made, then the court can decide as to whether or not he's forfeited his right to a closing argument. But we could at least try to, by merely objecting and the court telling the jury to
This is a very
disregard
professional prosecutor.
and instructing Mr. Brooks to move on to the next topic, we could try to allow him his opportunity to provide a closing argument. If that's unworkable, then I think this record will be very clear as to the efforts of this court. And I think there is materials in the bench book, or I'm sorry, the jury instruction 705 that talk about a jury instruction. This court could even give, telling the jury that they are not at liberty to disregard the law, but we're not going that far yet because, frankly, you have told them and you will tell them that closing arguments are not evidence. And I think they will abide by that. So I know it's going to require effort for the court to allow this to allow Mr. Brooks to try and proceed, but I think we should try that or something similar to that in an effort to get through this next step, or else we will continue at this pace forever.
I'm certainly willing to try that.
It's about all we could come up with, Your Honor.
I mean, I'm certainly willing to try it in this courtroom, and if he disregards that, to excuse the jury and then have him present from the other courtroom would be the second step, and then third would be a forfeiture.
Agreed.
Your Honor, I object to that.
They're giving you a chance, you dumb.
Your objection is noted for the record. That will be the course of action that this court takes. The first time you violate the rule, you may be subject to forfeiting your right to be present, where you will give the closing argument from the other courtroom. And if you continue in a blatant disregard of the requirement that you not reference in any way jury nullification, I may make that final determination outside the presence of the jury.
I object to that, Your Honor.
All right, with that, let's bring the jury
For the
out.
record, may I
Oh, my
respectfully
God.
request the legal reconsideration of your ruling?
He needs to stop. And this, by the way,
Is that a
the
tacit agreement that you don't have to
the
answer my objection, Your
prosecutors
Honor?
volunteer of a way
decline
to
to
possibly do this
reconsider.
is a great example of a
reject
prosecutor
that
who
ruling
cares
and
about
take
justice,
exception
not
to that ruling,
convictions,
Your Honor.
which is what the prosecutions should be all
Noted for the
about,
record.
right? They should
For
be
the
all about
record, may I
seeking
request
justice,
a
not
legal or
convictions.
factual basis for your ruling, Your
Because
Honor?
she probably also has
Denied.
just as much of an interest in making sure that this
For the record, may I respectfully request a written
conviction
judicial finding
stands.
of facts and conclusion of law on this issue, Your Honor?
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the court to address that.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction, which this court has no subject matter jurisdiction
Denied.
under,
The jury's
based on
coming
what
in.
law or
All
fact?
rise for the jury, please.
Based on what law or fact?
Jesus. Bay State, thanks so much for the super
Going
chat.
to
Says,
inform the jury of their power.
oh God.
They deserve to know.
This whole trial has been an emotional roller coaster, or this whole trial has been an emotional roller coaster. He's so ridiculous. All I want to do is laugh and joke at this idiot. Then I remember what he did and what happened. Rubber banding over here. Oh yeah, no, I'm with you on that, because it's like, while this is happening, it's so easy to laugh and scoff. You know, I mean, sometimes that's also just a natural kind of defense mechanism, right? As we're dealing with
Thank you,
the
everyone. Please be
absurdities
seated.
of this defendant. But yeah, let's not forget that this is there are
Go ahead,
some
Mr.
horrible
Brooks, your
things
closing
that he's
argument,
done.
please.
Good afternoon. It's been a long day. First off, I'd just like to start by letting you guys know that
It's the first thing he's going to say. He's
it's a
gonna
lot
say
of
it.
information that you guys should be privy to, I believe. And one thing that I believe that you have not been privy to is the truth of your rights and your duties.
Thanks, Ms. Amanda.
Being
Good reminder.
the jury. The fact that you and you alone have the power, not well-prepared DAs with well-prepared and clearly rehearsed speeches and exhibits and a lot of theatrics. Frankly, not the judge. You and you alone have the power. You and you alone decide what is truth and what isn't truth. You should be informed that you have the power to nullify any law that you
Oh,
don't agree
no.
Objection, move to strike the statement.
Sustained.
with. Objection.
I will strike from the record the last statement made by the defendant. The jury will disregard it.
Which is clearly what I've been saying. I believe that not only is it fair, but it's essential that you be privy to all knowledge, not knowledge that certain people feel that you should hear and shouldn't hear, disguised under the color of law. The fact of the matter is, just like I did with my opening statements, I don't have a well-prepared or rehearsed speech. I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right or anything like that. I've chosen to speak from the heart in my opening statements, and now I'm going to speak from the heart. What you won't hear me do is argue facts. And the reason you won't hear me argue facts is because I believe that it takes away from what should be recognized. The tragedy of this event, it should be recognized. Trying to argue facts of this, facts of that, I'm not going to waste your time doing that. It's a little emotional. I apologize for the long pause. It's hard to keep everything together emotionally. And honestly, I don't believe that I have any more tears left. It's been a hard year for the families, mostly. And that should not be lost on anyone. It shouldn't be taken away. I said it before and I'll say it again. It's a lot of people that are healing, that are attempting to heal. That opens the door to talk about forgiveness for a little bit. With every healing process, there comes a forgiving process.
Oh, geez.
It's not an easy thing for anyone.
Forgiveness doesn't come without contrition, man.
What you've been hearing from the prosecution, and not to take anything away from them.
And it's not up to the jury to forgive you. It's up to the families to choose to forgive you.
Let's call it what it is. You've been hearing a lot of rerun. Same things over and over and over. No different than when you turn on the radio and you first hear that song that you don't like when you first hear it, but they play it so much that eventually you start saying it, the words to yourself before you even realize it. And then you sit and you go, I hate that song. Why am I singing it? That's what's been happening. Rerun over and over and over and over and over and over and over. Attempting to make things stick in your head that simply aren't true. Why do I say, what am I saying? I say, look at the testimony. You know, the theme from the prosecution here has been intent, 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 intent. We all know what's been said. We all know the picture that's been painted.
On the
And
ground, he
prosecution
gets up
said
to an hour.
themselves, how can you look in somebody's head and say, this is what they intended to do?
Circumstantial evidence, dude. There's a lot of it.
You know, for a year, I've sat and gone through this. Feeling so powerless. You know,
Well, that may
letting
be
other
real.
people run with the narratives. Sitting back helpless while other people paint a picture that has zero truth. Zero.
Except that there's a hell of a lot of evidence saying otherwise.
I understand about healing myself, tragedy, pain, all that. A lot of it, there's no need to get into. I myself in my own life have had to do a lot of healing. As a man with children myself.
Don't try to use your children here.
I find it hard to believe that anyone who's really had conversations with me, spent time around me, would think for 1 second that this is an intentional act. I've never heard of someone intentionally trying to hurt someone while attempting to blow their horn.
What?
While attempting to alert people of their presence. Which brings me to more information that I believe that you should have been privy to. And I'm sure that the prosecution will beg to differ. But the fact of the matter is, the vehicle in question, make and model of 2010, Ford Escape. The vehicle in question, actually 2008, 2009, and 2010 of that model was in fact recalled.
Objection, misstatement of the facts, facts not in evidence.
Was in fact-
Improper argument, Your Honor.
Sustained.
Was in fact recalled.
Yeah. You can't be bringing in new evidence
Was
in the
fact,
closing.
a class action lawsuit against Ford
Objection.
for those
Facts,
model
not evidence,
for
Your
those
Honor.
model vehicles.
Sustained, the juror will disregard.
Information that you should have been privy to,
If you
that you weren't allowed to be privy to. Why? I don't know. That information, malfunctioning throttle bodies.
Mr. Brooks, move out.
It's information that you should have been privy to. Vehicles that malfunction and accelerate, not being able to be stopped.
Objection, that is.
It's information.
inaccurate,
It's
Your Honor.
There's an
information.
objection. Hold on. Go ahead.
Move to strike statements by.
Sorry
Mr.
for the
Brooks.
interruption.
They are facts, not an evidence, Your Honor, and it's complete misstatement.
Sustained.
How's it a
the-
misstatement when I have the information?
Mr. Brooks, move on.
This is information that I feel like you needed to know. You should have known. Information that was taken away from you. Why? To prove a case? Information that you definitely should have been privy to.
So he's trying to blame the brakes, saying that that the car wasn't functioning properly. Facts, not evidence. If you didn't introduce any evidence to support that, you can't try to sneak them in your closing argument.
DA says the defendant has an utter disregard for human life. Utter disregard for human life. Not realizing that they're talking about someone that has children. Talking about someone that watched their children come out of the womb and be born into this world, cut the umbilical cord, held them before their mom even did. Moments that I'll never forget.
It's probably proper.
And yet they say disregard, utter disregard for human life.
I mean, I don't know, mowing through over 60 people does sound like utter disregard for human life.
They made reference to a rage. As if they were, or if this particular DA was right there, standing right there. As if this DA is a psychiatrist. I said to myself, what rage? What do you mean rage? How can you characterize that? How can you have the audacity to diagnose what someone's brain is? Where it's at, what it's thinking, why it thinks the way it does? DA makes references to blocks of no one being injured, but then says it's intentional. You add that up with the supposed rage.
James Morris, thanks for the super chat. Couldn't he bring this up in
The
rebuttal?
supposed intent.
There's
harm
evidence
and
that
kill.
he could have brought up previously that he's trying to get in
And it
here
doesn't
for sure.
kick in until well within blocks.
Bronwyn Warwood.
And maybe it's just
Did
me,
they have
but I
someone
would think
testify that
if
there was nothing wrong with the car? I think so. Yeah, I believe there
I
was a mechanic who
characterizing
testified
someone with
to
this
that,
intent to kill, and
which is
and
which
this-
is why
and
the
this-
prosecution objected
this
here.
rage and this anger Then why weren't people
This is
immediately
from
harmed?
earlier too.
Why was someone with
Nishant Therapali.
intent to kill and rage
They can still
try
convict.
to alert people of their presence, repeatedly honk their horn? You heard a detective, if you recall, testify that the vehicle that he observed was not only honking his horn, but was not speeding. So where does this rage kick in? Where does this insatiable intent to kill kick in? They speak as someone who's known
Stuck
someone
on
for
strings.
years.
Thanks for the super chat. He tried to bring it in yesterday. Prosecution stated that car was inspected and recall doesn't apply to the VIN. Right, because there's going to be some specific information on
Which brings
that
me back to
specific
the
car as to
vehicle. What
whether
if
it's
the
subject to a
vehicle couldn't stop
recall.
because of the malfunction?
And there was nothing there.
In fact, not in evidence.
What if the driver of the vehicle was unable to stop the vehicle?
What if? Well, that doesn't seem to be
Because
the
of
case
that
here.
fact, what if the driver may have panicked?
And mowed through over 60 people in a state of panic.
Does that make the driver a crazed, or not crazed, a rage? Does that make the driver in a rage and intent on killing people? DA played exhibit 17. You don't see anyone struck in that vehicle. On that exhibit, you don't see anyone struck. Was someone who had this intent to kill, this rage, as she says. If that was their intent, wouldn't they have taken the opportunity to hit as many people as they could? Target people, mow down people. Reference was made to this vehicle, the damage. Says this was all caused by bodies, but then later turns around and says hits barricades and other objects. I've heard testimony about hearing loud crashes and things of that nature, but the DA wants you to believe that this all came from people. Evidence doesn't support that. So I go back to trying to wrap my head around everything that's happened in the last year. Praying for those families, praying for the people that tragically lost their life, because that should not be lost either. The fact that there was lives lost, and all the emphasis has been put on the alleged defendant.
For those lives lost, yes, that's what this trial is about.
Disregarding. Makes me wonder, does the DA even care about those people? There's been prayers going up every day. It's been suffering on both sides. It's been threats, hate mail. because of the narratives that's been put out there, the misconceptions that have been put out there, the lies that have been put out there.
That video
Lies
footage
that
doesn't lie,
have
man.
caused my children not to be able to go to school, to be bullied, for my mother to have to leave her home and stay at a hotel because she's afraid for her safety.
Is that
Because she
because
gets hate mail shoved through her mailbox.
okay?
My nieces
That
and
could
nephews
be.
to fear for their safety.
Could be that the people around him are dealing with hate mail and that kind of thing. Maybe. But that's not a reason to not convict him.
And what's been equally hard is not only having to answer the questions from my daughter, who was 7 at the time, my baby girl, who was 7 at the time, is now 8. Attempting to answer her questions that she's asking and still continue to shield her from what she sees, what she hears. Having a newborn son that I haven't even been able to meet. I haven't been able to hold, touch, kiss. Having to navigate everything that comes with this whole situation. While still attempting to wrap my head around it. I can't honestly say how many times I've sat in my cell, especially during lights out, alone, where it's just you.
McPeckbian, thank you so much for your generous super sticker. Thank you.
And just been praying and asking myself, how could this happen? Not just for the people, but for everybody involved, the community too. How could this happen? How? The hardest questions you can ask is those that don't have an answer. No matter how much thinking you do, no matter how much you try to look at it from different perspectives and listen to other outside perspectives and listen to people that you trust and that you love, still coming up with nothing. But to think for 1 second, one question I never had to ask was if this was intentional. That's something that I never asked once. Because I know it wasn't. As a matter of fact, it never even crossed my mind to even attempt to ask myself that, because I know it wasn't.
Samuel Schweitzer, thanks so much for your super chat. Watching with my lawyer parents, we are baffled right now. Yeah. It's
And I know sometimes during this trial probably doesn't show.
either dazzle them with brilliance or baffle them with
Maybe
bullshit,
hard
as they
to
say.
believe.
He's baffling.
But trust me when I say no one outside of the families that had to go through this, no one's heart is more in pieces than mine.
Yeah, I don't think that anybody's going to believe that. Law Francisco, thanks so much for your super chat. Father of the Year, Darrell Brooks. Yeah.
So again, I go back to all these exhibits.
These are not real tears.
Go back to everything that's been shown, everything that's been testified to.
Jay Cass, thanks for your super chat. He's finally admitting he was behind the wheel, which he kind of sort of did in his opening statement too.
Everything you've heard.
John O'Rourke, was that an admission
during this
in a way?
whole process, this trial. And again, I say the same thing that I said earlier. Same thing I said in opening statements.
Nice.
I'm not reading from any paper, any books.
That's pretty clear.
Everything you've heard in opening statements, everything you're hearing now is from right here. Everything.
Thomas Harkins, thanks for your super chat. Grandpa of the years, 15 years a mom.
You have the decision. You and you alone, all of you, you have the decision. I'm sure you've taken a lot of notes during this process. Some days are longer than others. A lot of movement in and out of the courtroom for various reasons. Remember the power that you have. Don't for 1 second let it be taken away from you. I can never understand the position of sitting on the jury in something of this magnitude. So I'm sure there's a lot of pressure.
Angel Bunny 856, thanks for your super chat. I just want to know what his
I pray
end
that
goal
the right
is.
decision is made.
Continuously arguing with the judge and disregarding her rulings does not make him look good. I completely
The
agree.
right decision.
Yeah. I don't think he's strategizing much at all.
It's almost like that message. Well, not message, but that writing when we're in our vehicles and we have that rearview mirror and it said things are closer than they appear. but it's also another way of saying sometimes things aren't as they appear.
Okay. John O'Rourke, thanks for your super chat.
I can't speak for
You
anyone
heard-
else, but me, myself, I believe in Jesus Christ.
Oh,
That's how I was raised. That's what I believe in. None of us are perfect.
John O'Rourke, you heard from right here. I killed him,
try every
peeps.
day
Yes, you did, Brooks.
to make sure
You killed
that
those innocent people in a holiday Christmas
I
parade.
acknowledge him.
Yeah.
That's why every time I step in this courtroom,
Jen Gosi, thanks
I
for your
have my
super
Bible
chat.
with me everywhere I go. I even read it on breaks, recesses. This is not something that started at the beginning of this incident. This is something that has been instilled in me since I came out of the womb. This is how my family lives their life. This is how we was raised.
To mow into dozens of people? Yeah, it's been a long day.
For whatever mistakes that I myself have made in my life, I've made peace with God. Made peace.
Jen Gosi. And another one. Thank you. Thank you for another super
I'm happy
chat.
to say that my conscience is clear.
Is it though?
And because I believe, I trust him with my life. Nobody will never know why it was his will for this to happen.
Well, it wasn't his will. It was your will. That's why you're on trial. This was not an act of God.
A lot of lives were changed that day, mine included.
Iris, thanks so much for the super chat. Thank you.
God's way is not our own. And no matter how much sometimes we want to question, we have to have faith.
There's no way that the jury is coming away from this not disgusted. There's absolutely no way. It's clear that this is all a charade. These tears are crocodile tears.
Look inside yourself. Look inside yourself and make the right decision.
Jenny Kosi, thank you for the generous super chat. I figured it out. Love your channel. Thank you. Thank you. Thank you. And thank you for joining us and for engaging in the chat. Love it.
Look inside your heart.
Yeah, I don't think you're going to want to know what they see when they do that, buddy. This is not going to play the way you think it will.
You have everything in your hands now. Everything. Do what's right.
I wish I could see what the jury is doing right now. They probably are not looking at him. Maybe looking elsewhere in the courtroom,
what's
maybe
right.
looking down. But there's just
Don't let the smoke and mirrors take away your power. Don't let the theatrics take away your power. Each and every one of you has a decision.
Charles Dossett, thanks for the super chat. He thinks he's arguing for
That's
why
right.
they should nullify. A mistake was made, but don't punish me. It is honestly what he's arguing. Yeah. Yeah, but there's no
Make
way
the
that
right
that's a winning
decision.
argument. There's no way. Because it's beyond a mistake. A mistake is maybe in the first instance mistaking the gas pedal for the brake pedal, right? Or the inverse. But this, I agree with you that that's what he's trying to do. And I think we can probably all agree that it's not playing well. Yeah, but thanks for the super chat.
It's hard to think about.
Yeah, no way, but it's what he believes. Yeah, you might be right about that. Yeah,
My younger kids getting older.
I can agree with you there.
At some point, having to explain everything to them. Kids don't stay kids forever.
Unless you kill them with your car, buddy.
And nowadays, kids is frankly a lot smarter than we were when we was kids. I'll tell you that much. I got a letter the other day. My youngest daughter. And she's still learning cursive right now, so she's the best writer when it comes to cursive. She'd rather print. She said, "Dad," and this is from the letter. She said, "Dad, why are people saying all these mean things about you?" I haven't read the rest of that letter yet.
Letha, thanks for your super chat. Alita, do you know if jurors and the
The
chat
rest of that
overlap
sentence
much?
said,
Do you mean if the jurors like appear in this chat? They shouldn't be.
"That's not the dad I know."
Because they're supposed to stay away from all social media and everything about this case. I'm not sure if that's exactly what you were asking, but if it is, that's my answer. So.
Throughout this year, I've been called a lot of things. And to be fair, I am a lot of things.
Oh, you meant the opinions.
A murderer is not one of them.
Well, the chat seems to be a pretty good metric for how the average person is going to react.
Never has been, never will
So,
be.
there's a good chance that they are feeling the same way that you guys are, for sure. I mean, you know, I can definitely empathize that when you have
So before I close,
a lot of people saying things about you on the internet or in the media, it can be hurtful. But look, what can you complain about when you have mowed down over 60 people in a parade in one go? Ugh. Stephen
just want to say,
Yarger,
open your hearts.
thanks for your super chat. If anyone in the chat is feeling like what he's saying is bringing up things you don't want to feel, maybe hitting a little too close to home, please don't forget there's resources and support out there. Thank you so much for saying this. Yes. If this is bringing up these kinds of feelings, please do reach out to people.
Go inside yourself when making this decision.
Because this guy is not worth you getting harmed in any kind of way for seeing this awful person. Thank you for that, Stephen. Kate Leslie, thanks so much for your super chat. This is really hard to listen to. Thank you to everyone for coming here today and providing a safe place to watch this. Yes, thank you. And thank you to you too.
I have no fear.
Debbie Faison Cook, thanks for your super chat. I'm waiting for him to say, why didn't they get out of my way? I know, that's what it sounds like, right? John O'Rourke,
Pray
thanks for your super chat.
This
closing seems like a long apology and admission. Thoughts?
No, it's right.
Little bit. It sounds like a little bit of an admission, a little bit of an apology. Kind of, right? Because he's not exactly arguing much in opposition to what the prosecution has said.
Think about everything you've heard. Think about everything you haven't been privileged to hear. Think about the whole entire picture.
There's a question about how can people be making jokes about what this guy is saying right now. I do caution judging people and their reaction to this kind of thing, because sometimes people will use humor as a way of deflecting emotional pain. So keep that in mind in the chat and elsewhere. All kinds of people have a lot of different ways of handling this kind of situation.
Make sure you yourself can live with it. Make sure you can live with it. That's the magnitude of the power that you have. Just like this tissue is in my hand, this is everything. You have everything. Be at peace with what you decide. Have no regrets. Don't let this decision weigh on you after it's over. Hold hopefully we got a lot of living ahead of us.
In jail,
Lord willing.
in prison.
Don't look back and kick yourself in the behind. It's been about 3 weeks with you. And took a lot of courage and a lot of guts to pause your life for this. To put important things on hold, to basically stop your life. You should be commended for being able to sit up here with this amount of pressure. I want you guys to know that's not lost on me. I'm sure it's a lot. And you all should be commended because it took courage to do this. I don't know, but I would bet a lot of people wouldn't want to be sitting in your position right now.
I know of plenty of people that would like to be in
And
the
you
jury's
guys had the
position right
guts to
now.
do it. Thank you for that. Thank you for taking pretty much a month and setting it to the side for this.
It's got a little over 10 minutes left, I think.
I know it's probably not proper, but you guys deserve a round of applause if you could get one. Thank you guys sincerely. And I know, and I have faith and I trust that you guys know what's right. Ladies and gentlemen, I don't think it's fair to just say guys, but I believe in your heart you know what's right. Thank you.
Oh, Lord.
Thank you, sir. Before I give the state an opportunity to present rebuttal, please stand for a minute. So please stand.
Okay, so now we're going to have rebuttal. Also, I just pinned in the chat, there's a link to pages benefiting the families of the Waukesha families impacted by Darrell Brooks, verified by GoFundMe. So that is, if you guys feel inclined, you want to donate to these families, please do so. I mean, this,
Can I
it
have a
looks
seat,
like,
please? And Attorney Apparay,
it looks like a lot of these
time
have
both
fulfilled their
closings. You have
their
13:28
initial
left.
request, but I think that's a
Thank you, Judge. I
very
don't think that'll be an issue.
worthy place to send your money if you want to do something good out of this.
Folks, let me just say this. Mr. Brooks stands here and professes to speak to you from his heart. He plays on your sympathy. He talks about his children. He talks about the
I'll get this later.
hardships that he's encountered and his family's encountered. And he brushes over the loss to the community. He wants to talk about how he's never held his newborn son.
Mm-hmm.
Never once acknowledges the Sorensen family.
What about these other families?
The Owen family, the Duran family, the Hospital family,
Yep.
the Kulik family, Sparks family. Never once It's nice that Mr. Brooks can get letters from his loved ones.
Oof.
I don't know why he did this. I told you that. But actions define a person.
Yep.
It's that simple. You can stand with the Bible in your hands all day long and profess to be the finest man under God that you can be. But when you drive through a parade route and roll over children with band instruments to the extent that your vehicle heaves up and down.
Oh, God.
Your intent is known, Mr. Brooks. It doesn't have to be guessed. It's known. You don't have to stand and wonder as he claims to. For him to keep going after he drove over those children in the band and have Jackson Sparks fly off the front hood of his car, lifeless, and keep going.
She can go for
and have
quite a
Jane
while.
Kulik fly off
She's got
the
plenty of time
the
reserved.
Hood of his car, run her over, and keep going. I'm not going to go on. You get it. You need to look in the mirror, Mr. Brooks. If you want to accuse me of practicing my closing argument, you need to look in the mirror, sir. Your actions are that of a murderer. You murdered these 6 people.
Yep.
You endangered the safety of 61 others. There are 68 victims in this case, folks.
Yeah.
That's not an accident. That's not a, gee, I woke up one day and don't know how I found myself in this position. If you have some explaining to do to your children, Mr. Brooks, I recommend you do it.
Whew. Whoa. Mic drop.
Objection.
Now, members of the jury, the duties of the parties and the court have been performed. The case has been argued by the parties. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 76 forms of verdict will be submitted to you concerning the charges against the defendant, Darrell E. Brooks. Count 1. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 2. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 2 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 3. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 3 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 4. Excuse me. Count 4. Count 4. One reading. We, the jury, find the defendant, Darrell E. Brooks,
Trinity
not
Valley
guilty
North
of
Central,
first-degree
thanks for your
intentional
super chat.
homicide as charged in
Do we
count
know the
4
makeup
of the
of the jury, men
information.
versus women? I
Another
actually
reading.
don't know.
We, the jury, find the defendant,
we can
Darrell
look it
E.
up, though.
Brooks, guilty of first-degree intentional homicide as charged in count 4 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following
And
question,
John
yes
O'Rourke,
or no.
try to donate via
Did
the
the
link.
defendant commit
There's the
first-degree
opening
intentional
webpage, not a
homicide
Darrell
while
Brooks
using a
recovery page.
dangerous
Oh.
weapon? Count 5. One reading. We, the jury,
Okay.
find the defendant, Darrell E.
Let me
Brooks,
check
not
that out.
guilty of first-degree intentional homicide as charged in count 5 of the information.
Okay,
Another
thanks
reading.
for letting me know,
We,
John
the
O'Rourke.
jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 5 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 6. One reading. We, the jury, find the
Jen
defendant,
Gosey, thanks so
Darrell
much
E.
for your
Brooks,
super
not
sticker.
guilty
Really
of
appreciate
first-degree
that.
intentional homicide as charged
Michael
in
Cook,
count 6 of the
You're
information.
done, son.
Another reading.
I think
We,
he might
the
be.
jury, find
I
the
think
defendant,
he
Darrell E. Brooks,
definitely is.
guilty of first-degree
Thanks for the
intentional
super chat.
homicide as charged in count 6 of the
Law
information.
Francisco, thanks for your
If you
super
find
chat.
the defendant
Mr. Brooks,
guilty
you
of
did something
first-degree
wrong, whether on
intentional
purpose or
homicide,
not. You still have
answer
to be
the
held
following
responsible.
question, yes or no.
100% true.
Did the defendant commit first-degree intentional homicide while using a dangerous
A
weapon?
Gryffindor, thanks
Count
for your
7.
super chat.
One
We made a
reading.
big deal
We, the
about
jury,
not
find the
consenting to be called
defendant,
Mr.
Darrell
Brooks.
E.
Did we ever
Brooks,
find out the
not
name he
guilty of
wants to be
first-degree
called?
recklessly endangering safety
No, he
as
never
charged in
seems
count
to
7 of the
divulge that
information.
information.
Another reading. We, the jury, find the defendant, Darrell
Lord
E. Brooks,
Narcissus.
guilty of first-degree recklessly
She is
endangering
kicking his
safety
ass.
as charged
Yeah,
in
she
count 7
really
of the information.
just nailed
If you
that.
find the defendant
that,
guilty of first-degree recklessly endangering
that
safety,
rebuttal right
answer
there.
the following question,
Thanks for the
yes or
super
no.
chat.
Did the defendant commit first-degree recklessly endangering
Krista
safety while
Richards,
using a
thanks for your
dangerous
super chat.
weapon?
Does this trial include
Count 8.
sentencing?
One reading.
Sentencing
We,
is
the
going to be
jury,
at a
find
later
the
date.
defendant, Darrell E. Brooks, not guilty
Yeah.
of first-degree recklessly endangering safety as charged in count 8 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 8 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 9. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 9 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 9 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 10.
Yeah, this is
One
going to be the
reading.
verdict
We, the
form
jury,
here
find the
that she's going
defendant,
through.
Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 10 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 10
Miss
of the
Amanda,
information.
this is an interesting
If you
tidbit.
find
Thank
the
you for
defendant
sharing.
guilty of
In the
first-degree
beginning, Brooks
recklessly
complained
endangering
about the
safety,
jury being
answer
a
the
team of
following
all
question,
white
yes or no.
and wanted a whole
Did the
different jury to be
defendant
selected
commit
because he was
first-degree
afraid his
recklessly
skin color would
endangering
make him
safety while using a
would make them
dangerous
judge
weapon?
him unfairly.
Count 11. One reading.
Okay,
We,
thanks
the
for
jury,
sharing that.
find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count
Michael
11
Cook,
of
thanks
the
for your super
information.
chat. I'm hoping the
Another
victims'
reading.
families have something
We,
to
the
be
jury,
thankful
find
for
the defendant,
these upcoming
Darrell E.
holiday
Brooks,
season.
guilty
Justice was
of
served.
first-degree recklessly
Yeah.
endangering safety as charged in count 11 of the information. If you
HWS.
find the defendant guilty of first-degree
Thanks for your
recklessly
super
endangering
chat. I'm
safety,
back. Can you
answer
say
the
hi to
following
Lily for me?
question,
Hi,
yes or
Lily.
no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 12. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 12 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 12 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 13, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 13 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 13 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 14. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 14 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 14 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 15. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 15 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 15 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 16. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 16 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 16 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon?
New pinned link.
Count
For the
17.
GoFundMe for
One
the families
reading.
of the
We, the
Waukesha
jury, find the
Christmas
defendant,
Parade
Darrell E. Brooks, not
massacre.
guilty of first-degree recklessly endangering safety as charged in count 17 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly
Hopefully this
endangering
one works
safety
better
as
than
charged
before.
in count 17 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 18. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 18 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 18 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 19. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 19 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 19 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 20.
Michael
One
Cook,
reading.
thanks for
We,
your
the
super
jury,
chat.
find the defendant,
I have a feeling
Darrell
it'll
E.
take
Brooks,
longer to read the
not
verdict than
guilty
for
of
the jury to
first-degree
decide.
recklessly endangering safety
100%.
as charged in count 20 of the
I'm with you on that.
information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 20 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 21. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 21 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 21 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 22, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 22 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 22 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 23, one reading. We, the jury, find the
John
defendant,
O'Rourke,
Darrell E.
welcome to
Brooks,
Bike Club.
not guilty.
So happy
of
to have you
first-degree
here.
recklessly
Thanks for
endangering
becoming a YouTube
safety
member and
as
supporting
charged
the
in count
channel.
23 of the
Hope to see you on
information.
Friday in our
Another
Bike Club member
reading.
stream.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 23 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 24, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 24 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 24 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 25, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 25 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 25 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no.
Yeah.
Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 26, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 26 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 26 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 27, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 27 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 27 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 28, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 28 of the information.
Yeah, for those of you
Another
wondering
reading.
why it
We,
seems
the
like
jury,
she's going
find
through
the
this
defendant,
again,
Darrell E. Brooks,
she's
guilty
going through
of first
the
degree
verdict form
recklessly
here.
endangering safety as charged in count 28
So,
of the information.
reading through
You
what they're
find
going
the
to have to
defendant
read
guilty
through,
of first degree
making sure
recklessly
it's all in the
endangering
record.
safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 29, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 29 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 29 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no.
Yeah,
Did the
dangerous
defendant
rhetoric.
commit first
Verdict has
degree
not been returned
recklessly
yet.
endangering
Jury has
safety while
not had an
using a dangerous
opportunity to go
weapon?
into the jury
Count
deliberation
30.
room.
One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 30 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 30 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 31. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 31 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 31 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 32. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 33 of the information. That should be 32.
Natalie T, how long does the jury take to make a decision? It's up to them. It can be as quick as 10
Another
minutes,
reading, we the
or it
jury
can be hours or
find
days.
the defendant, Darrell E. Brooks,
So
guilty
this,
of first degree
I would
recklessly
imagine, is going to
endangering
be a
safety
relatively
as charged in
fast,
count
relatively
32
fast decision. The forms
of
may
the
take a little bit
information.
longer for them to fill
If
out.
you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? We're going to have you take a short stand break
Yeah,
while I confer with Madam Clerk.
good idea. Get everybody moving.
So I'm sure you have all the verdict forms, right? This will need to be corrected. So I need 33. Okay, well, you could read one twice and then I'll make another one.
Yeah, so they do have to go through the verdict forms and read them into the record to make sure that they can say that the jury has gone through these verdict forms. You know, even if they're not really paying attention, the fact that they're in the room, they're awake, they're ostensibly paying attention. This way, you know, if anybody comes out later and says, I never got a chance to see the forms, it's you know, it's not exactly an excuse.
When you're ready, have a seat.
Ms. Amanda, fun fact, the longest jury deliberation in the U.S. is 6 months. Yikes.
Count 33. One reading, we the jury
How
find the
long did
defendant,
OJ take?
Darrell
Was
E.
that
Brooks,
the one that you're
not guilty
talking
of
about here?
first degree
'Cause I
recklessly
think that one
endangering
took a while,
safety
didn't it?
as charged in count 33 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 33 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 34. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 34 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 34 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 35. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 35 of the information. Another reading, we the jury
OJ
find
was
the
4
defendant,
hours. Okay.
Darrell E. Brooks, guilty of
Fair.
first degree
I was very young when
recklessly
that
endangering
happened, so
safety as charged in count
there are
35
some
of the
things I
information.
remember, other things I
If you
don't.
find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety or using a dangerous weapon? Count 36. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 36 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 36 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 37, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 37 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 37 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 38, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 38 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 38 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 39, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 39 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 39 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 40. One reading, we the jury
Shireen,
find the
very
defendant,
true.
Darrell E. Brooks,
Well, we got
not
through closing
guilty
arguments
of
together,
first
chat.
degree
Thanks for all
recklessly
being here
endangering
together.
safety
Agreed.
as charged in count 40
Agreed. It's
of the
been
information.
great to go through
Another
all of this
reading,
with all
we
of
the
you.
jury find the defendant, Darrell E. Brooks, guilty of
As
first degree
frustrating as
recklessly
it's been.
endangering safety as charged in count 40 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question yes or no. Did the defendant commit first degree
That's
recklessly
what I was
endangering
thinking
safety
of.
while
Southern
using
Gal
a
Gen
dangerous
Gen.
weapon?
But in the OJ trial, the jury
Count
was the longest
41.
in history as
One
sequestered
reading, we
265.
the jury find
Can
the
you imagine?
defendant,
Yeah,
Darrell E. Brooks, not guilty
that was it.
of first
They were
degree
sequestered for
recklessly
so long.
endangering
That's why it took
safety as
them.
charged in
That's
count
why they
41
rendered
of
a
the
verdict so quickly.
information.
Probably
Another
was
reading,
because of
we
the
the
fact
jury
that they
find
were
the
sequestered
defendant,
for so
Darrell
long
E. Brooks,
and wanted to
guilty
be done. I'm
of
sure.
first degree recklessly endangering safety as charged in count 41 of the information.
John O'Rourke,
If you
thanks for
find
the
the
super
defendant
chat.
guilty of
Free
first
super
degree
chat.
recklessly
Uber
endangering
Eats Abuelos
safety,
on the way.
answer the following question yes or
Well,
no.
that sounds yummy.
Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 42. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 42 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 42 of the
Oh,
information.
Sean Risner, what does it mean to be
If you find the
sequestered?
defendant
It
guilty of
means
first
to
degree
have a
recklessly
jury
endangering
isolated
safety,
from
answer
the
the
outside
following
world.
question
So
yes
they have to
or
stay in a
no.
hotel,
Did the
specific
defendant commit
hotel. They've
first
got
degree
security.
recklessly endangering
They're allowed to
safety
make some
while
phone
using
calls,
a dangerous
but
weapon?
limited phone calls to
Count
family.
43.
So in the OJ
One
case,
reading,
they were
we
sequestered
the
for
jury
almost a
find the
full
defendant,
year,
Darrell E. Brooks, not guilty
which
of
is a
first
long,
degree
long,
recklessly
long time to
endangering
be away from your
safety
family.
as charged in count 43 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 43 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 44. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 41 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 44 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 45. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 45 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 45 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 46. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 46 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 46 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 47. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 47 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 47 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 48. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 48 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 48 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 49. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 49 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 49 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 50. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 50 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 50 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 51. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 51 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of
Michael
first
Cook,
degree
thanks so much for
recklessly
your super
endangering
chat. He's
safety
going to have
as
so much
charged in
time to
count
work on his
51 of
music
the
career.
information. If
Yeah.
you find the defendant guilty of
Yeah,
first
you're
degree
right.
recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 52. One reading, we the jury find the defendant,
Count
Darrell E.
52. We're
Brooks,
getting
not
close.
guilty of first degree recklessly endangering safety as charged in count 52 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 52 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 53. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 53 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 53 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 54. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 54 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 54 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 55. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 55 of the information. Another reading, we, the jury, find the
Marianne
defendant,
Williams, thanks so much
Darrell
for
E.
your super
Brooks,
chat.
guilty
Says thank you for
of
spending the
first
whole day
degree
covering this.
recklessly
No
endangering
problem.
safety
This
as
was one
charged
that I
in
was
count
genuinely
55 of the
interested in
information.
seeing from start to finish today. After
Another
all that's
reading,
happened in this
we, the
case
jury,
so far.
find the
So
defendant,
thanks for hanging out
Darrell
with
E.
me today
Brooks,
as well.
guilty of first degree recklessly endangering safety as charged in count 55 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? I think I'll give my jurors one more stand break before I conclude. So please stand, and anyone else in the courtroom, please.
One more stand break. Everybody in the chat, stand up. Get a good stretch. Get that blood pumping.
You can add them to this. Yep. And here's, if you want these too. For now. That's more.
Oh, yeah, I did read it all.
Oh, did it? Yeah. All right, thank you. Have a seat. Count 56. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 56 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 56 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 57. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 57 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 57 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 58. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 58 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 58 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 59. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 59 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 59 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 60. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 60 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 60 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 61. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 61 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 61 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 62. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 62 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 62 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 63. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 63 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 63 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 64. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 64 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 64 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 65. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 65 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 65 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 66. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 66.
Oh no, she lost track.
I'll just repeat count 66. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 66 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 66 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 67. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 67 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 67 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 68. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 68 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 68 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Virginia Sorensen? Count 69. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 69 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 69 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Leanna Owen? Count 70. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 70 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 70 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Tamara Durand? Count 71. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 71 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 71 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Jane Kulik? Count 72. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 72 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 72 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Wilhelm Hospital? Count 73. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 73 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 73 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Jackson Sparks? Count 74. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of bail jumping as charged in count 74 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of bail jumping as charged in count 74 of the information. Count 75. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of bail jumping as charged in count 75 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of bail jumping as charged in count 75 of the information. Count 76. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of battery as charged in count 76 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of battery as charged in count 76 of the information. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously.
Yep.
In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the parties before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdicts will be read into the record in open court. The court may ask each of you if you agree with the verdicts. Before I swear the officers, we will determine the alternates, and then I will have all of the civilian bailiffs and deputy bailiffs that will be in charge of the jury during their deliberations and sequestration. Wait, hold on. Yeah, let's put it over here. Okay. I have a lot of stuff up here. Do the percentage. There we go. Counted and recounted 15.
So picking who's going to be on the jury.
One of your numbers in the tumbler. I'm going to draw 3 numbers. Those numbers will be the alternates. Who will nonetheless be sequestered in the event we would need to call upon one of you to replace another juror. The first number that I'm pulling out is 10.
So it's normal for the jury to be sequestered at this point in time because they are supposed to come together and not have any
Second
distractions.
number I am pulling out.
Now, sequestering doesn't necessarily mean that they can't go home.
And the third number I am pulling out.
But
1.
this is they're not supposed to be talking to anybody
But I
at
still
this
have
time.
12. I know Madam Clerk did it, but I will also do that to be sure.
And different judges, different courtrooms have different ways of choosing who or not choosing, but determining which jurors end up alternates, which ones end up on the jury. In the Rittenhouse trial, for example, the judge there he said that he always has the defendant pick through the lottery because there was one time that there was I think it was an African American, or I should say it was a Black defendant, and there was only one Black juror in that pool of possibilities.
That the other 12 numbers
and I think he said that it had something to do with the perception of impropriety of that. So he wanted to have, even though it's a chance, no matter who does it, he wanted to have it,
I will need all
so
of
that
the
there's no
deputies
appearance of impropriety for any kind of prejudice to the
sworn
defendant.
on the record for the sequestration, and I'll go ahead and do that.
Okay, Leslie says that they do have a hotel for them, so they actually are being fully sequestered in this case. So that's interesting. I mean, I'm wondering if it's because of the determination of the overall impact of this case on the community.
Join them just in case you're needed. All right, would you all please raise your right hand? Do you swear that you will keep all jurors on this trial together in some private and convenient place, and that you will not allow any person to speak to them or you speak to them yourself, except to ask whether they have agreed on their verdict, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God? All right, and then Madam Clerk will just make a record of who you all are. It will take us a moment just to have all the finalized paperwork to go back with the jury. We do have all of the verdict forms, if I want to get that to Jen.
That should have all the new ones in them. It does.
All right, and here are the jury instructions as well. For the record, it's 6:24. All rise for the jury as they're excused to begin their deliberations.
All right. Jury is now going out for deliberations.
Do what she did previously.
But yeah, I'm gonna need all of them and then I'll
Yeah, no,
tape
I
them
know,
down and all
but
that
those are
business.
the-
Yeah.
Okay.
Is that closed?
No.
All right, thank you. You may be seated. Just so the record is clear, the alternates, of course, will not be participating in the deliberations. They will be in a separate jury deliberation room and will only be called upon if needed, of course, after consultation with the parties. As far as how late I will let them deliberate tonight, we have ordered dinner for them. I believe it will be here shortly. And I really will leave it up to them as to how late they want to deliberate before they would want a break and then to retire for the evening. They are under a sequestration order, so they will be kept separate and apart. Their electronics have been confiscated, and they will not be going home until verdicts have been reached or they are discharged from the court, whichever would occur sooner. Anything else the parties would want me to address at this moment from the state?
Thank you, Judge.
Anything from you, sir?
Yep. So essentially, I would have to stay here while they're delivering. I'm gonna be able to go back to my unit, use the phone, shower. It is shower day for my pod. We only get 2 shower days a week.
So here's what could happen though, sir. I don't have a problem with you doing that, but they could have questions. And then you would need to become available so we could address any questions. They may ask for exhibits, things of that nature. So as long as you're willing to come back for those things, I don't have an issue if, I probably should talk to the COs or at least the sheriff and make sure I'm not stepping on their toes since they're in charge of all of that. But it's possible that we get a request for exhibits, some exhibits initially. I wouldn't be surprised if we got that.
Watch them come back with 0 questions.
Let me do this. Let me confer with the sheriff's department. I don't initially see an issue with that, but I want to make sure that they have a protocol in place and that's what they would like to do as well. Okay.
And one more thing.
Go ahead.
I was curious. 61 charges for the reckless. 61 injured parties did not testify. So how does that work? How essentially are charges able to be charged if all of the injured parties did not testify?
From my perspective, sir, the state presented their theory of the case and there was sufficient evidence regarding the charges to go forward to the jury. I can't further explain it from there because that would require me to explain the law. And I guess that's all I can really say about it at this point.
I got a point though.
I'm sorry?
I got a point though.
Oh, geez.
I'm not going to comment on that, sir. Of course, the state bears the burden of proof, and they have to convince a jury beyond a reasonable doubt. For better or for worse, sir, I was not presented with any motions to dismiss, either at the end of the state's case or the close of the evidence, regarding any legal arguments you may have had regarding those issues. And so at this point, the jury has the case and they will determine their verdicts. If there are issues of law that you want to raise after the verdicts are received, then you'll have to make that determination.
Yeah, that has to be raised because essentially you can't, if no injured party testifies, then it shouldn't be a charge.
I disagree with that characterization, sir, but there is frankly no motion in front of me based in law or fact. So for me to comment any further would require me to give an advisory opinion, which I'm not willing to do.
So you're saying I need to make a motion?
So what I will say at this point is I do have one issue that I would like to raise with the parties. I frankly I need a break a little bit. I mean, obviously the court has to stay open. I know my dinner is coming. And I think it's reasonable.
Like, I need a break here
together, but I do need to make a record of some information that I received earlier today, so that the parties are advised of that. But I will do that. Let me confer with the Sheriff's Department about your requests. I'd like to take in about 30 minutes, address the issues that I need to address or the issue. And I want to find out if that would interfere with your request about taking a shower and all of that. So if you can hold tight and stay with us for a little bit.
Can you believe that it's still
great.
going?
And I'll confer with the Sheriff's Department and have a more definitive answer.
It's over.
Today, okay?
It's finally over.
You want the originals back. If Madam Clerk has scanned them all in and they're uploaded, I don't have an issue giving you the originals back. They will have the date stamp. They don't have a time because they were filed in court.
When he put the time on them, I also, so that you knew they were in there, printed them after I scanned them in, so it has a document number.
So you're getting 2 copies. So you'll have that, okay?
See, I didn't interrupt you, see?
Oh,
I'm sorry?
congratulations.
I said, see, I didn't interrupt you.
Thank you, I appreciate that. I would like the parties back in about a half an hour. Thank you, unless they have a question sooner.
Your Honor, do I have to go in that holding cell or do I get to go?
Nathan Gross, thanks so much for your super chat. Says it only just occurred to me they haven't had dinner yet. Those poor people. Yeah. Sandra Ramirez, thanks so much for your super chat. Very generous. Thank you for your legal commentary, Lita. Of course. Thanks for hanging out. So, Kurt, any final thoughts on this case?
Well, I was wrong. I thought there would be no closing from Darrell. But amazingly, we did get a closing from Darrell. And it was actually not the worst closing ever. But my expectations are so low that, I was like, and I was just wondering how Emily D. Baker was responding on her stream because I was imagining she was losing her shit.
Yeah.
So I was just imagining her in my head most of the time.
Yeah.
I was like, how's this going for you? Like, you're dealing with this complete nightmare crap show of the thing that's going on.
Absolute complete nightmare. Blaming God, talking about how, I haven't been able to meet one of my kids, my youngest kid. I haven't been able to meet him because I've been in prison. Well, there's also plenty of kids who will never be able to see their parents again because either they're dead or their parents are dead. It's like the pure gall that he had in his closing was just too much. And especially after especially after that closing by the prosecution, which was pretty effective. You know,
Yeah,
like
yeah, yeah.
I liked the fact that it was not overly emotional, that she just let the horror of what happened speak for itself.
Yeah, I really appreciated her use of the time. I really appreciated that it was relatively short.
Mm-hmm.
I really did like the length of it. I also really liked that I don't know what video she had, obviously because we couldn't see it. But
Yeah.
she felt like she had this really, really good video and she mic dropped by just saying, okay, I'm done talking now and just watch this video. I really like that as a rhetorical move. She started a little rough, but that's okay. As a public speaker, I have a very similar problem where I do public speaking and even competitively, I tend to not, my openings tend to be my weakest. And it's a little bit awkward. But she was so maybe a little bit awkward, a little bit off her foot at the very start, but as she went, she kept going better and better. And her presentation, I thought her use of emotion was nicely peppered in. I also really liked the way that she applied the emotion and then kind of backed off from it a little bit. And she didn't just keep pushing it. She brought it in and then, took a step back kind of in the emotional rhetoric. I really like that sort of pacing that she had. So I gave it basically, and just for the timing issues alone, I bumped it up a half point in terms of my evaluation. Because that's worth a half point just in terms of the time management. So I was like, well, this is a 9 out of 10 for me. It did everything I needed to do. It covered everything. It really, really highlighted the intentionality of it. In particular, it's like, could have stopped at any time, he could have done this, could have done that. And he's just barreling through. And I'm like,
yeah,
yep. And then Darrell Brooks gets up and says, well, I'm not
she actually used was he kept going. He kept going.
Yeah.
He kept going. That was just effective repetition. Very simple and effective.
Right. And then Darrell Brooks got up and says, well, I'm not contesting any of the facts. I'm like, well, as a juror, that makes my life real easy.
Yeah. And then at one point when he was like, oh, you have a tough job, no one would want to be in your role. I was like sitting here with the chat that I was like, I think there are a lot of people that would love to be in the role of the jury right now, just so that they can have swift justice that they can bring upon this person.
Yeah, I'm just, and it looks like the jury's going to be deliberating a little bit, so we might get a verdict tonight, which I find hilarious.
Yeah,
so we might be done.
I don't know if I'm going to last that long because it's already early morning.
Dude, I've been up all day and I've been doing shots and it's been going roughly. So
yeah. Nate came in. He popped in for a second and said, oh, I was in Joe's chat or someone's, I can't remember, that he mentioned, and he was like, yeah, and they made me take a shot for every $100 super chat or whatever. So then of course folks in my chat were like, oh, we'll take that as an opportunity, here's $100, take a shot, Nate.
No, well, Nate came into my chat and he said, well, if there's $200 super chats in the next 15 minutes, I'll take 2 shots. I think it took about 3. So nice. He's like, it's like cursing. I'm like, you said it, but he did his shots. So
yeah. He's
and then he came back after the break and said, "Oh, I'll do another shot." And so we've been enjoying the alcoholic inebriation, which has made things at least marginally more entertaining. Plus, the soundboard makes things great.
Oh, it does. It does. Mine's still in the mail. It's still going to be arriving. Hopefully soon. I would like to start using one because I know that they're so much fun.
Yeah.
So Andy the Game Maker says, so how about some tea? Well, we've had the legal tea all day today. That's what this has been. Tuesdays are legal tea on Legal Bites, and we definitely got a lot of it today. And he says, Kurt, what are you doing on Friday, November 4th?
I thought we had already penciled that in. Wasn't that the date we'd already penciled in?
I think he's prompting you to talk about it.
Oh, okay. Sorry. I was confused there for a second. Yeah, so I apologize. Yeah, so Andy the Game Maker, as you know, has this wonderful game, Crypto Cartel. And he has converted it so that it's available for online play through the Tabletop Simulator app on Steam. And so Friday, November 4th, we're going to have Andy the Game Maker and other people that are all new to my channel, which is exciting. So I get to make new and exciting friends. Very fun for me. Including, he said, a stand-up comic, which, then I get to trade humorous barbs which is also entertaining. And we will get to experience his game and show all the uncivilians that are on my channel all about it. And he has promised me the use of a gift code. And I'm going to sell more of them than you, so that your brother winds up giving more money to me than you and stealing his love from you. These are my goals.
You want my brother to love you more than he loves me.
Yes.
There you go. All right. Well, it's a challenge, I guess. Oh man. Yeah. So that's that'll be fun. That'll be a lot of fun. So we're doing the
Yeah.
same thing on my channel here on Sunday. So that'll be fun. Natalie Wisco said that she's going to be able to come onto my channel for that. So and I'm figuring out who else can come on, but it should be a lot of fun. It's a fun game. I've played it many times. So
Excellent.
yeah. So Ms. Amanda says, do you know exactly how many pages the forms are that the jury has to fill out? I don't know exactly. But it's a lot, right? Because like these jury the jury forms are, the font is spaced out and whatnot. So I would venture they're probably around 100 pages, maybe. Possibly.
Well, the jury forms themselves are probably a little bit longer than that because they've got two forms, one for guilty and one for not guilty. So you're probably talking double that.
Yeah, you're right. Close to 200.
Yeah. Good times.
Yeah. Wait. Yeah.
But that's
So
okay.
it's-
There's 12 jurors. So we can split that up. That's like, 8.
If everyone
each.
just agrees he's guilty across the board.
It's 8 each. How fast can we fill out 8? Pretty fast. Just forge my name at the bottom. It's fine. I don't care.
Yeah. So, yeah.
He is so incredibly guilty, Alita.
He absolutely is. There's without a doubt. I mean, there's zero. I mean, you know me. I like to be like, I like to hold off before really like coming in strong with an opinion.
Yeah.
Because I never want to reach a conclusion for the wrong reasons, but this is one that was pretty damn clear pretty early on that this was an easy case for the prosecution. The only thing that made it difficult for them is maintaining that conviction on appeal because of all of the crazy things that he threw in everyone's way throughout this trial.
Is that judicial determination?
On what grounds?
Grounds.
Oh,
Can I get a written decision in law and fact, based in law and fact?
Let's get a timestamp.
Can I have an interlocutory appeal and a stay?
And by the way, what under what lawful law as opposed to unlawful law?
I still don't know what lawful law means, even from his framework. I don't know what that means. Do you know what that means in sovereign citizen land? What does lawful law mean?
I feel like he's trying to say like what proper law, like what law that is properly accepted, because like just because law exists doesn't necessarily mean that it's good law, I suppose.
Yeah, well, the judge has explained it many different times with many different citations. I'm like, yep.
That's fun. All righty. Well, I think
come on. It's only what, 2 a.m. there?
It's a little beyond that. I gotta get to bed. But this has been wonderful. Thanks so much for joining me, Kurt. At the end
I'm
of
going to keep streaming if you want to send your chat over my way.
Sure. Everybody go hang out with Uncivil Law over on his chat. And continue the party there. You just might get a verdict today. So
exciting, right?
I know. I will be kind of mad if I miss that, but I do need some sleep before the sun comes up.
Yeah, well, I'm pretty sure it'll be guilty times however many 76 it was that we got to. So
yeah, fair. And also before we go, American Legend, thanks so much for becoming a YouTube member, supporting the channel, and welcome to Bike Club. We're as I've mentioned before in this stream, we are going to have a Bike Club member exclusive live stream again this Friday, just like we do on Fridays. So I hope you can join us there. And then otherwise, Thanks to everybody that joined me today. Kurt obviously is here. We had Eric Hunley, Natalie Wisco, Nate the lawyer. So thanks to everybody for joining me today and giving some good discussion here and there in between all of this craziness. Thanks, of course, to everybody in the chat for engaging and having wonderful, wonderful discussion and sort of living through the frustration and all of these emotions that we went through together in the chat, and for maintaining a good, warm, welcoming space for people to come and experience this all together. And of course, thank you to the mods who were as always ushering in that great conversation and making sure that everything runs smoothly. And I guess one last super chat. Kate Leslie, thank you so much for the super chat. Thank you, Alita and mods. Thank you. And
all right, I'll let you go for now, and I'll see anyone who wants to join me over on my chat hopefully in a minute. Thanks, Alita, for having me over.
All right, of course. See you, Kurt.
Bye-bye.
All right, guys. So that is it. Even Holmes is snoozing. He's snoozing away. Like a typical snoozy cat. Okay. All right, guys. That does it for me. This has been wonderful. Thank you so much. And I will see you in the next video, which will be tomorrow. Maybe I'll modify a little bit if there's, not a jury verdict before that point, but otherwise my plan is to get into a deep dive on a chess scandal and a lawsuit, defamation lawsuit that has followed with that. So there's a massive scandal in the chess world, and we're gonna deep dive into that tomorrow. One last super chat before we go. Stuck on Strings, thanks so much. Yes, thank you, Alita and mods. Merci, of course, and thank you, of course, and again, thank you to the mods. Wonderful, wonderful, wonderful. Okay, all right. I said I'd be out. Now I'm out officially. Bye, guys. See you in the next video.